Welcome to True Crime and Celebrity News. If live breaking news and court trials and following true crime your thing, please consider subscribing to my channel, and if you see what you like in my content, please consider giving the content a thumbs up.
Good morning, true crime friends. How are we this morning? I hope everyone is having a good morning. So far, it's okay. I'm here, and I have to be blessed and thankful that I'm here. So today I think I can only go till 3, whenever the bus decides to come get me. It's therapy day. I have to go to therapy today. They're not going to listen to I don't feel good today. So while I'm listening to this, I'm going to make a phone call to the RTA and find out what time they're going to be here, because they came an hour and 20 minutes early last time. So we aren't doing that. I'm not going to therapy an hour and a half early when the drive is literally 5 minutes away, but too far to walk. Thanks for being here. Don't forget to like, subscribe, and comment. So we're doing the Matthew Pahl trial. We're almost through day 5. We're going to keep it on the speedy. So we're almost through it. We're going to keep it on the fast pace, because that one lawyer, he just talks so slow. And then we'll get into day 6. They did day 6 yesterday. So we're not too far behind. But I just want everyone to no, I don't want everyone to what? I lost my train of thought. Sit back and enjoy the trial. Just listen. Let's find out if Matthew Pahl could have really have done this. I don't know how. I don't know how this man, unless he walked her back there himself, but people would have seen. People are nosy. Someone would have came and been like, yeah, I seen them walk back there, But there's no way he drug her back there. No way he drug her back there. Not with a broken foot. No. I watched his interrogation this morning, and it just seems like to me, he's just confused. He's just confused as everyone else about what happened to Stephanie. He knows that she's done this several of times in the past, and she also had an attempt in April. So why they automatically think somebody harmed her is beyond me. I don't get it. Good morning, Kathy. Good morning, good morning, good morning. How are you this morning? Well, I hope good. Okay. I don't understand it either. But apparently they took a whole year to investigate this evidence, and they claimed they didn't even know about Matthew Pahl until after she was found. So when you went and talked to the mom, I guess, yeah, maybe. I don't know. Let's get this day going, because, like I said, I have to be done at a certain time today. Okay, here we go.
We have a different witness to present, Your Honor. That had been discussed earlier.
Right. That's fine.
Let me assemble this first.
Do you want to go?
Okay, this is going to seem really fast, but your ears, your brain will get used to it. Trust me. I don't know what I just did. I don't know what I did. Oh.
And is that person on their way in?
Yes, Detective Billing is in the courtroom.
All right, sir, why don't you come up to the witness stand to my right, remain standing and raise your right hand once you get up there, please.
Please swear the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth.
Yes, I do. All right, have a seat, sir. Yeah, tell us your full name.
Jeremy Stilling,
All right, spell your first name for us.
Jeremy.
All right, go ahead.
How are you employed, sir?
With the Washington County Sheriff's Department.
And how long have you worked for the sheriff?
Since January of 2015, 10 and a half years.
Okay. And what's your current role?
I work as a detective in the Detective Bureau.
Directing your attention to the date of September 18, 2023. Were you working in the Detective Bureau at that time, sir?
Yes, I was.
And were you asked to assist in executing a search warrant at the apartment of Matthew Pahl located at 1001 Delafield Street in the city of Waukesha?
Yes, I was.
And you were one of several officers present for that search warrant, correct?
Yes.
Were you tasked with searching a particular area of the apartment?
Yes.
What area was that, sir?
There was a bookshelf, it's a smaller apartment, bookshelf against the wall, and then there was a closet just next to the bookshelf, which ran adjacent with the kitchen countertop, I believe it was.
Okay. I'm going to put up a photograph by way of previous agreement. So I'll just ask the published, please, number 172. Do you recognize Exhibit 172, sir?
Yes, I do.
Okay. And is this the area you were just describing for us?
Yes, it is.
Where's the bookshelf?
On the right side.
Okay.
The black shelving.
And the closet?
To the left of that with the brown sliding doors and a gold handle.
Okay. And the door's actually open in this photograph?
Yes.
Okay. In searching that closet, did you locate any items of interest relative to this investigation?
Yes, there was a piece of paper that was located on the top shelf. It was in some form of a box. I believe in my report I described it as an envelope box. And on said piece of paper, it had something to the extent of non-extraditable countries or countries with no extradition.
Okay. If we could please display 173. What is 173, please?
It is the note that I was speaking of.
Okay. It's a little hard to read. I'm going to ask Ms. Gussie to zoom in a little bit. Okay. And we're looking at this white piece of paper, sir?
Yes.
And at the top on the right-hand side of the paper, what do you see there?
I see number 1 circled with no extradition written right next to it.
Okay. And then below that?
Below that, I see a 2 with an X, 100K at, and then additional countries, multiples circled.
Does that actually say look at instead of 100K?
Yes, it does. Sorry.
Okay.
Apologize.
So that means look at. And then there's a list of words there, correct?
Yes.
You recognize those words?
Yes, I do.
What do you recognize them to be?
Countries with no extradition.
Countries all around the world?
Correct.
Okay. And if the key of this note is to be believed, the ones that are circled don't extradite, and the ones with an X need to be looked at.
Correct.
Okay. You found this in the belongings of Matthew Pahl on September 18, 2023?
Yes, in that closet.
Okay. Thank you. I don't have any other questions.
Cross-examination?
Wait, I got the witness, Judge.
Go ahead.
Detective, you were searching the whole residence, is that true?
My primary focus was that area that was depicted in the picture, sir.
That closet only?
Closet and the bookshelf.
And that note was with other items?
It was with additional pieces of paper, yes.
And what were on those other pieces of paper?
I could not recall.
Do you know who wrote that note?
I do not.
Do you know when the note was written?
I do not.
The note seems like it's... Do you have the note here with you?
I do not have a note, sir.
Do you know how long the note had been in that box?
I do not.
If that note was written 10 years ago, you would not disagree with me, would you?
I wouldn't know if it was written 10 years ago or the day of.
I have no further questions, Judge.
Read right?
No, sir.
All right, thank you very much, sir. You're excused. Next witness.
Thank you. The state will call Jesse Chilson.
Come on up, please, to the witness stand to my right. And once you get up here, remain standing and raise your right hand. Fix up quick over here.
Please swear the testimony you're about to give in this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
All right, have a seat, please. And could you please spell us your name?
Jessica Chilson.
Spell the last name.
Chilson.
Thank you. Go ahead.
Good afternoon, ma'am. Hi. How are you employed? I'm the manager at Willow Park Apartments. And how long have you worked down there? About 5 years. Okay. Do you know Matthew Pahl? Yes, he was a resident at our residency. Do you remember when he came to live at the Willow Park Apartments? I'm not 100%, but I do believe it's like 2022. Okay. If I show you a copy of his lease, would that help you know for sure? Yes. Okay. So I'm going to ask to display for the witness only Exhibit 167. It'll come up on the screen to your right there, ma'am. It was November 1st of 2021. Okay. And the exhibit that's on your screen there, 167, is that a copy of his lease? Yes, that's the original lease. Okay. And do you believe this is a true copy of the lease? In other words, nobody's altered it or changed it before court? No, nobody's altered it. Okay. Oops. So November 1 of 2021, Mr. Pahl signed a lease with the Willow Park Apartments, correct? Correct. Was he allowed to have any roommates? He can have guests, but nobody living with him. Was that a rule of his rental agreement? Yes. Was it, if you had learned that he had somebody living with him, would that have been a violation of the rules? Yes. What would have been the consequence?
He would get a verbal warning, and then we would end up giving him 5-day notices, and we give him up to 3 5-day notices that he cannot do that,
Okay.
and then we end up evicting.
for not obeying the rules. Okay, this is a secure building, right? Correct. And about how many units are in the building? About 120. Okay, and there's many doors that lead into and out of the building? Yeah, but they're all locked. You have to have a key access to get into them. Okay, and would it be possible for Mr. Pahl to sort of prop a door open and let somebody in? Yes. Okay. Are there cameras at the Willow Park Apartments? They weren't at the time. 2022. No, they were not cameras at the time. Okay. You remember giving police officers access to your video recording system in August of 2022? Oh, I'm sorry. Yes, we did have cameras. We just got a new camera system. I see. Okay, so sorry. That's okay. So since all this happened, you've replaced it? Yes. Okay, yes. But back then, in 2022, you did have several visits from the sheriff's office, right? Yes. The SWAT team was there. Sure. But they also came and asked for your video, right? Correct. Yeah, they took it a couple of times. And you helped them retrieve it from your system? Yes. Okay. And the video cameras show all the doors and people that are coming and going? Yes. Okay. If Mr. Pahl rented the apartment solo as a single occupant of the apartment, would he have gotten one key to the apartment? Yes. Okay. For the witness only, I move to admit 167, Your Honor, but I'm not asking to display it.
Any objection?
No, sir.
Okay, 167 is admitted.
And then for the witness only at this point, 168, please. Do you see what's shown on your screen there, ma'am? Yes. Have you ever seen this document before? Yes. What is this? That is something that Mr. Pahl gave me to make sure that if anything ever happens to him or he needs to let somebody access, we can let them in his unit without him saying, or without him saying that it's okay to enter. So if suddenly he's not there sometime, he's giving permission to somebody else to get into his apartment? Yes. Okay. Do you believe this is a true representation of that letter you got from Mr. Pahl? Yes. Move to admit 168, permission to publish, Your Honor.
Any objection?
No, sir.
168 is admitted. You may publish.
All right, it's a little hard to read. Are you able to read that, Ms. Chilson? Would you rather I read it? I, Matthew Pahl, give Kathy Pahl and Marcus Pahl and their choosing of moving company premises to move all my belongings, property off my property room. 317, Apartment 317 at any time upon my request. Okay, and then it's signed, thank you. Thank you, 9/20/2022. And I signed it, and so did Mr. Pahl. Okay. You remember him bringing that letter to you? Yes. Did you ask him for that letter? No. He just presented it to you, and you put it in his file? Yes. Okay. Okay, thank you, ma'am.
Cross-examination.
Good afternoon, ma'am.
Hi.
So Mr. Pahl was on the lease, true?
Yes.
Ooh, y'all, that don't look so good. Why is he giving her a letter in case someone needs to move the stuff out of his apartment? Was that after? Stephanie, I keep forgetting what year she died. I think 2022, right? So that don't seem right. But then maybe he thought they were hounding in on him and they were going to bring him in. Maybe he did that after the interrogation he had with them.
And he was allowed to have a guest at his apartment, true?
Yes.
How long is the guest allowed to stay?
About 2 days. And if the guest is somebody that's from out of town, then they would say about a week to 2 weeks, and if it has to be longer, they have to contact the office.
So out of town would be out of the city of Waukesha?
No, out of town, like up north or a different state or something that they're visiting for a long periods of time as far as on a vacation.
How does the tenant know that that's what out of town means?
We explained it to him at the time of the leasing.
So the guest is allowed to come over and stay. Are they allowed to bring clothes as far as a change of clothing?
Yes.
Now, as far as you know, were there any complaints from any other tenants that lived in the building against Mr. Pahl?
No.
No one complained about loud noises?
No.
No one complained about yelling occurring inside the apartment?
No.
In regards to that exhibit you were shown, that letter that Mr. Pahl gave you dated September 20th, 2022, you received that again from Mr. Pahl, true?
Yes.
And had he traveled to the Philippines and got forsaken, died in the Philippines, would his parents have been allowed to?
Yes.
I have no further questions.
A redirect.
Nothing further, thank you.
All right, thank you very much, ma'am. You're excused. Next.
Street calls Kyle Hobeck.
Wow, we're whipping through these. Yeah, I was thinking, I forgot he went to the Philippines. Remember, I just learned that like a day and a half ago. I didn't even know he went. We're whipping through these. Okay, so I'm assuming this will end out him, and then David will end out day 5, right, Kathy? David is the last witness on day 5 because Kyle is the Facebook marketplace purchaser. He purchased a pressure washer from Stephanie. I thought, oh, okay. All right, well, let's listen.
Sir, if you come up to the witness stand to my right, I want you to get up here and remain standing. And if you can face our clerk over here.
Please swear the testimony you're about to give this matter before the court shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, have a seat, sir. Can you tell us your name, please?
Kyle Hobeck.
Spell both the first and last.
Kyle, K-Y-L-E, Hobeck, H-O-B-E-C-K.
Okay, thank you very much. Go ahead.
Hi, Mr. Hobeck.
Hello.
All right, I'm just going to ask that you talk slowly, okay, so the court reporter can take everything that you say down. At some point in the summer of 2022, do you recall coming across a Facebook marketplace sale for a power washer?
Yes.
Okay. Do you buy a lot of things on Facebook Marketplace?
Yes, I do.
Okay. Just have to wait until I finish
Okay,
the
fine.
question, okay? It sounds like you're a little nervous. So why were you trying to buy a power washer?
To fix, to resell.
All right, is that kind of a business you have?
Yes.
So who did you contact on Facebook about buying a power washer?
Profile by the name of Stephanie.
All right, and did you know this person?
No.
Ever meet her in person before?
No.
So you just see the post and you send her a message?
Correct.
That's pretty much how our Facebook Marketplace works, right?
Yes.
You see something you're interested in, you might send a message to the seller, see if it's still available.
Yes.
Okay. So that happens on July 19th of 2022, that sounds about right?
Okay. Yes.
And then throughout July, do you and Stephanie kind of go back and forth about whether you're going to meet up for the power washer and begin to have kind of a conversation?
Correct, yes.
Now, at some point, I want to say on August 9th of 2022, you still haven't met up with Stephanie, right?
Correct.
You had engaged in some conversation over Facebook Messenger, I should say?
Yes.
And on August 9th, do you recall exchanging phone numbers with Stephanie so that you could actually text instead of just communicating through Facebook Messenger?
Yes.
And after August 9th, do you remember continuing to try and contact Stephanie to get in touch with her?
Yes.
Okay. Do you recall sending Stephanie a Facebook message on August 26th of 2022?
Yes.
Okay, and August 27th of 2022?
Yes.
August 31st of 2022?
Yes.
And then a final message on August 31st?
Yes.
When you hadn't heard anything from Stephanie, did you get any responses to any of those messages?
When the response stopped, I received a text a few weeks later from another number.
Okay, so do you recall on September 14th then sending Stephanie a text message to her cell phone rather than communicating through Facebook Messenger?
Yes.
I'm going to show you what's been marked as Exhibit 174. So I'm going to throw it just to you first. It's going to come up on your screen right there in front of you. It's going to take a second. All right, do you see what we have in front of you there?
Yes.
Okay, and there's a number with the last digits of 8558. Do you recognize that number?
Yes.
Okay, is that your number?
Yes.
And what's the message that you sent to Stephanie?
You still got the pressure washer for sale.
Okay, and that's the message you sent to Stephanie on September 14th at 1:23 a.m.?
Yes.
Okay. Did you get a response to that text message?
I do not believe so.
Okay, and then you said a couple of days later you got a message from a different number?
Correct.
I'm going to move Exhibit 174 into evidence and permission to publish.
Any objection?
No, sir.
All right, you may do so.
All right, so this is that message that we just talked about that you sent to Stephanie?
Yes.
Okay. Now, if I can show for just the witness, please, Exhibit 175. Were you familiar with the number that sent you a message talking about the power washer?
I was not.
Okay. I'm going to show you at the top of your screen, please. This is Exhibit 175. Do you recognize the phone number that's at the top?
I do not.
Can you please read that?
262.
Okay, so I just found out that David Schroeder will go over Soder. I don't know how to pronounce his last name. We'll go over into day 6. So it'll be this guy and then David will finish out the day and come back the next day. Okay.
66636.
And do you recognize these messages?
Yes, I responded to that message, questioning which pressure washer it was.
Okay.
Don't forget to like, share, and subscribe and comment. Thank you.
I would move Exhibit 175 into evidence and permission to publish.
Any objection?
No, sir.
175 admitted.
Mr. Hobeck, do you recall giving law enforcement, they came to talk to you and they actually took a screenshot of your message, right?
Yes.
Okay, so the message on the left, who is that from? The message at the very top.
Unknown.
Okay, so that's coming from that number at the top that you don't know?
Correct.
Can you please read what it says?
I have your info from one of my workers who wasn't doing her job. There's a note you're interested in a pressure washer that is for sale yet.
Okay, and at the bottom underneath that message, does it say the date and time that you received that? Or that it was
September
sent?
17th at 2:41 p.m.
Okay, and did you respond to that message?
Yes.
What did you say?
I buy a pressure washer. What do you got?
Did you know if this was referencing the same power washer or pressure washer that you've been talking to Stephanie about?
I assumed because that was the only one I hadn't picked up.
Okay, so you had been making a lot of Facebook Marketplace purchases and this was kind of an outstanding purchase?
Yep.
All right, and it looks like then you sent 4 more messages following September 17th and did not get a response. Is that
Correct.
true? Okay, and so fair to say that you did not have any contact with Stephanie Pavlons after August 23rd of 2022?
No.
Okay, and you attempted to make contact and never received a response?
Correct.
And ultimately then you received a text message from an unknown number?
Yes.
Did you know how this number was related to Stephanie?
I think earlier in the conversation she was selling stuff for her employer, so I figured this was her employer.
Okay. I don't have any other questions, sir.
All right, any cross?
Just a few questions, sir. So earlier in your conversation with Stephanie, she had told you she worked for somebody, true?
Yeah, she worked for a landscaping company, she said.
And she was trying to sell this
Some equipment.
on behalf of her employer.
Correct.
I have no further questions.
Right, thank you very much. Any correct?
No.
All right, thank you very much, sir. You're excused.
Thank you.
And by the way, I appreciate your dressing up for court.
Thank you.
on an everyday basis, you should see what people wear when they come.
Judge, I just need a minute with the court to talk about the next witness.
Okay, let's take a short break, okay? All right, Jerry. Okay, the jurors have left. Have a seat, everybody.
So if we are not going to be bringing that in-custody witness next, we have our next witness is the lengthy witness, but I just want to let the court know that we're going to be bringing that witness in the jail next.
Okay, so it's just a little bit after 2 o'clock, and this witness, it's
Yes.
Schrader, is it?
Yes.
Okay. You know, I sent the jurors out, and anybody else need a break for a moment or anything? All right, go ahead, because they usually take a number of minutes before they come back in any event. Let's take a break for about the quarter after, okay?
Oh, wow. Break time already, y'all. Y'all, it's break time. We just started. So, I'm still going to go with I don't think he did it. We can blame anybody on anything to make the family happy. They just wanted to bring somebody in that they could get enough evidence from to prosecute them, to prove to the family that they've done something. You know, Wisconsin is good for that. But that's my own opinion. My own opinion that I don't believe he did this. I know usually you're not supposed to do that, but I'm sorry, but I just don't think he did. There's not enough evidence. So, let's go. So he's going to finish out the day, okay?
I was put into my position that I'm currently in.
Oh,
You said you are assigned to the computer forensic lab. What does that mean?
For computer forensics lab, the primary, I guess what we do is to identify, acquire, process, analyze, and report on electronically stored data. The long way of saying that we look at cell phones, computers, USBs, analyze that data, preserve that data for courtroom purposes. We also deal with historical cell site location analysis, which would be, whether you know it or not, your cellular provider, so AT&T, T-Mobile, Verizon, are keeping records that contain tower location information for every call, every text that you make. We as law enforcement utilize that information to get general locations of cellular devices.
To be in the computer forensic lab and to conduct a lot of these examinations of devices, do you need particular training and certifications?
Yes, ma'am.
Okay, tell me about that.
So the majority of my training is at the United States Secret Service National Computer Forensics Institute, that is in Alabama. Down there I have over 500 hours of training. That ranges from Windows forensics to Mac forensics to Android and Apple, device repair, network intrusion, pretty much anything tech-based. I have a certification from the International Association of Computer Investigative Specialists, which certifies me as a computer forensic examiner. As part of that, I'm a peer review coach for them, which means other candidates that want to apply that certification. It's a 4-month process. They have to do different problem sets, and I'm assigned to review their work and coach them through the process. I also hold individual certifications in the various tools that we use. Some of which you'll hear here are going to be Celebrite, maybe Axiom, Great Key. So I hold certifications in all the tools that we use as well. On top of that, I have I guess enough experience. Since 2022, I have forensically examined over 500 individual devices. And I'm an instructor for Celebrite. So when I'm not working here, I'm a contract instructor for them and teach digital forensics. I teach their core classes, which would be regarding extractions of data, analysis of that data, and best practices in digital forensics. In terms of the historical cell site analysis, I've attended training through ABM Intel. They are a third-party training vendor for CellHawk. CellHawk is something that you'll hear quite a bit in my testimony. They hire third parties to teach their software and how to conduct record analysis of call detail records. In terms of experience with those, I think I've analyzed records in over 90 cases, and the total amount of records is in just north of 4 million records. All right, excuse me for a second. You said you're going to use the term CellHawk. That's brand name. That's correct, yes. Spell that out for us, please. It sounds just the way it sounds. Yep, CELLHAWK. All right, thank you.
You said you've analyzed over 4 million records?
If you're going to count every individual record that is in the returns that we get, yes, it's over 4 million records.
And are you the individual at the Waukesha County Sheriff's Department that is responsible for any of that cell phone tower mapping that you've briefly described to the jury?
Yes, I do have another partner that does it with me, but I am our primary person that does this analysis.
Right. So you've told us that you work in the computer forensic lab. Is it just you, or do you have any partners in the lab?
I have one partner in the lab with me.
And are you and your partner responsible for what we've heard to be downloading and extracting the data from digital devices?
Yes, ma'am.
Do you do that for both your department and assist other agencies?
Correct.
Okay. Now, in this case, were you asked to assist in a death investigation related to a suspect and ultimately a defendant of Mr. Matthew Pahl, related to a body that was found in the woods near OAW on September 9th of 2022?
Yes, ma'am.
So initially, what was your role in the investigation?
The very first thing I did was analyze extract cell phone data from what was identified as the decedent's old cell phone.
Okay, so that would be the victim, Stephanie Pavlons?
Correct.
When you extract the data, can you just give us a pretty brief understanding of what exactly is happening and how you know that you're getting all the right data?
Yeah, so the tools we use, due to modern technology and encryption, reading the physical memory chip at like a binary level is not possible. So what our tools do on modern cell phones is conduct what we call full file system extraction. That extraction of data extracts all live files available on the phone and puts them into a zip container. So a lot of it is tables containing information, log files, your pictures, your text, your calls, and a bunch of stuff that you guys would not be able to see on your cell phone, such as system files and log files that you are not able to see by just clicking through your phone. It comes out into a zip container, and then either you have the training to look at that manually, or we put it into another tool to analyze that data.
Okay. Later in the investigation, after a search warrant was executed at Mr. Pahl's residence, were you provided with more devices to assist the investigation by downloading and extracting?
Yes, ma'am.
What were those devices?
I was provided what was identified to me as the victim's new cell phone, and then also Mr. Pahl's cell phone.
Okay. Later on in your investigation, were you provided some extraction information from Detective Fine from the city of Waukesha?
Yeah, a lot later on.
Right, about a year after the initial investigation starts?
Correct.
Okay. And did you save all of those files into the Sheriff's Department system so that Detective Plennis, Detective Fredericks, and even yourself could review some of those items?
Yes, ma'am.
All right. And so overall, there were a number of electronic items in this case that were collected, and you were responsible for either making sure someone else was able to extract those or completing those extractions at the Sheriff's Department?
Yes, ma'am.
Okay. Once you completed those extractions, fair to say that you have a little bit and probably a lot more experience than some of the other detectives in the Detective Bureau with going through the phones, understanding the data that you're looking at, and maybe even finding.
So just for some commentary, I entered some things in the chat. So this gentleman is going to talk about analyzing stuff. He reviewed cell phone records for Pavlons and Pahl's phone. On September 9th, before anyone knew that Pavlon was missing. Oh, Leah. I don't know why she won't let me keep the computer on top of her. On September 9th, before anyone knew that Pavlon was missing, Pahl conducted web searches relevant to the case. But he knew she was missing. He knew that something wasn't right. On September 10th, Pahl's phone searched for Ed body found by construction crew. On September 11th, Facebook messages were sent from Pavlon's account. Pahl claimed he was driving up and down the street searching for the victim, but evidence showed that he stayed in the same area. Between March and June 2022, 380 messages were deleted from Pavlon's device. Between August and September 2022, 93 entries were deleted from Pavlon's device. Pahl conducted obituary searches beginning on August 26th and used a police scanner device regularly after the victim's disappearance. I have a scanner on all the time. I mean, that doesn't mean I went out and murdered somebody. What is having a police scanner? It's free. It's legal. You can download it on your phone. That does not prove that you hurt anybody. Under cross-examination, Schroeder conceded that he didn't know when the items were deleted from the devices or who deleted them. Pahl's device showed zero usage on the day Pavlons went missing. And I'll add some more here in a little bit. Don't forget to like, share, and subscribe. Thanks for being here.
Other things that detectives in the Bureau wouldn't really understand or know what they're looking at.
Sure, that would be fair to say.
Okay. And as a Celebrate instructor, you're very familiar with the tool Celebrate that's used to actually review some of these devices?
Yes, ma'am.
Okay. Now, as part of the investigation, you did some of these extractions, you assisted in some of the investigation, and very early on, you were provided with phone records.
Correct.
Why were you provided with phone records related to Stephanie Pavlons and ultimately then Mr. Matthew Pahl?
So our detectives that are assigned to do investigations, myself, I don't typically get assigned as like a lead detective or anything on an investigation. I serve in a support role. So the detectives assigned would typically obtain those records from the cellular provider via a warrant. Once they obtain those records from the provider, they bring them to me to either create graphical representations of that location data or analyze those records.
Okay. And in this case, they brought you those records and asked you to analyze them.
Yes, ma'am.
Also, as part of this investigation, were you asked to assist both Detective Fredericks, Detective Plennis, and ultimately the prosecution team in kind of putting together a timeline of all of the things that you were able to locate within the digital devices, but also other pieces of the investigation and put them in time order?
Yes, ma'am.
Okay. I'm going to show you what's been marked as Exhibit 202, just for the witness first. Okay. This is a 124-slide PowerPoint.
Yes, ma'am.
Okay. Detective, did you create this yourself in conjunction with Detective Fredericks and Detective Plennis, as well as the DA's office?
Yes, ma'am.
Okay. You recognize this exhibit?
Yes, ma'am.
You reviewed and created this exhibit?
Yes, ma'am.
Does it seem to be a fair and accurate description of the PowerPoint that you created?
From here it does. If you want to scroll the slides, I could
Yeah, we can do
confirm
that.
that, yes.
Okay, defense will stipulate. I would move Exhibit 202 into evidence and permission to publish.
Any objection?
No, sir.
It's admitted.
Thank you. Detective Schrader, to clarify before we get started in this, did you know every single detail about the whole investigation in the same way that Detective Fredericks or Detective Plennis, as the lead detectives, understood and knew this investigation?
No, ma'am.
Okay. Were you asked, when asked to put this PowerPoint together, to provide specific pieces of information from different devices in order to help us put these this timeline in order?
Yes, ma'am.
Okay. So there may be some things that you know where it came from, but you don't know a lot of details about that piece of the investigation?
That's correct.
Okay. We're going to start with slide 1, or slide 2. All right. You told us that you got the cell phone records for Mr. Pahl and Ms. Pavlons. Can you please explain to us what exactly we're looking at here and how call detail record analysis works?
Yeah, so before we get into the, the timeline portion of this PowerPoint, it's important that we understand portions of this PowerPoint, which are going to detail maps that show like a graphical representation of location data. It's likely that you guys have never seen it, so the first couple slides here just to explain a little bit about how your cell phones work and communicate with the network, and the information that we receive from the provider that helps us map that information. So cell phones, well, modern cell phones are basically mini computers in your hand at their core level. They're a handheld radio that uses radio frequencies to communicate. When they're on, they're constantly scanning the network for the...
Can you slow down a little bit?
Yes, absolutely, I'm sorry. When your cell phone is on, it is constantly scanning the network, looking for the best tower. Should you choose to pick that phone up and make a call, it already knows which tower to connect to. It's interacting with the network constantly while it's on. That's important. If you turn the phone off, there's no longer that connection to the network. So while it's on, it's constantly going to be recording different records. Every phone call you make, every text message, anything that travels through the network will generate a record. In this case specifically, I use what's called timing advance records. Those are specialized. Those don't require the user to be using their phone, just let the device be on and connected to the network. Those are happening all the time as the device moves around. These records are being generated and stored by your provider.
Can you go to the next slide, please?
Cell sites, I'm sure we've all seen them as you drive around, maybe along the interstate, but they come in all shapes and sizes. They're not always your standard cell tower in the middle of the woods. They could be on a building. They could be on a church steeple, pretty much anywhere. But a typical cell site is going to have what are called sectors, and there's going to be 3 of them. Each of those sectors covers approximately 120 degrees, so putting those 3 sectors together would give you the full 360 degrees of coverage around that tower. They're typically labeled as 1, 2, and 3. Sometimes it's 11, 12, 13. However the provider decides to name them, that's up to them. It's important to note that every cell tower is assigned a unique identifier that identifies that tower on the network. So when we analyze these records, we reference a cell site list, which we're able to get. And when we look at the records, we can pin that call down to a very unique and specific tower where that record was generated from. Outside the scope of what I'm talking about, network providers build these towers and place these towers to best facilitate their network. We don't determine where they go. So typically see more dense cell tower usage in like urban or metro areas, where if you get into the rural areas, towers are much more spread out.
Okay. And next slide, what are we looking at here?
So this is a cell tower that may look familiar to some of you, but at the bottom is an equipment structure that facilitates all the programming behind this tower. That's not anything to do with what I do. But at the top, on this tower, you can see there's a triangle-looking shape. There's a total of 12 antennas on that tower. Those 4 antennas, kind of where that gray arrow is pointing, those 4 antennas would come together to make 1 sector. So on this, we're seeing those 3 sectors, each one having 4 antennas.
Okay, next slide.
In the analysis that we do, you're going to be looking at like a bird's eye view, so you're looking straight down on a map. You're kind of seeing on the compass on the right there, the 3 sectors, 1 being red, 1 blue, and 1 green. When we get the records, it'll give us the tower information, the sector that was used, and then an azimuth or whatever could be found in a cell site list that would tell us which direction that sector is facing. So if we're looking top down on a tower, due north is always 0 degrees, and then moving clockwise around that to get our 360 degrees. So according to this slide, or I guess not according to this slide, but it's on there, but if you think of a clock, every hour is 30 degrees. So if we got records back that said the sector was pointing towards 90 degrees, you could have a tower, it's not always going to be due north, it could have sectors facing any direction that they designed that tower to have.
Okay, and the next slide shows us an example of what a cell site and sector looks like. Tell me about this.
Correct, so this is out of CellHawk. So this is exactly kind of what we're going to see. This one has all 3 sectors shaded. Typically, if it's 1 record that we're looking at, you'll only see one of those sectors showing, so it kind of look like a piece of a pie. You generally won't see all 3 sectors like that unless I'm showing like a still shot, and through that time lapse that I'm showing, every sector was used by the records.
Okay, and the next slide.
We just talked, but this is more so what you'll see if we're looking at 1 record. You'll have that pie shape. It's important to note that that shaded area has nothing to do with the coverage range of that tower or the radio frequency coverage from that tower. That shaded area is put on there just so that we can see or make it easier on our eyes to see which direction it's facing. Again, it has nothing to do with the coverage or area that that tower can cover.
Okay, and this is an example of call detail records, right? This is not an example of what it would look like with timing advance?
Correct. This would be a simple, I'll call it simple, a simple call detail record. So a phone call that was made on the network, it would be this tower, this sector. That's all we would say off that record is that it was using this tower and it was orientated facing southwest, we'll say. Okay,
and so in a case where you're using just call detail records, fair to say that you're going to have much fewer records that are actually available to law enforcement because your phone's only connecting to the network when it makes a call or receives a call or a text?
Correct. If we were only doing analysis on a basic call detail record and did not have the advanced location data, you could have very large gaps in your records because if they're not using their phone, if they're not making a call or not making a text, you just have a gap in the records then.
Okay, but in this case, you actually had timing advanced records.
Correct.
Okay. Can we go to the next slide, please? Tell me about that.
So timing advanced record, as I said, does not require the user to be interacting with their phone. So as long as the phone is on and connected to the network, these records are being generated. Similarly to the previous stuff we talked about, it'll give you a cell tower location, a sector or an azimuth for which direction that antenna is facing, and then it also gives you a distance from the tower. The estimated distance is based on a delay in time. So These signals travel at the speed of, I believe it's light, radio waves. So if we know the speed that radio waves move, and we know how long it takes a signal to go to a device and back to a tower, it assigns a time in advance value to that distance. Based on that delay in time, we can estimate a distance that that device would be from the tower.
Okay, and I see that this arc on the slide goes all the way from the left, where it says University Heights, kind of over the Waukesha DMV, and then down to the Waukesha County Expo Center. What's the significance of that arc and, I guess, that entire distance?
So if we were looking at these arcs, or I was doing analysis on this, let's say we were looking for somebody, and patrol called and said, where should we look? I would look at this record, and I would look for typically high points along the large arc you're seeing there. So the big arc that goes around, this record is indicating that the device is likely in proximity to that arc. Somewhere along that arc is where the device is most likely located. So this specific record, I'd look at some of the places you named, but Country Springs Water Park, the DMV, the Expo Center, those are all places that they would likely be, probably not on the airport grounds, but I would look at high points and send people there to look for somebody.
Okay, so this doesn't tell you, just based on the arc, exactly where the device is, right?
Not at all.
Okay. Next slide, please. You obtained from Detective Plenish records from Mr. Matthew Pahl's cell phone, is that correct?
That's correct.
And these are the records that you see on your screen, and the phone number that you obtained those records from?
Yes, ma'am.
Okay, and why do you need all of these files?
So these are from T-Mobile. I don't determine what they send back. We make a request for the records that we want, and they respond with however they provide those. In this case, they provided a health document, a certification of these records, and then you'll see the files named CDR meditations, or mediations. That's the, I'll call that the basic level, call detail record. That's for your calls and your texts. The data sessions file is for data usage, and then they broke down all the different time in advance files by date range.
Okay, and the next slide? These were the similar records that you obtained from Stephanie Pavlons' phone number ending in 7991?
That's correct.
Okay, and you used these same records, similar types of files, but for a different phone number to track Ms. Pavlons' device?
Correct.
Okay. Once you have these records and you have all of the, it looks like they come in Excel files?
For T-Mobile, yes, Excel files.
Okay.
It varies, but yes, these ones are in Excel files.
Okay, once you receive the Excel file, what do you do with it?
Typically, we'll put them into CellHawk. I know I mentioned about training, but it's as simple as dragging and dropping these Excel files into software. What that software is designed to do is map these records. So it's important that we map them, but in these, there's probably, I didn't do a total, but there's thousands of records in here. So if I wanted to by hand, I could go through and map thousands of records by hand, but the software will do that very quickly for us. Where it would take me days, weeks, months to map all this, it'll do it in probably less than 5 minutes, and then we'll go in and verify any key points of interest. Okay.
Once you have the records in CellHawk, are you then able to narrow it down by a specific day or a specific time frame that you want to look more closely at?
Yes, you can apply filters to the data sets. So depending on what the request is or what I'm trying to analyze, I would apply filters to see that information.
And in this case, were you asked to first in your investigation look at the date of August 23rd for these records?
In summary, yes, but I first looked at Ms. Pavlons' records. Those are the first ones I had, and gave a general overview of the device's movements for that device.
Okay, and that assisted later in the investigation with determining kind of the last known place she was, video was obtained from those areas?
Yes, ma'am.
Okay. Are you also able to make animations from this CellHawk software?
Yes, ma'am.
Why is that helpful in an investigation?
So again, these records might not always get you down to an exact pinpoint area where the device is, but if you analyze them enough, you're able to see general routes of travel and establish time frames for when a device maybe leaves or comes to an area. So I guess that's why we use the animations, is to show you guys and show other people that maybe don't have the training experience that general movement of a device.
You said that the difference between a call detail record and a timing advance is really comes down to the number of records that are retained. Is that right? There's a lot more records retained in timing advance that are going to show you location information?
Correct. The timing advance, again, doesn't require the user to be using the phone. This is generating a lot more records than you'll call or text on your device. So there's going to be a lot more time in advance location information than there would be in a basic CDR. We also don't get that distance measurement in a basic CDR, so all I can really say is it's in this area away from the tower. I don't know precisely how far from the tower it may be. Okay.
Now the next slide is going to go into our timeline. We start on August 19th. Throughout your assistance in this investigation, were you asked to review Skype messages that were obtained from Mr. Pahl's phone? And when I say review, I'm asking, were you asked to kind of find those within the devices and put those together?
Yes.
Okay. So we're going to start on August 19th. If you can please read what we have here in the messages.
So beginning on August 19th, each of the following timestamps I'm going to give will be on August 19th. But these are a conversation through Skype between Mr. Pahl and Cheryl Lynn, or his beautiful disaster in Skype. At 6:32 a.m., Pahl says in part, "Find out about your annulment. I just want you to understand that so it's not a surprise because it's becoming surreal for me that soon I will be there." At 6:43 a.m., Pahl says, "Also, you really had no reason to apologize to Stephanie. I'm asking you to just leave her alone for now. I don't think she'll be a good friend anyways." At 7:12 a.m., Pahl says, "Don't make me ask you again because I will set it up where you won't be able to talk to her." 7:38 a.m., Pahl says in part, "I'm hoping my future will be in the Philippines with a good, honest girlfriend."
Okay, and the next slide. This is on August 20th. Were you also aware that there were Skype messages between the victim, Stephanie Pavlons, and the defendant, Mr. Matthew Pahl?
Yes, ma'am, there were quite a few.
And Skype is a little different in how they display, I guess, the messages from who they're from and who they're to, right?
Yes, it depends on which tool you're using to analyze it, or if you're looking for records obtained from Skype themselves, yes.
Okay, and here we have in the message from and message to columns different live usernames from Skype, right?
Yes, those are Skype user IDs.
And were you able to determine which messages come from Mr. Pahl and which messages come from Ms. Pavlons?
Yes, the live ID ending in BAB4 is for Matthew Pahl's account. The live Skype ID ending in 7432 is for Stephanie Pavlons' Skype account.
Okay. And these messages occurred on August 20th of 2022?
Yes, ma'am.
Really, the significance of these messages is there's discussion about going swimming at the Y, right?
Yes, ma'am.
Okay. August 21st, please. Based on your review of Mr. Pahl's initial cell phone, were you able to determine when he connected to the Wi-Fi in the Waukesha YMCA?
There was a log file that indicated he connected to the YMCA Wi-Fi at 1:40 p.m. about 1:40 p.m. on August 21st, 2022.
Why is that something that you, as you might, as an investigator, want to know whether logging into Wi-Fi or connecting to Wi-Fi?
If we're talking about locations, it's helpful in identifying where they may be.
Okay, I'm going to play for you first this video on the left, which occurs at 4:17 to 4:19 p.m. And Detective, you recognize this as Willow Park surveillance video?
Yes, ma'am.
Okay, thank you. Okay, and the next video, please. Can you pause it, please? Oh, that's fine. Detective Schrader, you saw Ms. Pavlons come up to the door and try and open it?
Yes, ma'am.
Okay. And she then sent a text message to Mr. Pahl from her phone to his phone saying here?
Correct.
Okay. And we're not going to watch the rest of the video, but you review the video and Mr. Pahl returns and actually lets her in as he walks out.
Yeah, he walks out, doesn't appear to acknowledge her, and she slips in the door behind him, yes.
Okay, and that timestamp was consistent with the timestamp of the text message that you reviewed from the devices?
Yes, ma'am.
Okay. Going to the next slide, please. You were also asked to assist in reviewing and compiling some of the email records that were obtained by Detective Plannis, right?
Yes, ma'am.
And this is an email between Ms. Sherilyn Valente from a Gmail address to Mr. Matthew Pahl at a Phoenix 48 address?
Yes, those emails were identified to me, but that's why I was told yes.
Okay, so you're asked, these are kind of the important things. Can you please look at these, find these, and assist us in putting them in time order?
Correct.
Okay. What does this email say and the date and time, please?
It's August 22nd, 2022. It's an email from Sherilyn Valente to Matthew Pahl's email account. The subject is praying hands or clapping hands in a black heart. And the body of the message reads, "Life isn't the same without you. Please come back," with a couple of emojis after them.
Okay. The next slide is from August 23rd, and this is where you began mapping some of the cell phone records. Is that correct?
That is correct.
Tell me what we're looking at here on this slide.
So this is a still shot. I applied a filter to the records. I actually applied from midnight, so 0000 to 0830 on August 23rd, 2022. And I noticed that both devices, so from here on out, the blue records will be Mr. Pahl's device, the red records will be Ms. Pavlons' device, but all records between that time frame used a cell tower on top of 1001 Delafield.
And the tower is actually on top of the apartment building where they were staying?
Yes, ma'am.
Okay. Why is it important in an investigation like this to have not just the records of the deceased, but also the records of someone that lives with her?
I'm not sure what you mean by that, but we're...
I'm going to ask you a different question.
Okay.
Why do you have them separate on this particular slide?
On this particular one, when these records overlap, they kind of look purple. So to keep it as clear as I could, these are the exact same time frames, the exact same geographical area, but I just showed the records separately to see that you could see that both the blue and the red devices are using that tower. Okay,
and this slide is not animated because they're not moving, right? The records are all in one location.
Yes, they're either at or very near that area this entire time frame.
Okay, next slide, please. Detective, you're familiar with the 1001 Delafield location of Willow Park Apartments?
Yes, ma'am.
Okay, and what are those numbers associated with on the photos?
So the left picture is a top-down view of 1001 Delafield. I added the 7 and the 4 to this picture. The cameras were labeled internally as channel 1, 2, 3, etc. So that number 7 is on the north door. That was where channel 7 was. And then the 4 is near where door 4, or channel 4, is. Same with the picture on the right. This would be looking from north to south. So we're on the north end of the building, looking at the building. The numbers slip down a little bit, but right above door, or the number 7, you can see that north entry door. And then, can I draw on here?
Yes.
Door 4 is actually down in here.
Can we please preserve that for the record, Madam Clerk? Thank you. Okay, if we can clear the screen, please, and we'll go to the next slide. Now, Detective, we watched these videos a number of times, but tell me what's the importance of this particular slide and the timing of this slide?
Excuse me. So this is the last video that I'm aware of that Ms. Pavlons is seen leaving this apartment complex.
Okay, and this is at what time?
It's on August 23rd, 2022 at 08:39:20. She's going to walk out within that video clip within a couple seconds there.
Okay, and detectives took note of her possessions, and that became a significant point in the investigation, right?
Correct.
Okay, we can please play this slide. Okay, and the next slide.
This would be channel 4, 2022 at approximately 8:40:22 a.m.
Okay, can you push play, please? Next slide. Okay, Detective, what are we looking at on this slide, which is slide 19?
So this again is out of Cell Hawk. Going to be a little more information now, but what this is going to be is an animation between 8:35 a.m. and 8:48 a.m. I note on the top of the slide a speed. So that is 1 second here in the animation is 15 seconds of real time. So it's not going to play at real time. It's going to be a little sped up. And then the records are set to fade at 30 seconds. So once a record appears, once 30 seconds of real time passes, that record will disappear from the screen. If you're showing a lot of records, sometimes it gets real messy. So having that fade to have them fall off after a time makes it a little more clear to see. Do you want to know what we're going to see in this in terms of animation?
Yes, please.
So at about 8:40, you're going to see records start to pop up. And then it's going to go to 8:48 where the devices are clearly moving north away from this area. So there's a blue pin on there. That is 1001 Delafield Street.
And that's just a little bit north of the coop?
That's correct. Yep. So it's.
Can you circle that on your screen so the jury can see that? Okay.
I'm sorry, it's green.
That's fine. And can you also circle the quick trip pin that you have so we can have a frame of reference?
Detective, you know how to change color?
I don't. I'm sorry.
I know how to change color.
Right, so, touch that, right. And you can erase the others first if you want. So there's the eraser thing in the bottom.
It looks like they went away. So.
Now can you circle them? Oh, that's much better.
So the first or the lower circle is 1001 Delafield Street. The upper circle is Quick Trip at 2001 Gulf Road on City Waukesha. Okay, and so you said the records will begin to animate once we push play? Yes, and then just for reference here, not the Google icons are like where Sobelman's of Waukesha is not that icon or the Coop icon, but you'll see a bunch of different orange dots across the map. Those are various towers on T-Mobile's network from the cell tower list that we have.
Okay. You created a number of animations for this case for a number of different days, right?
Yes, ma'am.
And did you include the towers in all of those animations?
I believe so, yes.
Okay, why do you do that?
So it's always important. It is best practice to show all the towers available. With time in advance records, which is what we're going to see here, it's given a distance measurement, and it doesn't always have to be the strongest tower. Any tower can register a time in advance measurement on a device. If we're doing analysis on just going back to the basic call detail record where all I have is a tower in a sector, your calls and your texts are generally going to use the closest tower. Not always, but generally they're going to be the closest tower. So if I didn't have that distance measurement, then all I had was a tower and sector. It's important to know where the other towers are around it, because I can start getting a little more detailed in where the device may be. If I just had one of those pie shapes in the middle of my screen here, I would just say the device could be anywhere in this area. But if I know where the other towers are, I can hone in a little bit better to give you a better idea of where the device may be.
Okay. If we could clear the screen, please, Madam Clerk. Okay, so we're going to see the devices begin to move around what time?
It's about 8:44. You'll start to see them moving north. It's a little zoomed out, so I'll try to have you pause when I see them moving north.
Okay, and this is, what are we going to see actually on the screen moving?
You'll see red and blue pies and arcs that are going to start to pop up, and those will begin moving north away from that. They'll begin at 1000 in the area of 1001 Delafield Street. They will eventually begin moving north along Delafield Street.
Okay, we can push play on the side, please. Okay, Detective, it seems like there at the end we saw a lot of activity. What were we seeing in the beginning, and what are we looking at now that we've completed that animation?
Yes, and I don't know what second marker was in the video, but about 8:46 a.m. is when I see the devices begin moving north. So we're going to step back a little bit as we go forward in the slides, but you see the different colors popping up near 1001 Delafield. If we zoomed away in on this map, you'd see more detail. But they're in the area of 1001 Delafield. They then begin moving north along Delafield Street, west on Northview, and then ultimately northbound on Grandview, which is the very large arc that's coming down, up and down on the screen there. It's right along that line in the middle where you see the Culver's icon.
Okay, so it's important to not just look at the pie shapes, but also the long arcs that are coming across?
The arcs are very important, yes.
Okay. Tell me about why the arc is more important, or maybe just very important.
So To answer your question, pie shape, remember, is just to make it easier on our eyes. It's just showing us which direction that sector is facing. Those large arcs that are coming out where you see the individual lines, again, if we're looking for somebody that has a device, we're going to be looking along that line. The device is generally going to be in the area of that large arc. In a perfect world, and I can kind of see it on this one, but can I mark up again, please? So this record here, and this record here, we see these arcs like this, and we see this arc like this. Those are within about, it looks like one's at 47 seconds, one's at 30, so about 9 seconds apart. So if I were to be desperately trying to find whoever has these devices, I would send people to where these arcs intersect. And that's likely going to be where the device, it's going to be in that general area. We now have two different towers registering that device in a very close time proximity. Where those arcs cross is where I would send my team to look.
Okay, can we please preserve this for the record? And then clear the screen, please. Can we go to the next slide, please? Okay, what happens at 8:41 a.m.?
At 8:41 a.m., there are two text messages sent from Matthew Pahl's device to Stephanie Pavlons' device. So this is a snippet out of one of our tools. But the first text is on August 23rd, 2022 at 8:41:07 a.m. It's to Ms. Pavlons' phone number, and it says IC, and then there's like eyeball emojis. Approximately 1 second later, at 8:41:08 a.m., there's another message with a capital U that is sent.
Okay, and the next slide, please. You are aware that detectives obtained some dash cam video that was a dash cam that was mounted on Mr. Matthew Pahl's vehicle, and ultimately one video from August 23rd was recovered?
Yes, ma'am.
Okay, and that's what we're looking at here?
Yes, ma'am.
What time is this dash cam being captured at?
What time does it say here, or what time do I know this dash cam's from?
Both.
So the time frame displayed on the video is August 23rd, 2022 at 21:44:27. That timestamp is 13 hours ahead of where it should be. So the actual time would be August 23rd, 2022 at 8:44:27 a.m.
Okay, so at 8:41 there's a text message, I see you, and then at 8:44 we have this dash camera video. Is that accurate?
That's correct.
Okay, can we play this video, please? Okay, and the next slide. Where was that dash cam captured? Where was Mr. Pahl when he picks up Ms. Pavlons?
So that dash cam depicts the vehicle turning into Moreland Medical, which is just north of 1001 Delafield. So on this map here where it says V&N Productions, that building there is 1001 Delafield. So I use Google Maps to mark the distance from the north drive into 1001 Delafield up to the driveway of Moreland Medical. That's about 420 feet north of 1001 Delafield.
Okay, next slide, please. Now it looks like we're going to see an animation from 8:45 a.m. going forward. What are we looking for in this particular animation?
So this overlaps partially with the first animation we saw. Again, it's very zoomed out, but in this animation, you'll see the devices leave the area of 1001 Delafield Street and travel to the area of Quick Trip, which is at 2001 Gulf Road in the city of Waukesha.
Okay, and you previously circled that pin, so I'm not going to ask you to do that again. Anything else we need to know about this or know what we're looking for before we play the slide?
I don't think so, no.
Okay, we can go ahead and push play. Okay, it looks like the animation is stopped. Where are those arcs for both devices crossing over here?
So a couple points here. The arcs are very near that Quick Trip pin. You can see there's one full circle there. So Cellhawk is unable to identify which sector was used. It still has a valid distance measurement, but because it can't determine the sector, it places that full circle on there. So it's still accurate distance-wise, but it doesn't know which sector from that. Yes, I'm sorry. So if Cellhawk cannot determine which sector is used, it'll map the full circle. So we still know that the distance from the tower is good. It does it as to be safe, it maps the full circle saying we don't know which sector was used, but it's somewhere along this full circle.
Okay, and is that true for both Ms. Pavlons' device and Mr. Pahl's device that it's mapping the full circle?
You can only see it could be purple. It looks red at this point, but you may see it on both devices in the animations.
Okay, and then if we could go to the next slide, please, slide 24. We're not going to watch this, the jury's already seen this, but you agree that as part of your investigation in obtaining these records and reviewing them, you also want to corroborate any information from cell phone records by other available evidence, right?
Yes, ma'am.
Okay, and by reviewing the Quick Trip video, were you able to corroborate whether or not those records that you obtained in the mapping that we just saw was accurate?
Yes, ma'am, and I think that goes to show how accurate the records can be, because I actually used the records to send my partner out to Quick Trip to obtain this video.
So we didn't even know that Mr. Pahl and Ms. Pavlons had been to the Quick Trip until you reviewed the cell phone records and saw Ms. Pavlons' device near that location?
That's correct.
Okay, so you would agree that in this slide, Mr. Pahl's truck...
It's crazy that we're going over the same stuff that we've gone over the last 5 days. The same stuff. This is wild. I think they're trying to embed it in the jury's head, which is true. I mean, that's their job. That he did this, and do not think they didn't. Sorry, it took me a while to get back. I was trying to clean up my med bucket here. I dropped all my medicine in the bottom of it. Oh, that was a mess. Okay. All right, let's continue.
Enters the Quick Trip parking lot.
Yes, ma'am.
Okay, we'll go to the next slide, please. We can play this one.
This should be a still shot.
Oh, okay, so I'm sorry, let's go back. Tell me what we're looking at here.
So here you're seeing a still shot. I applied a filter to the records to only show records on August 23rd, 2022, between approximately 8:52 a.m. and 9:13 a.m. All of the arcs that you're seeing, with the exception of one, are very near the quick trip. That arc coming off the very top record there, so it's a red pie shape facing southwest, and a large arc. That's actually a record at 9:13 a.m. and it's further west of quick trip. So at this point, they knew that by 9:13 a.m. the devices had left quick trip.
Okay. And the next slide. What are we looking at here?
Same thing. This is just zoomed in, showing quick trip and where those arcs are crossing closer up.
Okay, so unlike the last slide where you were maybe there was particular times associated, you did a whole time frame in these last two slides of seeing all the records within that time frame, right?
Yes, I just did it zoomed out so you could see what towers that information was coming from.
And this shows you that those two devices are at or near the quick trip on Gulf Road.
Yes, ma'am.
The next slide, please. Again, you reviewed the quick trip video to corroborate that Ms. Pavlons actually entered and kind of corroborate the time frame at which those records on CellHawk showed the two devices being at quick trip.
Yes, ma'am.
Next slide, please. Okay, and you reviewed all of the quick trip video from this particular time frame, and what did you observe while you reviewed that video when they're inside the truck?
So with this video, Ms. Pavlons comes back to the truck and gets in. There's a gap in video on this PowerPoint. I did review the video between that gap, and I didn't note anything unusual.
Okay, and the next slide. I'm going to ask to play this slide, please. This starts at 9:08:38 a.m. Is that accurate?
Yes, ma'am.
Can we pause it here? So I paused it at 9:10 a.m. Detective, when a vehicle starts to move, how long is it going to take before you're going to start to see a change in the records from a location?
It depends how many records are being generated. In theory, it would be immediately, but it all depends on how many records are being generated at a given time. So it may take some time just to see that gap in the distance of the arcs moving.
Okay, and we're going to start the video again at 9:10. Okay, Detective, based on this video, were you able to determine what time the vehicle left the quick trip and entered Gulf Road?
Yes, it appears it turned west on the Gulf Road at approximately 9:11:20.
Okay, next slide, please. Now we're looking from 9:12 to 9:20. Where's the approximate location of the devices during this time frame?
So at this time, or between that time frame, you'll see the devices generally moving west from the quick trip pin towards the OAW pin. Based on my analysis, the devices will be in the area of OAW, or Orthopedic Associates of Wisconsin, between approximately 9:15 and 9:18 a.m.
Okay, so we'll start. Okay, Detective, fair to say that everything we've seen so far indicates that both devices from Mr. Pahl and Ms. Pavlons travel north to the area of Quick Trip and then west to the area of OAW.
Yes, ma'am.
Those devices, their records indicate that they are traveling the same approximate path.
Yes, ma'am.
Okay. Next slide, please. Then we know from OAW records that Mr. Pahl had an appointment on August 23rd, and according to these records, he checked in at 9:34 a.m. You see that the bottom left, sir?
Yes, I do.
Okay. And next slide, please. What are we looking at here?
This was a picture recovered on Matthew Pahl's device. What you're seeing on the right is what's called metadata. That holds information about what type of camera, make and model captured this photo, and date and time that the picture was captured. So that camera model matches that of Matthew Pahl's cell phone, and it was captured at 8/23/2022 at approximately 9:34:07 a.m. And I've never been inside, but it does appear to be consistent with Orthopedic Associates' tape environment.
Okay. Do you recall, you said this was sent through Skype, so that's not, he's sending it through a Skype application on his cell phone?
Yes, this message was sent through a Skype message,
Okay.
yes.
Next slide, please. This indicates that Mr. Pahl checked in, or was first seen at 9:38 a.m., and his time out of the appointment was at 10:33 a.m. You agree with that?
It does appear accurate, yes.
Okay, thank you. Now, the next slide, please. What are we looking at here?
This is another animation. Covers a pretty wide time frame. The time frame is on August 23rd, 2022, from approximately 09:20 a.m. to 10:55 a.m. Primarily, all the records are going to be at or very near OAW, and at approximately 10:54, you will see at least one record that, based on my analysis, shows the devices are beginning to move east.
Okay, so we'll push play here. Okay, what did we say there, Detective?
Again, the devices, or the majority of the records in this animation, are at or very near, appears to be the same area of OAW. And then right at the very end there, approximately 10:54 a.m., you start to see those records or arcs moving east.
Okay, so based on the record from OAW in the slide before that, with his appointment ending at 10:33 a.m., the time period between 10:33 a.m. and 10:54 a.m., Mr. Pahl's device and Ms. Pavlons' device both remain in the area of OAW?
It appears so, yes.
Okay. Next slide, please. What are we looking at here?
Time frame is August 23rd, 2022, between approximately 10:52 a.m. and 11:04 a.m. In this animation, you'll see both devices take a general route of east on either I-94 or one of the side streets there to Grandview Boulevard. They'll go south on Grandview, east on Northview, south on Delafield, back to the area of 1001 Delafield.
Okay, and this animation overlaps a little bit with the last animation we saw?
Correct.
Okay, so will we see those, when that moment when those devices begin to move away from OAW on this animation as well?
Yes, ma'am.
Okay, thank you. If we can push play. Okay, next slide, please. The last slide we saw went up to 11:03 a.m. What are we watching here?
This is video from the north door at 1001 Delafield. You can kind of see outside there to the parking lot. You'll see a truck pass within this video that resembles Matthew Pahl's truck.
Okay, we can push play, please. Okay, so at 11:03, Mr. Pahl's truck enters the parking lot. Was that consistent with what you saw on the cell phone records?
Yes, ma'am.
And did that again corroborate the validity of the records that you had obtained and reviewed and mapped?
Yes, ma'am.
Okay, next video, please. This is now at 11:14 a.m. Detective, we saw his truck pull in at 11:03 a.m.?
Yes, ma'am.
Okay, and so he's not seen on video until about 11:14 a.m., is that correct?
To my knowledge, that's correct.
Right,
Yes.
we can push play here. Detective, to your knowledge, are there any outdoor cameras at Willow Park Apartments that would capture anything that's occurring in the parking lot?
Not to my knowledge, no.
Okay, and you actually assisted in obtaining the video with Department of Criminal Investigations to bring back to your department and assist detectives in reviewing?
Yes, ma'am.
Okay, is this the only camera view that really shows any portion of the parking lot?
I believe so, yes.
Okay, we'll go to the next slide then, please. What are we looking at here, Detective?
To be a very long time lapse, but it covers from August 23rd, 2022, from approximately 11 a.m. to 23:59 hours, or essentially midnight on August 23rd. During the animation, the devices appear to stay at or very near 1001 Delafield.
Okay. So up to this point now, you've essentially mapped the entire day of August 23rd, starting with that first animation that shows, the records remaining in the same place now, through this animation going through midnight?
Yes, ma'am.
Why did you want to see all of the records on that particular day?
At that time, that was the date that was given to me of interest, and to my knowledge, that was the last time we ever saw Ms. Pavlons on camera.
Okay, so we're going to play this animation, please. Okay, Detective, there are live records there, but did you see the devices at any point move away from that location?
If they did, it's in very close proximity to that area.
Okay, next slide, please. What time is this video from Willow Park taken at?
This is August 23rd, 2022, at 12:19:14 p.m.
Okay, play please. Okay, next slide, please. So we see him walk outside at 12:20 p.m.?
Yes, ma'am.
Okay, next slide, please. Play. Okay, and we see Mr. Pahl walking out towards the parking lot at 12:20 p.m.
Yes, ma'am.
Next slide. What time does this video start?
August 23rd, 2022, at 12:29:50 p.m.
Play, please. Okay, Detective, you told us earlier that between essentially this time, 12:30, all the way to midnight, Ms. Pavlons' device stays very close proximity to this apartment, right?
That's correct.
Does anyone use her device on that date?
Yes, someone does.
Okay, can we go to the next slide, please? What happens with Ms. Pavlons' phone on August 23rd?
So on August 23rd, there's 2 outgoing calls after that device returns. They're both to Quest or the food share or food card. So the phone number is listed there. It's 1-877-415-5164. The CTDU/food card is how the contact was listed in her phone. And those 2 outgoing calls occur at, the first one is at 3:53:22 p.m. That one lasts for approximately 1 minute and 16 seconds. The second outgoing call is at 3:55:15 p.m. and that call lasts approximately 45 seconds.
Okay, and that call comes from Ms. Pavlons' device at that time, right?
Yes, ma'am.
And it comes from, based on the records, in very close proximity to the apartment at 1001 Delafield Street?
Yes, ma'am.
And Mr. Pahl's device is also located at or near that same location during this time?
Yes, ma'am.
Okay, next slide, please. Actually, can we go back? Detective, were these calls present on Ms. Pavlons' phone when you reviewed her phone?
In the extraction, yes, they were.
Okay, that means that they were present and had not been deleted from her phone?
That's not true.
Okay, tell me about that.
So these 2 calls specifically were deleted from her phone. Because of the extraction we got, we recovered database files. We were able to see that these calls were still recovered. So they were actually deleted. The user of the phone would not see these. Through our forensic examination, we're able to see these 2 calls.
Okay, next slide, please. All right, we've moved on now to August 24th. What happens on Ms. Pavlons' phone on August 24th?
At approximately 2:52 p.m., there's an outgoing call to Pick and Save. The call lasts approximately 5 minutes and 52 seconds. This call was also deleted from her device.
Okay. Now, you testified earlier that on August 23rd, you mapped all of the records from Ms. Pavlons' phone, which indicate at the end of the day, her phone remains at the residence, right?
After very near, yes.
Okay, thank you. Were you asked to then review the records to determine if there were any other dates that Ms. Pavlons' phone or device left the area of 1001 Delafield?
Yes, I was asked to do that.
Okay. And did you create a mapping of any of those dates and times that her device left the residence?
Yes, ma'am.
If we do not have a mapping in this PowerPoint, what does that indicate the device location was?
So for the records we do have, it would be near 1001 Delafield. Unless there's missing records or something, it would be at the area of 1001 Delafield.
Okay. So only on a few select dates does Ms. Pavlons' device leave the residence?
That's correct.
So on August 24th, 2022, that outgoing call from Ms. Pavlons' device would have come from at or near the 1001 Delafield apartment?
Yes, ma'am.
Okay. Next slide, please. What happens in the Skype records on August 24th between 8:03 p.m. and 8:08 p.m.?
On August 24th, between 8:03 and 8:08 p.m., there's a conversation between Matthew Pahl's Skype account and Normagine Desierto Skype account. At 8:03, Pahl sends a message that reads, I'm really worried about something, but I can't tell you through text. It's not about me though. I think there's a typo there. I believe these messages are at 8:07 p.m. and 8:08 p.m.
Oh, okay.
I believe, I could be mistaken here, but so what I believe is 8:07 p.m. Pahl sends can't text certain things, and at 8:08 p.m. I believe Delafield responds, okay, I understand, but does it concern you, hon?
Okay, I know there's nobody in here watching, but I'm gonna fast forward because they're just going over the same stuff from yesterday that the other detective talked about. So let's just go up. I guess let's just start day 6. Because this is too much. I mean, why? Why are we discussing the same stuff? So let me find, because I want to try to get day 6 done before I have to go. You know what I mean? Yeah, my dog has to go outside, so I'm going to have to take her out. I totally forgot I had a dog because I kept putting the computer on top of her. The laptop.
No, sir.
Okay. All right. And you're prepared with your witnesses today, sir?
Well, we have witnesses. I just got to tell them to get here sooner than I thought.
Okay. All right. Very good. You need to test your equipment, ma'am?
Yes, please.
All right. And go ahead.
How long will I take? About another hour? 2 hours?
Yeah, we're about 1/3 of the way through the process.
1/3?
So 2 hours.
27 slides.
Yeah, okay.
I'm going to tell Dr. Goodard to be here by.
Okay.
Okay, well, I'll get...
Before we bring the jurors, anything else from the state?
No.
Defense?
Oh, great, this guy
No.
again. So
At that same time, there's a message sent from Mr. Pahl to Delafield on Skype, indicating that he woke up with a bad feeling. Evening hours of August 26th, there's, I believe, 3 missed Facebook calls to Ms. Pavlons' Facebook account from Layla. None of those are answered. Immediately following that, there's an incoming call on Ms. Pavlons' cell phone from Layla, and she leaves a voicemail. Generally speaking, she indicates she's in the hospital with a broken leg. About 15 minutes later, there's an outgoing call on Ms. Pavlons' device to check voicemail. And then Mr. Pahl sends a message to Delafield indicating that his niece had a broken leg. To my knowledge, I did not see any contact between Mr. Pahl's device and Layla. Later that night, there's an outgoing call from Matthew Pahl to Marvin Pahl. The outgoing call lasts several minutes. That's the first contact that I saw between their devices in over 2 months. After that call, there's a message to Delafield on Skype. That he says, Matthew Pahl says that he spoke to his father, that he's kind of worried as well.
Okay, thank you for that summary. Up to the point of August 26th, did you see any calls either from Mr. Pahl's phone or Ms. Pavlons' phone calling 911 or making any report to either the City of Waukesha Police or the Waukesha County Sheriff's Department?
No.
Okay. We can return again to Exhibit 202, please. I'm going to start on slide 57. That's in front of you now, Detective. What happens on August 27th?
On the morning of August 27th, there's an incoming call on Matthew Pahl's device from Marvin Pahl. That call lasts approximately 1 hour and 23 minutes. During that call, there's some web searches that we recovered on Marvin Pahl's MacBook computer. Those web searches are all made through the Yahoo search engine, and they include Stephanie Pavlons, missing persons, Waukesha, Wisconsin, and Stephanie Pavlons, missing woman.
As of August 27th, has Ms. Pavlons been reported missing by anyone?
Not to my knowledge.
Okay. Next slide, please. What happens on August 28th?
There was a Skype conversation between Matthew Pahl and Delafield at approximately 7:19 a.m. And Matthew Pahl says, in part, something happened, hon, I can't explain in text. And Delafield responds, was it related to the matter you were worried about?
Detective, I want to ask you, we've seen a couple messages where Mr. Pahl has indicated he can't talk about this through text. Based on your experience in reviewing hundreds of cell phones and messages from criminal defendants, is there a common theme for individuals to not want to talk about any criminal activity over text message?
I agree with it.
That's one question.
I'd agree with that statement.
Okay. What happens next?
There's some police scanner app usage on Matthew Pahl's device. It's open from approximately 7:22 a.m. to 7:27 a.m. And then later in the morning, there's a Skype call between Matthew Pahl and Delafield. It's about 9:04 a.m. and that call lasts approximately 2 hours and 16 minutes.
Now, Detective, we had a couple mentions of Mr. Pahl using a police scanner. What types of things occur over a police scanner?
Joint communications between law enforcement, dispatching to calls for service, any communication on a police radio.
Okay, and so if, say, a body was found or parties, law enforcement was responding to a crime scene, would that be aired over the radio?
Yes, it would be.
Okay. All right, next slide, please. What day are we on here?
August 28th, later in the morning, about 9:55 a.m. to 10:32 a.m. These are internet searches recovered from Marvin Pahl's MacBook computer. Search terms were made through Yahoo, missing people list in Wisconsin 2021, Stephanie Pavlons, missing woman, and then there's several Facebook searches, mainly for Layla Pavlons, appears to be Stephanie Pavlons with a spelling error, Stephanie Pavlons photos, again with a spelling error, and Georgianne Pavlons.
Do you know Georgianne and Layla Pavlons to be relatives of Stephanie Pavlons?
That's what I was told, yes.
Okay. Next slide. What happens on August 29th?
On morning of August 29th, the top two are web searches on Matthew Pahl's cell phone. There's a web visit to GM Today, the Waukesha obituaries page. Approximately 1 minute later, there's a search on GM Today for Pavlons.
And at this point on August 29th, has anyone reported Stephanie Pavlons missing or in trouble?
Not to my knowledge.
And at this point, does anyone, even law enforcement, know that Stephanie Pavlons is deceased?
No.
And what happens next?
There's two instances of police scanner app usage on Matthew Pahl's phone. They occur from approximately 10:34 p.m. to 10:40 p.m. and 11:22 p.m. to 11:27 p.m.
Next slide, please. Turning to August 30th, what did you find on Mr. Pahl and Ms. Pavlons' devices?
So beginning August 30th, I started to see messages being sent from Ms. Pavlons' device to Matthew Pahl's device. The first two are listed here. The top section is information that I obtained from Matthew Pahl's physical device. It shows that there's two incoming messages, both with what appear to be YouTube mobile links. And then the bottom section here is information from Ms. Pavlons' call detail record. Those RCS-IM chats are essentially your multimedia messages. So it's showing that there's outgoing multimedia messages from Ms. Pavlons' device to Mr. Pahl's device. The reason I referenced Ms. Pavlons' call detail record here is I did not observe these messages in her phone anymore.
So in order for those messages to not be on her phone, what would have to happen?
Either someone would have to delete them or a setting would have to be set to only retain messages for a certain amount of time and the phone would automatically delete them.
Okay. And I see, is that 8 messages outgoing from Ms. Pavlons' call detail records?
Yes, but that's not necessarily to say there's exactly 8 messages sent from her device. Sometimes you'll see multiple entries. Some of these are the exact same timestamps. So this would be what the network recorded, although they might not be 8 individual messages.
Okay. And in Mr. Pahl's device, you found 2 messages, including those links?
Correct.
So those messages were deleted from Ms. Pavlons' phone, but not from Mr. Pahl's phone?
Correct.
Next slide, please. What else happens on August 30th?
There's an incoming call on Ms. Pavlons' phone from what I believe to be Aurora Medical. What you're seeing on the top there is an incoming call on Ms. Pavlons' device, and then that same call being routed out to voicemail. So the incoming call obviously wasn't answered, and that call was directed to voicemail. Approximately 32 minutes later, there's an outgoing call on Ms. Pavlons' device to check voicemail, and that outgoing call to check voicemail was deleted from her phone.
And these calls and messages that were both sent and received in the outgoing call to the voicemail, did all those occur at or near 1001 Delafield Street?
At this point, yes. I don't have any indication that the device left that area.
Okay. You also indicated that the voicemail, is it the voicemail itself that is deleted or the call to the voicemail that's deleted?
The call to check voicemail.
Okay. Next slide. Continuing on August 30th, what do we see here?
There's a Skype conversation between Matthew Pahl and Delafield. At approximately 10:30 p.m., Delafield says, "Have you talked with your dad?" And then at approximately 10:36 p.m., Matthew Pahl says, "No, not today. The day before, I did, but tomorrow I have to call him again. It's very important."
What happens next?
There's a Skype call between Matthew Pahl and Delafield. It's an incoming call on Matthew Pahl's device, and that call lasts approximately 45 minutes. It occurred at approximately 10:39 p.m.
Okay. Next slide, please. What happens on August 31st that was significant of this investigation?
There's additional web searches on Matthew Pahl's device between approximately 10:26 a.m. and 10:27 a.m. There's a web visit to GM Today, specifically the Waukesha obituaries page. Then there's a search on GM Today for Pavlons, and then an additional search, a web visit on Waukesha obituaries page on GM Today for Richard D. Pavlons.
Okay. What was unusual about these web searches that you continue to see going forward from August 23rd all the way to now August 31st?
I'm not sure what you mean by unusual. What I did here is sometimes you'll see if somebody leaves a tab open, it's not actually an additional search, rather they just opened that tab again on their phone. So when I put these searches in the PowerPoint, I selected only ones that have different or unique spelling. So in this case, we saw that the search for Pavlons actually has a space after it. That's different than the last search for Pavlons.
So you can say that this is a new search, not just opening a new tab, or opening the same tab over again.
Correct.
Okay, so this is a unique and different search from the searches you've seen before.
Yes, ma'am.
Okay. What about those incoming calls on Ms. Pavlons' device?
At approximately 2:39 p.m., there's an incoming call from who I believe to be Delafield Dental, and there's a voicemail associated with that call. Approximately 1 minute later, that same call is routed out to voicemail.
Okay, if we can play the voicemail, please.
This message is for Stephanie. This is Katie calling from Delafield Dental. I was just calling to let you know I look forward to seeing you this coming Friday, September 2nd at 12 p.m. for an invitation appointment. Again, that is this coming Friday, September 2nd at 2 p.m. Thank you, Stephanie. Have a great day.
So, Detective, that message was left on August 31st in reference to an appointment on September 2nd?
Yes, ma'am.
Okay. Next page, please. Okay, Detective, what are we seeing here?
So this is going to be another animation. It's on September 1st at approximately 7:13 a.m. This was the first time that I saw obvious movement on Ms. Pavlons' device moving away from the area of 1001 Delafield. The device generally is going to travel from the area, the Waukesha area, down to the area of Frederick Hospital. It does appear that both Matthew Pahl's device is traveling with Ms. Pavlons' device at this time.
Okay, so from August 23rd until September 1st, Ms. Pavlons' device remains at or near 1001 Delafield Street?
It appears to, yes.
Okay, and then on September 1st, when you observed that these devices traveled together away from the apartment, did you also endeavor to make sure that there was no surveillance video of Ms. Pavlons exiting the apartment around the same time that these devices are leaving?
I didn't specifically do that, but to my knowledge, she's never seen it on the video at 1001 Delafield.
That was done by other detectives in the Waukesha County Sheriff's Department?
Yes, a number of people reviewed that video.
Okay, so you said this is going to be an animation just like we saw before, right?
Yes, ma'am.
And please tell me about what exactly it is that we should be looking for on the map as far as the significant portion of the animation.
Yeah, so you're going to see both blue marks pop up on the map. Those will be for Matthew Pahl's device. You're also going to see red marks pop up on the map. That would be for Ms. Pavlons' device. It's important to note, remember, that the tower is going to have that cone shape, but when we're doing analysis of these records, we're looking more so at the arc from that tower, not necessarily the tower being used.
Okay, we can push play, please. Okay, Detective, and based on your review of these records, do you believe both devices have traveled together to the area of Freighter Hospital?
Yes, ma'am.
Okay, next slide, please. Why was this significant on September 1st?
These are pictures captured on September 1st by Matthew Pahl's device. Up top, that's some data regarding application usage logs, which shows that the camera applications being brought into focus on his device. Between approximately 8:11 a.m. and 8:12 a.m., there's 2 pictures captured on Matthew Pahl's device. These 2 pictures are both from a building at Freighter Hospital.
Why did you find these to be significant in your analysis of the records themselves? Let me ask you a different question. Do these pictures help you corroborate the records and the analysis that you've made of the records?
Yes, ma'am.
Okay, tell me about that.
I guess it's 2-part. First off, these records, we're tracking a device. So I'm not tracking necessarily a specific person, but rather I'm talking about generalized locations for a device. So it's important that we're able to determine who's using that device. Further, these records do have some variance to accuracy. In my experience, they are very accurate, but it's still important that we corroborate our findings with other known facts, such as pictures being taken at a specific location.
Okay, and so this corroborated that Mr. Pahl's device was certainly at Freighter Hospital based on these photographs?
Yes, ma'am.
Okay, next slide, please. What else happens on September 1st?
This conversation between Matthew Pahl and Delafield on Skype, including the following message. At approximately 8:11 p.m., Matthew Pahl says, "Other one is called vacay.com or vacay.com. Either one, I'm looking for a one-way ticket from Chicago O'Hare to the Philippines, most likely Manila. Then 2 days before I leave, I will buy a throwaway ticket to go to Thailand or Vietnam. You have to do this if you plan on staying longer than 30 days, but I think you know this."
And important in this message, Mr. Pahl indicates that he's buying only a one-way ticket rather than a round-trip ticket?
It appears that way, yes.
Next slide, please. What else did you see on the devices on September 1st?
On September 1st, between approximately 8:52 p.m. and 8:53 p.m., I observed more messages being sent from Ms. Pavlons' device to Matthew Pahl's device. So the top section is from Matthew Pahl's device. It shows that there's incoming messages, 2 of them. They each have 1 attachment, and then the attachment is listed on the far right. The first one is named 1154.heic. The second one is named 1138.heic. And I marked that they're empty because that attachment wasn't necessarily recovered. However, at not the exact same time, but within seconds of those messages being sent, his phone created thumbnails of images. And in the thumbnail file name, I see the matching, so the first one is THMB, which is typically short for thumbnail, _1154, which matches the file name attachment. And then the second one is THMB _1138, which matches the second attachment. The bottom section on this page, there's some really long file names, but specifically the second line down here where it says images, and then there's a description of a really long file name. That image, that's an image, it's cached by Ms. Pavlons' messaging application. That image matches the thumbnail attachment on Mr. Pahl's device. And then later on, second from the bottom, there's another image with a very long file name. That matches the second thumbnail created by Mr. Pahl's device. In the bottom section, around what we're seeing there is application usage on Ms. Pavlons' phone that shows that the messaging application and the gallery application are being used. I noted that information because the messages on Ms. Pavlons' phone were deleted. So I'm using this evidence to corroborate that that application was in use, and it's likely that a message was sent.
Okay, so you don't actually find the messages sent from Ms. Pavlons to Mr. Pahl in Ms. Pavlons' phone?
That's correct.
Okay, so you need all of this kind of complicated information to confirm to you that those messages actually were sent?
I guess I don't need them because I see on Matthew Pahl's device that there are incoming messages, but the bottom portion I use to show that they were sent from Ms. Pavlons' device and they were deleted.
Okay, and the next slide, please. This pertains to some of the information you've already testified to, right?
Yes, these are the 2 images that I just talked about. Each image appears twice. The reason being is the very first image, so starting far left, is that very long file name that I talked about that is being cached or modified by Ms. Pavlons' device. And about the same time, that thumbnail is created on Mr. Pahl's device. And even though they're slightly different based on computer technology, to your eye, they appear the same. And the same thing for the third and fourth picture. The third one is the very long file name being cached or modified by Ms. Pavlons' device. And then about the same time, that thumbnail on the far right, or the fourth picture, is what is created on Matthew Pahl's device.
Okay, so we have still just 2 photos that are sent from Ms. Pavlons to Mr. Pahl's device, and this tells you how you know it's these particular photos?
Yes, ma'am.
Okay. Next slide, please. What else happens on September 1st?
There's additional conversation between Matthew Pahl and Delafield on Skype. Beginning at approximately 9:28 p.m., Delafield says, "What time do you prefer to travel and arrive, hun?" At approximately 9:36 p.m., Matthew Pahl says, "Time doesn't really matter, but I think I'm looking for a flight leaving possibly at the end of the month or beginning of next month." Approximately 2 minutes later, Matthew Pahl says, "Last time I checked, this month was September. End of this month to beginning of November is my target date to launch."
Detective, I failed to ask you this when we were talking about the last few messages that were sent from Ms. Pavlons' device to Mr. Pahl. You showed us a mapping earlier in the day of both devices traveling to Freighter. Did you also observe that these devices return back to the residence or are later at the 1001 Delafield location?
Yes, ma'am. There were records that showed Matthew Pahl's device traveling a similar route back to 1001 Delafield. There were no records on Ms. Pavlons' device necessarily to show it traveling back to 1001 Delafield, but it does eventually show back up at 1001 Delafield.
If the device was powered off, would that explain why there are no records for a particular device?
Yes, ma'am. For the time in advance records, I guess a couple situations where those records would not be generated would be if the device is off, if the device is not connected to the network, or lack of record retention by the provider.
Okay. And in this case, you saw records for Mr. Pahl traveling back to the residence?
Yes, ma'am.
And they have the same provider?
They're on the same provider, yes.
Okay, so that would rule out that particular scenario for Ms. Pavlons not having records?
Yes, most likely her device would be powered off or lost connection to the network.
Okay. And the images that were sent from Ms. Pavlons' device to Mr. Pahl's device, those are being sent at or near 1001 Delafield Street?
Yes, ma'am.
Okay, thank you. Now we'll move on to September 2nd. Next slide, please. What did you see on September 2nd?
This is again additional messages being sent from Ms. Pavlons' device to Matthew Pahl's device. Same kind of theory here in terms of why there's so much information here. The top section is from Matthew Pahl's device. You'll see that the first message at approximately 8:23 a.m. has that 382.jpg attachment. A couple seconds later, there's a thumbnail with that 382 being modified on Matthew Pahl's device. At approximately 8:24 a.m., there's a message sent to his device with an attachment of 379.jpg. And a second later, you see the thumbnail, including 379.jpg, being modified on his device. At the bottom, same type of information. These messages were not recovered on Ms. Pavlons' device. So here I'm showing that between 8:23 a.m. and approximately 8:24 a.m., there's the usage for the messaging application. And while there's usage in the messaging application, there are two long file names, one at 8:23:44 a.m. and one at 8:23:58 a.m. Those two long file names being modified by Ms. Pavlons' messaging application match the thumbnails being created on Mr. Pahl's device at this time.
Okay, next slide, please. Same thing here. We're looking at the actual images that were sent from Ms. Pavlons' device to Mr. Pahl's device?
That's correct. So it's two images, each displayed twice, one being the modification on Ms. Pavlons' device, one being the thumbnail modification on Mr. Pahl's device, and that's the same for each image.
Right. And in order for these images to be sent from Ms. Pavlons' device, someone would need to be actually manipulating the phone, going through the photos, and finding these to send through the messaging app?
Yes, ma'am.
Next slide, please. What else did you see on September 2nd?
At the very end of that exchange that I just talked about, there's a snapshot that's created. We saw this previously back on August 24th. We had the same snapshot displayed. This is very similar to a screenshot on your device, but this is the phone doing this automatically, typically when an application is closed. So we just saw two pictures that were sent. In this snapshot, you can see that the last text, or appears to be the last text message, is a message to Chewy, in which you, or Ms. Pavlons' device, sent a picture, and that very small thumbnail matches one of the pictures that was sent from Ms. Pavlons' device to Mr. Pahl's device.
Okay, we also see in the snapshot a message on Wednesday, two messages on Tuesday, and a message on Monday. Were those messages located within Ms. Pavlons' device themselves?
I don't believe any of those were recovered from her physical device.
And so that would mean that they were deleted sometime after September 2nd when the snapshot was created?
Yes, ma'am.
Okay, and some of those messages are talking about appointments?
Yes, ma'am.
Okay, even those messages were deleted. Is that your message?
I believe that's right, yes.
Okay. Next slide, please. Continuing on September 2nd, what else happened?
At approximately 12:09 p.m., there's an incoming call on Ms. Pavlons' device from who I believe to be Delafield Dental. That call goes unanswered and is routed out to voicemail. So that's what you're seeing in those top two entries. These were recovered from Ms. Pavlons' call detail record, as these phone calls were deleted from her device. Actually, I don't believe that these ones were deleted. I'm not confident in that. Approximately 7 hours later, at 7:17 p.m., there's an outgoing call on Ms. Pavlons' phone checking voicemail.
Okay, we can play that voicemail, please.
Hi, this message is for Stephanie. This is Katie calling from Delafield Dental. We had you scheduled today for your new patient appointment at 12 o'clock. The time is now 12:10. We're just calling to see if you were on your way or if we do need to go ahead and get that appointment rescheduled for you. We can see you up until 12:15, so if you are on your way, please go ahead and give us a call back here within the next 5 minutes. And if not, then just get that call rescheduled. Thank you. Bye-bye.
Now, Detective, whoever listened to that voicemail would know that Ms. Pavlons missed an appointment on that day?
Yes, ma'am.
Right. And are these calls occurring at or near 1000? Well, let me ask that again. Are these calls occurring while the device is at or near 1001 Delafield?
Yes, ma'am.
Okay. Next slide, please. Okay, September 2nd at 8:52 p.m. What was significant about this timing?
This is going to be another animation. This is the second occurrence that I noted where Ms. Pavlons' device clearly leaves the area of 1001 Delafield. It's going to get messy again with the number of records shown, but the devices appear to be traveling together. Mr. Pahl's will be the blue, Ms. Pavlons' will be the red. They go to the area, kind of the south side of Milwaukee, and then they both return to the area of 1001 Delafield.
Why were you asked to map each time both devices left the area together?
So the initial request to me was to identify any times where Ms. Pavlons' device appeared to leave 1001 Delafield. And if I were to identify any times where her device left, does it appear that Matthew Pahl's device is traveling with it? So this is the second of 3 occurrences where I could tell that Ms. Pavlons' device left the area of 1001 Delafield.
And during each of those 3 occurrences, did both Mr. Pahl's device and Ms. Pavlons' device leave?
Yes, and they appear to be traveling together.
No other times where Ms. Pavlons' device leaves on its own from the residence?
Not that I found, no.
Okay, thank you. If we can play this animation, please. So, Detective, that animation shows the devices both leaving the residence, going to an area of Greenfield and Layton Avenue, and then also returning?
Yes, ma'am.
Okay. I see the time counter on the right-hand side. Is that approximately the times that we are seeing the devices leave and then return?
On the right-hand side of this map?
Yes.
Yes.
Okay, so you said at approximately 8:52 p.m. both devices leave the area of 1001 Delafield. What time did the...
So he went over the messages that were deleted from Stephanie's phone, which was the dental office. And these were done after she had passed. Don't sound good, but still don't mean he unalived her. Sorry, I was outside with my dog. And then every time I go out there, it's like I'm dying when I come back in for my allergies. And I take allergy pill every day. I don't know, guys. I just don't think that, I mean, when could he have done this? They said right after his therapy appointment. Well, there were people everywhere, people coming and going, people. All right, well, let's see what else he has. Don't forget to like, share, comment how I'm doing, okay? Thank you.
Do both devices approximately return?
I don't recall specifically if you played back the animation. I could give you my best approximate based on the speed of this animation.
Right, this is a pretty quick animation.
Yes, ma'am, it's moving very fast.
Okay, we'll start it again.
Based on the speed of that, my best approximation is about 10:05 p.m.
Okay, and this time counter goes all the way to 10:14, so there's some overlap that both devices are back at the residence and remaining there?
At or very near. With the zoomed out, I can't say specifically that they're at 1000 Delafield.
Okay, next slide, please. Then what happened on September 4th that was significant in your investigation?
On September 4th, these are UTC times, so between approximately 5:05 p.m. and 5:40 p.m., there's activity on what's labeled as Stephanie Pahl's Facebook account, which was told to me that is Stephanie Pavlons' Facebook account. So there's a message from Ms. Pavlons' account to Sherilyn Valente on Facebook. And at 10:05 p.m., that message reads, "What's happened with you and Matt?" Following that, there's a number of messages incoming from Sherilyn Valente's Facebook account to Ms. Pavlons' account.
Okay, and can you tell us what Ms. Sherilyn says at 10:07?
At approximately 10:07 p.m., Sherilyn Valente types, "Hi, I don't know, I'm clueless. I really didn't know what's happening. Do you have any idea? Because I've been worrying so much."
What was significant in your review of the Skype messages between Sherilyn Valente and Mr. Pahl, and any contact you were aware they were having between August 23rd and September 4th?
In reference to Skype specifically, I don't believe there's any Skype contact between Sherilyn Valente and Matthew Pahl between August 23rd and this time. I do believe there's an email exchange between them, though.
Right, we saw an email between Sherilyn Valente and Mr. Matthew Pahl on August 26th?
That sounds right, yes.
Okay, and so it appears that Ms. Pavlons' account is the one that reaches out to Ms. Sherilyn Valente?
Based on this, yes.
Okay. What's the next message Ms. Valente sends?
At approximately 10:08 p.m., Ms. Valente writes, "Please help me."
And the next two messages?
The next one at 10:09, those swears are likely from some type of emoji or something that can't be encoded properly. And then at 10:11 p.m., there's a message from Sherilyn Valente reading, "I don't want to lose him, Steph."
And what are the next few messages that she sends on September 4th?
At 10:33 p.m., Sherilyn Valente writes, "He never gave me his real name." At 10:34 p.m., Sherilyn Valente writes that I respect him. If he doesn't want to, that's okay with me. And at approximately 10:40 p.m., Sherilyn Valente writes, "Steph, I don't have trusted friends either, and I'm glad I met you. In fact, I'm really getting shy with you because I don't want you to think that I only talk to you when I need something. No, it's not that. One day, I'll make it up to you."
These messages occurred between 5:05 and 5:40. Where was Ms. Pavlons' device located at the approximate time of these messages?
I believe at or very near the area of 1001 Delafield.
Okay, next slide, please. The Facebook messages continue. Can you read these messages, please?
Yes, beginning at approximately 10:40 p.m. Ms.
What time
Valente,
in local time?
I'm sorry, 5:40 p.m. local time. Ms. Valente writes, "Like, asterisk." At 10:40 p.m. again, Ms. Valente writes, "What made him mad?" At approximately 10:41 p.m., I'm sorry, 5:41 p.m., Ms. Valente writes, "I don't want him get mad." At approximately 5:43 p.m., Ms. Valente writes, "I'm sorry, Steph. If it seemed I'm not interested, I don't mean that."
And what does Ms. Pavlons, what does her account respond at 5:54 p.m.?
At approximately 5:54 p.m., Ms. Pavlons' account writes, "I have belly ache. I need to find medicine. If he says anything, I'll just tell him you care very much, and I just reached out to you. Sorry, I have to rest, but please take care of yourself. And so you know he always cared very much for you very much."
How does Sherilyn Valente respond to those messages sent from Ms. Pavlons' account?
She first reacts with the heart emoji on that message, and then at approximately 5:58 p.m., Sherilyn Valente writes, "Oh, I'm sorry to hear that. You take med stuff and you take care of yourself. I just feel relieved talking to you. I'm so worried about him, and I care for him so much that hopefully we overcome this. And sorry too if I don't open my messenger much. I just opened this for work, but I'll surely can receive your messages. Take a rest, Steph. Thank you for reaching out. I really do appreciate it so much. Have a great day."
And that last message is sent at 5:58 local time?
That's correct.
Okay. Going to the next slide, did you observe both devices leaving the residence at approximately 9:27 p.m.?
Yes, they do leave the residence. This is much closer proximity. It's not as obvious that they leave the residence, but they appear to travel south to southeast on Delafield Street to the area where the coupe is labeled on this map.
That's pretty close to the apartment based on this map?
Relatively speaking, yes.
And based on your evaluation of these records, compared to some of those records where we saw them travel great distances, did you believe that the devices were traveling by some way other than car?
Yes, most likely on foot or on a bicycle, definitely not in a vehicle.
Okay, we can play this animation, please. based on that animation and the arcs of those records, do you believe that the devices remained in close proximity to maybe like the downtown Watchet area or just on the west side of the river?
Yeah, based on my analysis, they'd be in the area of the Coop or about where Madison and East North intersect, and I can circle that if you'd like.
Sure, that'd be great. And how did you make that determination? Just trying to understand how these records work and what exactly you're looking at.
Yeah, so when I analyze these, remember that the shaded area has nothing to do with the record. That shaded area is just for visual. So when the animation started, you saw the blue line or the blue arc slowly moving away from 1001 Delafield, moving south. Eventually, we began seeing records from Ms. Pavlons' device coming into the map, and those are also south of 1001 Delafield. So looking at just the records on our screen here at this time, both devices are in the general area of those arcs, Ms. Pavlons being the red, Mr. Pahl's being the blue, and those are clearly away from 1001 Delafield at this time.
Okay. Next slide, please. I guess I should ask you before we move on. Detective, did you then observe both devices return to the residence?
They do eventually return. I don't have an exact time frame when they return back to the area of 1001 Delafield.
Okay. Next slide, please. Okay, if we could clear the screen. So looking at September 5th, what do we see here on the screen to the right?
So I kind of just talked about this, but this is a list of Skype contacts between Matthew Pahl and Sherilyn Valente. So the top two messages here, one being August 21st, 2022, the next entry being a missed incoming call from Sherilyn to Matthew Pahl on 8/23/2022, and then there's a gap from 8/23 to September 5th, 2022, where I did not observe any messages between Ms. Valente and Mr. Pahl on Skype. But again, there was that email exchange between them on August 26th.
Okay, and on September 5th at 6:42 a.m., what message does Mr. Pahl send to Sherilyn Valente?
Yes, at approximately 6:42 a.m. on September 5th, 2022, Mr. Pahl sends Ms. Valente a message that reads, "What's the matter? You don't check your emails like you're a messenger?" And that's followed up with another message that reads, "If you want to know, good. If not, that's fine too."
Why was that message on September 5th about checking Messenger significant based on what we've seen on September 4th?
So, to my knowledge, Stephanie Pavlons is messaging Ms. Valente. I should say Ms. Pavlons' account is messaging Ms. Valente's account through Facebook Messenger. And based on this, it appears Mr. Pahl may have been the one doing that, as he's now questioning Ms. Valente as to why she doesn't check her email, but she's checking Messenger. And I take Messenger here to be that of Facebook Messenger.
Okay, and the last message that Mr. Pahl sends at 6:44 a.m.?
At approximately 6:44 a.m. on September 5th, 2022, Mr. Pahl writes, "No, I'm not trying to chat. Read your email."
Then what happens later that morning at 8:56 a.m.?
There's I don't remember if it's incoming or outgoing, but there is a call through Skype between Mr. Pahl and Ms. Valente that lasts approximately 2 hours and 6 minutes.
Okay, and that's the first time that there's any sort of voice call between the two parties dating back through Skype?
At least in the information I reviewed, yes.
Next slide. On September 6th, did you become aware that Mr. Pahl had an appointment at OAW at approximately 10:30 a.m., and based on these records, he checked in or arrived at about 10:34 a.m.?
Yes, ma'am.
Okay. Next slide, please. Did you become aware that there was dash camera video obtained from Mr. Marvin Pahl's apartment that depicted some of Mr. Pahl's activity on September 6th?
Yes, ma'am.
What does this depict?
This is a dash cam from Matthew Pahl's truck. Begins at approximately 12:08 p.m. on September 6th, 2022. And it's in the parking lot of Orthopedic Associates of Wisconsin.
Okay, and again, the same dash camera has that timing difference that you have to account for?
Yes, ma'am. It's approximately 13 hours ahead of local time here.
Can we play this video, please? Okay, that ends at 12:09:23.
Yes, ma'am.
It appears the vehicle is moving pretty slowly. Did you do anything to alter this video to slow it down, or is this at the normal speed of the video?
I did not alter this video at all.
Okay, we can go to the next slide, please. The next video starts at 12:09:31.
Yes, local time here, 12:09:31, September 6th.
It appears there's a little bit of a gap between the last video that we watched and this video. Did you find any other videos from September 6th?
No, ma'am.
Okay,
But not in this time frame, I should clarify.
This is the video exactly as you found it?
Yes, ma'am.
Okay, we'll start again, 12:09. Can you pause it, please? Oop. Detective, when we pause the
Video, and I'll show it to you just to be fair. Exhibit number 574. This is already published, Judge. You see Mr. Pahl in the video, true?
Yes, I do.
And he appears to have shopping bags on that cart, true?
Yes, it looks like groceries.
And did you ever, I mean, if you had gone to Walmart to buy those groceries, you were told that, did you ever check with Walmart with the receipt to indicate to the jury what he had in the grocery bags?
Did I personally? No, I did not check with Walmart for a receipt.
Did anybody from your department go check with Walmart to see what he had bought in that day?
I do not know the answer to that.
Would that have been possible to check with Walmart to see what was in those bags?
It's probably possible, depends on their point of sale system, but some places, yes, we would be able to get a receipt and see what was purchased.
So, if I told you there was food for him and Ms. Pavlons in the bag, you would know any different, true?
I don't know how I would know that.
True. If there was feminine products in those bags, you would know any different, true?
That's true.
If you got the receipt, would have been able to tell you that he put feminine products on that day?
Possibly, yes.
Did you check? I mean, we saw Ms. Pavlons' phone, but apparently she deleted text messages or information from her phone, true?
I don't know who deleted the information from her phone.
But there was deleted text messages, true?
That's correct.
Did you check Mr. Pahl's phone to see if there was deleted text messages on his phone?
To some extent, I don't recall how in-depth that analysis was, though.
But had he deleted similar messages on his phone, you probably would have noted that, true?
I don't recall if the request was made to me. I don't recall specifically analyzing the database on his phone as I did on hers.
Do these cell phones have limited storage?
At some point, yes. I don't know the exact capacity of these devices, though.
So, if the cell phone was to reach its capacity, would it be necessary to delete messages?
Yes, if you wanted to store more information, you'd probably get some type of a warning saying that your storage is running out, and they'll maybe offer you some guidance on what you could delete.
Now, you indicated that you were given cell phones from Mr. Pahl, true?
Mr. Pahl, yes.
Ms. Pavlons, true?
Yes.
Did you ever obtain in Marvin Pahl, true?
I don't recall seeing Marvin Pahl's cell phone.
You didn't delete anything from Marvin Pahl's cell phone?
I would definitely not delete anything from Marvin Pahl's cell phone.
Did you download anything from Marvin Pahl's cell phone?
Me personally, no.
How about Mr. Pahl's mother, her cell phone?
I don't recall forensically examining those devices.
There's one thing I was going to show you. I think it was slide 82 on here. Yes, I think you can probably show it. Please put it short to the goodness.
Like 82.
Correct. Slide 82. I think yours doesn't match with mine.
I just wanted to cut in. Say anybody could have deleted that stuff off anybody's phone. That does not mean that he's a murderer at all. It just doesn't. It does not make him an murderer. And I really hope that this jury is paying attention. We need their attention today. I skipped to the defense because the state was just repeating herself. The same video we watched yesterday. Same exact video. So, all right, here we go.
There was one where he's in front of the building. Right?
Yeah, that's...
There it is. I'm showing you it's been marked as exhibit number 81. Can you see that? Exhibit 202, slide 81. Do you see that?
Yes, sir.
And then you played this for the jury, true?
Yes, sir, I played.
And yeah, okay. Wait, can you stop it until you stop it? I can't. Could you start this for the jury? Again, this is the front of Orthopedics Associates, true?
That's correct.
Heading west, true?
Correct.
Could you stop it there? No, it's stopping it at, my monitor says 10825, true?
I see that, yes.
And you see what's west of Orthopedics? Are those woods?
They appear to be trees, yes.
Can you keep going? Can you stop it there? Those are clearly woods on the west side of Orthopedics, true?
I would agree that looks like woods, yes.
So there's woods on the west side of Orthopedics and apparently on the east side, true?
Yes, that's true.
Could you keep going, please? Just stop it right there. Now, as far as we know, there's no exit onto Gulf Road on this part of Orthopedic building, true?
I do not believe there's an exit on the Gulf Road on the west side of this parking lot.
So the only entry and exit is on the east side, true?
That is correct.
And that's where all the traffic is coming and going from the east side, true?
Yes, that's correct.
On this side, the west side, there apparently is no traffic. Would you say that's true?
I don't see any traffic in this video, no.
Could you keep going? Could you stop it right there? Do you see Orthopedics building on your right?
I do.
On the back end of that building, there appears to be no windows whatsoever, true?
Sure, from what I can see here, I don't see any windows. I guess in the back half, I see some windows immediately on the right here.
And we're approaching the north part of the building, true?
Correct, the northwest corner is what we're looking at.
And behind the building is more woods, true?
Yeah, I mean, there's a golf course back there, and yes, trees. Maybe you call it woods, sure.
Could you keep going, please? Can you stop it, please? So, you can clear. Okay. This is 109. Look, it's 0902. True?
Yes, I see that.
And again, that clearly shows the woods behind orthopedics. True?
Yes.
Are you aware there's a swamp back there also?
I don't know that particularly. It could be.
Could you keep playing? True? Keep playing, please. Could you stop it right there? You see the south side of the building of orthopedics?
I cannot see the south side in this. We're looking at the north wall.
I think it's the north side. You see the north side of the building?
Yeah, this is the north side of the building.
Again, this corner, do you see no windows on it? Absolutely no windows on that side of the building, true? On this end of the building.
Yeah, what would be the northwest corner? I see it doesn't appear to be any windows on there.
So on this corner of the building, there's absolutely no windows, true? On the west side and north side of the building, true?
From what I've seen in the dash cam, yes, the northwest corner, I do not see any windows in the building.
And again, this side of the building has, you don't see anybody walking in the area, true?
In this video, no, I did not see anybody
You
walking.
didn't see any cars coming in and going down the road, did you?
No, I did not.
There appears to be no individuals and no traffic in this side of the building, true?
True.
Could you keep on playing, please? Thank you. Would it be safe to say that all the traffic of individuals and vehicles are all on the opposite side of this building, true?
I'm not sure I understand what you're asking.
It's safe to say all the patients coming into orthopedics are coming in from the other side of the building, true?
I guess, yeah, I did probably enter the main entrance on the south side of this building, yes.
And again, the golf road, frontage road is on that other side of the building, true?
That's correct.
Straight ahead is woods and golf course, true?
That's correct.
Again, I asked you, if Mr. Pahl is circling around the building looking for Ms. Pavlons, your mapping wouldn't indicate anything different than that, true? Your self-hawk mapping?
Likely not enough to show that he's moving around the building, that's correct.
I have nothing further, Jim.
All right, any direct? All right, how much do you think you have?
Quite a bit.
All right, let's take a break now. It's just before noon, and let's come back at 1 o'clock. Yeah, everybody okay with that? All right, 1 o'clock. All right, Blueberry. All right, have a seat, everybody. Thank you. Sit down, sister. Anything before we break from the state?
No.
Anything from the defense before we break? Please, no?
No, sir.
Okay, very good. We'll keep you ready to do it at 1 o'clock. Thank you.
I'm here. Okay, I think we're gonna go into the... Oh no, he's still there.
Okay, so we'll take it. I don't know how long he's going to last, but we'll have the jurors leave after that, okay? All right, let's have the jurors come back then.
So what do you guys think? So it looks like he got a fresh haircut yesterday. Oh, looks like he got a nice haircut. He wanted to look good for the jury.
All right, all 14 jurors have a turn. Have a seat, everybody. I trust you have as much. Detective Schrader is on the stand, and you finished up with the cross-examination questions, Charlie. Yes, sir. Be direct.
Thank you. Detective Schrader, based on your review of the cell phone records and the data that you obtained, if Mr. Pahl told investigators that he found Ms. Pavlons' phone at the car wash on September 6th, would that be consistent with the information that you obtained during this investigation?
Judge, I object. That's not facts and evidence.
Overruled.
Judge, there's no testimony of a cell phone being found at the car wash. There's a person in the note.
Overruled. You can answer. No, that would not be consistent with my findings.
Right. Tell me why.
This information that's occurring in Ms. Pavlons' phone is consistent with somebody using that device. So if it were to have remained in the truck until the car wash on September 6th, I don't know who would have been using that device near 1001 Delafield.
Okay. Now, you said earlier that you don't know when some of these messages are deleted, but you can say with certainty that Ms. Pavlons didn't delete any messages after 8:23, right?
After 8:23, I do not believe it would be possible for her to have deleted any messages.
Obviously.
And in your review of the cell phone records that were used to map the maps that we've seen on Friday and again today, did you use best practices in making those maps?
Yes, ma'am.
What really do those best practices require?
In terms of specialized records that are used in the maps that I created, I follow the scientific working group of digital evidence, which indicates that you should, or it recommends that you map with cell site, sector information, and an arc providing the distance from tower.
Okay. Did you also have someone peer review those records that you peer review the maps that you created to ensure that you were providing accurate information to this jury?
Yes, ma'am.
You were asked about the records right around 10:53 a.m. and if it was possible that Mr. Pahl drove west on Gulf Road, right? Do you remember that question?
Yes, I do.
Okay. Was there anything in the records that indicated to you that Mr. Pahl's device drives west on Gulf Road past the point of OEW?
I did not see any information that would indicate that.
And in fact, the records indicate that the devices remain in the area of OEW between 10:33 a.m. and 10:53 a.m.
That's correct.
We can go to Exhibit 202, please. I'd like to start on slide 51. Detective, you asked a lot of questions from Mr. Delafield about the police scanner app in particular days. So I want to go back to those days. One of the days that he asked you about was August 26th. So we're going to go to, okay, looking at slide 51, what was happening on August 26th?
There's an incoming call from Brookfield Dental Center. There's an outgoing call on her device checking voicemail. And both on August 25th and August 26th, there's missed calls from Layla on Ms. Pavlons' device.
Okay, we can go to slide 52, please. Also on August 26th, Layla leaves a voicemail, which is ultimately checked. Is that correct?
I believe it to be checked, yes.
Okay. That would be consistent with other people in Ms. Pavlons' life reaching out to her, trying to reach out to her, making phone calls to her, right?
Yes, at least attempting contact with her, yes.
Okay, and if we can go to slide 64, please. That's August 31st. That was another day that Mr. Pahl was checking the scanner. What was happening on August 31st?
There's some web searches from Mr. Pahl's phone regarding obituaries. There's an incoming call from Delafield Dental. And there's an outgoing call on Ms. Pavlons' device checking voicemails.
Again, someone else reaching out to Ms. Pavlons, checking in, making a phone call, right?
There's an incoming call, yes.
Okay. So both of these are days that someone outside of Mr. Pahl may be looking for Ms. Pavlons. Fair to say?
To be fair.
Okay. Now, on 9/9, we saw that huge jump up to 66 times the police scanner was used, right?
Yes, it was about the focus, yes.
Okay, thank you. About the focus. In your experience as both a patrol deputy and as a detective, is law enforcement careful about what's aired on the radio over a scanner?
Objection, that's speculation. He doesn't know what everybody else is doing on the scanner.
In my experience, if we respond to we'll call it a sensitive matter, whether it be a fatal car crash or something where somebody may be deceased, we're always advised not to air that information. We would typically not provide license plates or names over the air, just to mitigate the risk of somebody scanning and providing bad information to an outlet.
It's important for law enforcement to be the first point of contact making a death notification, right?
We try our best to do that, yes.
So that type of information is not aired over the radio to prevent someone from maybe finding out about maybe their loved one being deceased before law enforcement's had an opportunity to do so?
That's
Yeah,
correct.
Judge, I'm objecting to all the speculation coming in.
That's correct.
If we can go to slide 123, please. Sorry. Detective, slide 123 is from September 14th. Sorry, can we go back to the left? Couple more, sorry. Oh, there we go. Sorry, I was wrong. Slide 113. We can now play this later for the witness. This is a message that's sent to Stephanie from Mr. Hobeck. Is that correct?
Yes, that is correct.
And that was also, September 14th was also a day that Mr. Pahl's brings the police scanner after focus, and then usually large number of times, right?
I don't recall how many times September 14th was.
Sure, we can go back to, I think it's forward. There we go. September 14th, he brings the police scanner after focus 30 times.
Yes, it does appear that way.
Okay. You asked about some of the obituary searches that you found on both Mr. Marvin Pahl's computer and on Mr. Matthew Pahl's devices. Why were any searches prior to September 17th for things like Stephanie Pavlons, obituaries, why were those significant prior to 9/17 in your investigation?
Again, I don't know exactly what was put in that press release, but it's uncommon for us to disclose that information during an active investigation. So with law enforcement not being notified of even the recovery of the body in the woods, to releasing that name, I don't believe that had occurred at that point. So any searches prior to that specific to her seem like somebody that would maybe have additional information.
You would agree that if Mr. Pahl dumped some devices in the river or got rid of devices, you have no idea that those devices had been destroyed, dumped, taken somewhere else, right?
Correct, unless I got outside information that something was destroyed or where it was placed.
So you don't know that that wasn't done in this case, right?
True.
You know what devices you have and the devices that you were able to extract and provide data from.
That's correct.
You asked a lot of questions about some of the video from August 23rd about Mr. Pahl's clothing, what he's wearing, what you could observe. You agree that there's about 10 minutes, 11 minutes between when Mr. Pahl's truck enters the apartment complex and when he actually enters the building.
I believe it's about 10 minutes, yes.
Okay. You have no idea what Mr. Pahl was doing in the truck before he enters the building, right?
I do not. No.
He could have brushed off his clothes.
He could have?
We don't know.
That's correct. I do not know.
You were also asked if he concealed the water bottle when he brought the pink water bottle in on August 23rd, right? You remember that question?
Yes, ma'am.
And you said he didn't conceal the water bottle.
That's correct. He just carries it in.
But he does conceal the purse when he walks in on August 23rd, doesn't he?
Objection, Judge, that's for speculation. Mr. Pahl always carried stuff in bags every single time he entered the apartment. This was not anything.
I'm
happening, tracking cell phones, contact with his father, and Marvin Pahl's device being used to do research or look things up related to Ms. Pavlons' obituaries, death, bodies being found, and so on. I'm going to find that there is sufficient information, again, substantially, to believe that the state could meet its burden of proof on both counts, and so I'll deny the motion to dismiss at this time. What's going to happen with the defense? How many witnesses?
2, possibly 3, Judge.
Okay, and is your client going to testify? Do you know at this juncture?
No, sir.
You do not know, or he's not going to?
Do not know.
Okay, all right, then will anything before we bring jurors back?
Can I go see if the witnesses are out there?
They better be out
Yeah,
there.
we had that construction day come back at 1.
Oh, yeah, so he's 3.
So I think this is Jason.
You gonna go check?
Construction worker.
Let's go, let's go. Let's see my line. No. Sorry, I didn't know.
Jason Denoise.
Jurors back.
This is for the defense. State rested.
All right, all 14 jurors have returned. Have a seat, everybody. Ladies and gentlemen, as we know, the state's arrested at this time. Shall these are Mr. We'll call you first witness.
Defense called Jason from Muslim.
Right, sir, if you come up to the witness stand to my right here, please. And then once you're I'm going to ask you to step up. And if you could raise your right hand and be sworn in by your clerk.
Please swear the testimony you're about to give is before the court, the truth, the whole truth, and nothing but the truth, so help you God.
Yes. All right, have a seat, sir. Can you tell us your name, please?
Jason Panasi,
And Jason, J-S-O-N. Correct. Spell the last name, please.
E-N-O-S-K-E.
All right, thank you very much. Go ahead, Mr. Galloway.
Thank you, Judge. Jason, where do you work?
I work at Finbrook Construction.
And what do you do for them?
I'm a carpenter.
And on September, August 23rd, 2022, who are you working for?
I was working for J.H. Findorf, but you were hired by Pahl to pound no trespassing signs that day.
And where was the no trespassing sign supposed to be placed?
Around a couple properties that kind of own around North Keith Building, off Road, I-94.
And did you go there by yourself to do this project, or were you?
No, there was 3 of us.
Who were the other 2?
It's Nick Ricano and John Bergeson.
And was anyone there in charge of the project?
Yes, that's Nick Ricano.
And again, you were there on behalf of Pahl?
That's correct.
And what kind of signs were you posting? What was on sign?
They were just a basic no trespassing sign. They were putting around the complete perimeter of their properties.
So that would have been on the east side of the building, true?
Yes,
Did you post
east
any?
and west.
So did you post any on the back side of the building?
I believe some of it kind of wrapped back there, but I can't say for sure. There was a number of trespassing signs.
I'm going to show you, as was marked as exhibit number 14, just the juror, and the publisher. Can I publish to the jury?
Yes, that's already been admitted, right?
No, exhibit number 400 in there.
Well, okay, I'm sorry, which number?
400, 400.
400?
Just your side with it.
Right, that's not been used yet, right? No, okay, go ahead. Wait, do you not have an objection to it?
Don't have an objection.
Okay, very good, go ahead.
It's going to come on your screen. Let me know when it's on your screen there.
I got it.
Can you see on your screen? Does that appear to be the area that you posted on August 23rd, 2022?
Yes, this was one of the sections.
And you were the one handling the signs?
Correct.
Was it you and
John Bergeson.
John Bergson were the ones handling the signs?
Correct.
And I think the other individual was the person telling you what to put them.
That is correct.
And do you recall the time you started the project?
I'm thinking it was earlier in the morning, 8 o'clock maybe. We started pounding signs, 8 or 9. It was somewhere in there, I think.
And where did you commence pounding the signs, you specifically?
Well, it would be the last. It would have been the last one we pounded in, and this back to tree line by the golf course.
And it's safe to say that you guys always stayed together when you did this project?
That's correct. I mean, Nick would take the lead and kind of check out maybe the next spot in a couple areas, but we followed him.
I'm showing you that's exhibit number 401. Do you see that?
I do.
Does that appear to be an area? Well, in that area you can see the golf course, true?
Yes, true.
And there's a wooded area in front of the golf course?
That's correct.
Did you mark that area?
With, yeah, in the back of it.
And do you see the part of the orthopedic building on the right there?
Say it again?
Do you see part of the building on your right?
Yes, I do.
And again, during this time where you're pounding this part of the no trespassing signs, you're all still free, all three of you still together.
That's correct.
Did there come a point in time that something caught your attention, or one of the three's attention about something in the woods?
Yes, it did.
What was that?
We weren't sure at first. Nick's the one who actually went over there and checked it out while Rock and I, John Bergeson, that's his nickname, were pounding there for the last sign.
So Nick got your attention?
Yes.
And did you walk over by Nick?
We both did. Similar time frame. Both at the same time we followed in. Once he said something like, I see a guy or I see something laying. So we followed over there and kind of checked it out and see what was going on.
When you heard Nick say that, where was he standing in relationship to the woods of the golf course? Was he inside the woods or outside the woods?
No, we were into the wood, frame probably the woods, but I would say maybe 10 feet. He cut towards the other side, the golf road side. That's where he spotted it.
He cut over to the other side through the woods?
Cut through, but not completely through the woods. It was just on the other side.
Was there a path going through the woods there?
It wasn't really a path. I don't remember that.
When you walked in, did you see what he was referring to?
Yes.
How far away were you from what he was referring to?
We all got within about 15 feet, I'd say roughly of it.
And did you know, or did you ever figure out what that was laying there in the woods?
Well, as time went on, kind of checking it out for a few seconds, we all settled on the fact that we're looking at a corpse here.
Yeah, could you tell, was the Did you make any guess or figure or thought as to whether or not to strike it? Did you know whether or not the corpse was a human versus an animal?
I'd say it was pretty evident when you saw shoes and stuff on it, yes.
So you thought this was a human versus an animal in the woods?
That's correct.
And you had a thought as to whether that was a female or male?
When I approached it, I assume I'm not a dead body expert, but generally are, but I saw what I thought looked like women's shoes on body.
Yeah, so you thought it was a woman?
The coloring is, I think, what sold me on it.
And you thought it was a woman laying there?
I thought, but I couldn't tell by the rest of the body.
Did you exit the woods with the other two?
That's correct.
Did somebody contact the police?
Yes, Nick found it.
Did the police arrive on the scene?
Yes, they did.
How long did it take for the police to arrive on the scene?
15 minutes.
Did you interviewed by any of the police officers?
I'm going to say, this was a couple years ago, but maybe a short period of time.
Yeah. Did you tell the police officer what you saw?
We filed police reports, so, yeah.
Did you tell the police officer that you thought it was a woman?
I believe so. I believe that was on the report.
I don't know if the person, Sean.
Cross-examination?
Thank you. Mr. Panaski, you were asked some questions. This was on September 9th of 2022, not August 23rd, right?
Yeah?
Does that sound right?
Yes.
Okay. So you're there on September 9th with your coworkers to pound into no trespassing signs, and you said that based on the shoes is what made you believe that this was a female?
That's what I thought, yeah.
Okay. Did you talk to anyone about this other than law enforcement that day at OAW?
No.
Did you go inside OAW?
No.
Did you tell anyone that walked by that you found a woman in the woods?
There actually was somebody that approached us, I believe it was a woman, and she asked what had been found, and I think somebody out of our group might have said, we discovered a body.
Okay, so that's all you're sharing with anyone other than law enforcement?
That's correct.
Okay. And you said that you assumed based on the color of the shoes that it was a woman?
I think so, yes.
Okay. Nothing else stuck out to you that made you think that was a woman?
No.
Okay. You said you couldn't tell by the rest of the body because of the condition of the
It's
body?
in poor condition, yes.
Decomposed?
It looked like it had been there for quite some time.
I don't have any other questions.
All right, any redirect?
No, sir, thank you.
All right, thank you, Mr. Panaski. Appreciate you being here. So you're free to go.
Okay, thank you.
Next witness.
Yes, sir.
So we have a doctor. Dr. Stacy Hale.
If you could come up to the witness stand to my right, please.
The ER doctor.
And you can step up and then raise your right hand and be sworn.
Please swear the testimony you're about to give in the stand before the court shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
All right, please be seated. Could you tell us your name, please?
Yes, my name is Dr. Stacy, Stacey, Hale, Hail, like a hailstorm.
All right, thank you. Go ahead, Mr. Galaviz or Mr. Galaviz. Okay, go ahead.
Dr. Hale, you currently employed?
Yes.
And where do you work?
I am an associate professor at the University of Texas Southwestern Medical Center located in Dallas, Texas, and I staff the emergency department at Parkland Hospital, which is also located in Dallas. It's also where JFK was taken when he was shot, and the single busiest emergency department in the United States.
And at the hospital, what capacity do you work?
Can you repeat that?
At the hospital, what do you do?
I am an emergency physician, and I'm also a medical toxicologist.
I'm showing you what's marked as defense exhibit number 441, and just for the witness. Is that on your screen, doctor?
That is my CV.
And a CV is what?
A curriculum vitae, kind of like a resume, but more in the academic setting.
It almost scroll through it just to double check. And did you draft this purposely for this trial, or is it your CV?
Yes.
It appears to be 33 pages long.
Yes.
Okay, well, I don't think we need
Does the CV discuss your qualifications?
Let's try to get
But for the most part, yes.
And could you go through some of those?
Or non-prescription medications and murdered and dumped at a dump. And I testified also at the federal level, even though it was a homicide, about a case in Texas where a nurse stole a drug called etomidate from the hospital.
I mean, you're going to have to spell that for the call reporter.
Etomidate is ETOMIDATE. This is a drug that we use to give patients before we intubate them or sometimes before procedures. And in this particular case, the individual injected his friend with etomidate to render him unconscious and then shot him in the head and stole some money from him. I think that's the ones on the top of my head right now.
You ever testified in a case involving an accidental homicide? Accidental homicide, any cases?
Well, I don't know what you mean exactly by accidental homicide.
Yeah, accidental death.
There are certainly accidental overdoses, which are many of the drug dealer cases and doctor-related cases that I've seen where not that it's necessarily an intentional or suicidal overdose of a medication, but someone that has a repeated supratherapeutic ingestion, meaning you keep taking more and more than you should. And of course, most people that are shooting up heroin or fentanyl don't mean to kill themselves.
Are there any kind of homicide cases that you've testified to that I failed to ask you about?
Not that I can think of on the top of my mind right now.
And when you've testified in these cases, were you testifying as a medical toxicologist expert or a medical emergency?
Well, you can't differentiate the two. As an emergency physician, my expertise is in
managing all comers to the emergency department. So whether it's trauma, whether it's a heart attack, whether it's a stroke, whether it's an overdose, whether it's a psychiatric problem, so anything that presents to the emergency department, and that is part of my expertise, is being able to not just have tunnel vision, but as a medical toxicologist, as a sub-board of emergency medicine. Most people find that confusing, but a medical toxicologist's expertise is in the management and treatment, diagnosis of poisoned patients. And most of the time, those are emergencies. So an overdose, a snake bite, a chemical exposure. And of course, there's things like asbestos exposure and cancer from factories that you work at that is more long-term, and that falls more into occupational toxicology. So my role as a cause of death expert when I am asked to review cases is not just wearing the tunnel vision of a medical toxicologist, but to look at the case as a whole, look for traumatic causes of death, look for natural causes of death, consider an arrhythmia, and look at the toxicology.
So have you ever, in these cases, do you render an opinion as to the cause of death?
Yes.
In what percentage of these cases do you render an opinion as to the cause of death?
Well, with regard to federal cases, there is a standard that I have to meet, which is the but-for cause of death. So typically, medical examiners will render a cause of death, which is, in terms of toxicology cases, they will list all of the substances that are found post-mortem. And it's not very common to find just one substance post-mortem. So therefore, they need, in order to render a but-for cause of death opinion, meaning but for this particular substance, this person would not have died, you need to have a medical toxicologist review that toxicology testing in the context of the totality of the evidence. And about 50% of the time, when the federal government asks me to review a federal level death case, I cannot meet that but-for standard because there may be some fact or some hole in the investigation that renders it not possible to render a but-for cause of death opinion.
Have you reviewed, you testified for the federal level, state level for the prosecution, true?
Yes.
Have you reviewed other cases for the prosecution that it wasn't necessary for you to testify, but you reviewed the case anyways?
I've reviewed hundreds and hundreds of cases where I will write a report and the defendant may plead guilty or the case resolves in some way such that I don't ever have to go to court and testify.
Judge, if I haven't done so, let's keep page on your CV. I'm strong to all the cases that you testified, true?
Yes. Or I should say all of these cases are cases where I have rendered a report and been designated as an expert witness. If I actually testified, that is listed on the CV under that case.
Page 22 of your CV lists your research experience, true?
Yes.
And could you briefly outline that to the jury?
When I was in high school, I was a science nerd, and I entered the science fair every year. I was working with Dr. Pahl in Milledgeville, Georgia, and I was doing cancer research with him and entered my research every year to the science fair. In my senior year, I won the state of Georgia science fair and got to go to the international science fair. And then this other research includes some of my undergraduate chemistry research that was at SMU.
Same page, your CV.
New street drugs to keep in mind or watch out for. Of course, for a number of years, the concern was that there were counterfeit pills that contained fentanyl, and so, of course, warning the public.
You, again, testified that you have rendered an opinion in the court of law as to cause of death, true?
True.
Have your opinion under both hats or just one hat?
Say that again?
Under both hats? You're an expert medical toxicologist, and you're an expert medical in medicine, true?
Your Honor, I'm going to object to the form of the question and the labeling of expert.
I'll sustain the objection. Next question.
So you testified as an emergency medicine doctor, true? For gunshot wounds.
Objection to the relevance, Your Honor.
It's relevance.
Well, I guess we don't know how Ms. Pavlons lost her life, so there hasn't just covering gunshot homicides, her experience in dealing with them.
There isn't anything on this record that says she died by gun.
I'll take that as a fact then. So have you dealt...
So the objection sustained. Next question.
No gunshot. Have you dealt with any patients who have been stabbed?
Yes.
Approximately how many?
Too numerous to count.
More than 1,000?
Probably not 1,000, but in the hundreds.
So have these patients who've been stabbed, have any of them passed?
Yes.
The number, any of them who have come in with stab wounds did any of them come in for seizures?
Yes, I would say I see a patient with seizures at least once a shift.
What kind of symptoms do you see of these patients with seizures?
Frequently, patients that have seizures, that they might either shake uncontrollably, but they can also become very rigid. One of the concerns is them biting their tongue, and that is a finding when someone has had a seizure that lets you know that they probably really did have a seizure. And then another thing that is not uncommon when somebody suffers a seizure is to have urinary incontinence.
What does that mean? You said
Urinary incontinence means to basically pee on yourself or lose your bladder. It's not something that person can control.
Any patients that were brought into your emergency room that dealt with having been suffocated?
Yes.
And what symptoms, if any, did you see on those patients?
Well, there are people that can be suffocated either by strangulation and compression to the neck, and if that's by hands or by significant force, then there's a bone in the neck called the hyoid bone, and that frequently can fracture in a situation like that. Not 100% of the time, but when you see that, that is concerning for some type of neck trauma, and it also has constriction of the arteries that go to your brain. So as soon as the blood is not getting, or the brain is not getting blood and oxygen, you can lose consciousness and pass out. And another thing that you can see with compression is what are called petechiae, which is spelled P-E-T-E-C-H-I-A-E, which are teeny tiny little punctate bruises that you would see from your neck up on the face, and that's not uncommon with compression to the neck.
Now, in this case, I contact you to render an opinion as to the cause of death of Stephanie Pavlons. True?
True.
And did you make an opinion in this case?
Your Honor, I object based on prior rulings of this court.
I'll overrule the objection at this juncture, because Mr. Gallagher is very well aware of my prior rulings.
What materials did you have to rule or strike a review to make that determination?
I not only reviewed the autopsy report, the toxicology testing, the police reports, the photos from the scene, the autopsy photos, text messages, medical records of Stephanie Pavlons. There was some video footage that I reviewed, or still shots of video footage, transcripts of interviews of Matthew Pahl, of other family members. So I am rendering a cause of death opinion with the totality of the evidence.
Are you medically licensed to prescribe prescription drugs?
Yes.
Based upon your review of the medical records of Ms. Pavlons, did you know whether or not Ms. Pavlons was prescribed medication during the year of 2022?
Yes.
Was she prescribed alprazolam?
Yes.
Have you ever prescribed alprazolam?
I have, but we try not to.
Why is it like that? What's alprazolam prescribed for?
Alprazolam, also known as Xanax, is what's called a benzodiazepine, which is benzodiazepine. And a benzodiazepine is a drug that is prescribed for anxiety, and it is a sedative hypnotic. It works actually very similar to alcohol, the same receptors, very similar. And basically the reason why we don't like to try to prescribe it continuously is because it does have a high addiction potential, and there is also a withdrawal syndrome associated with Xanax. Just like you might have heard of alcohol withdrawal, or DTs, which is delirium tremens. One of the life-threatening consequences of alcohol withdrawal is having these DTs and seizures. Benzodiazepines like Xanax also have a withdrawal syndrome that can cause seizures in patients that don't have epilepsy. It can cause them in anybody, which is why we try not to prescribe them chronically.
Was, based upon your review of the records, was she prescribed oxycodone?
Yes.
Have you ever prescribed oxycodone?
Yes.
What's the purpose of oxycodone? Why do people get prescribed that?
Oxycodone is an opioid pain medication, and it is used to treat pain.
It's not similar to alprazolam, is it, as far as being addiction?
Of course, you can become addicted to opioids, but opioids work at opioid receptors, whereas Xanax works at a receptor called the GABA receptor. Not necessary to understand all of the complexities of those receptors. Both types of medications are addictive, but oxycodone works at opioid receptors. And part of the toxicity of opioids is it causes something called the opioid toxidrome. Toxidrome is the words toxic plus syndrome mashed together in one, and it's a bread and butter term that we use in medical toxicology, and that is the constellation of signs and symptoms that are unique to a certain substance. So all opioids cause the same kind of toxicity, which is pinpoint pupils, so your pupils get teeny tiny, and then central nervous system depression, which is anywhere from being very sleepy to comatose, and then finally and most importantly, respiratory depression, which is when you're breathing slower and slower until you stop breathing and die. Now, Xanax, those benzodiazepines, can cause central nervous system depression in an overdose situation, but not specifically respiratory depression like the opioids. The respiratory depression associated with opioids like oxycodone is much different from what you see with the sedatives, which is why there was an opioid epidemic.
There's positive findings. Those are the substances that were reported to you to be present in some tissue, correct?
Correct.
From the autopsy report or the toxicology report, correct?
So I'm not sure what the objection is about alprazolam. These were things that Ms. Pavlons was described that she was taking during that month of the summer of 2022. Because of her state or decomposition, blood was couldn't take blood from her, so they only could take it out of her liver. So I think, I know Ms. Hopper doesn't want the jury to hear this, but it's unknown whether or not this was in her system because of, alpha-prazolone was because of the decomposition of the body and the lack of blood. That's,
So I'm looking at Dr. Hale's report, page 14. Do you have the report with you, Doctor?
I don't have it with me, but I would like to.
I could give it to her, Judge.
I'm going to show her. There's page 14, and it says positive findings, and it mentions a number of substances. That's document 156 from our file, and we'll just put up that document. Document 163, I'm sorry. I apologize, Madam Clerk. As always, you're right. Page 14. Just come up short, Doctor. It's frozen. All right.
Just I could show her. Want me to? I don't have an exhibit.
All right, bring it up.
It would be defense exhibit number 442. You want me to go page 14?
Yes, sir. Doctor, page 14 lists positive findings. Those are the substances that were reported to you to be present in some tissue, correct?
Correct.
From the autopsy report or the toxicology report, correct?
Correct.
All right. Ms. Galvez, you can ask her where alprazolam is in there or some kind of substance or derivative of that.
Dr. Gibbs, from this MMS report, where is alprazolam connected to those substances found in Ms. Pavlons?
So alprazolam is not on the toxicology findings. It is a medication that was prescribed to Ms. Pavlons.
But you don't dispute that it was prescribed to her, Ms. Hopper?
It was prescribed.
Okay. Right, no, I understand.
Okay.
But it wasn't found in her system.
Correct.
Right. So, and then oxycodone or its derivative. So what other objections do you have?
So that was on there, and that's in her report on the bottom of page 14, that oxymorphone was found.
Right, metabolite of oxycodone.
Yes.
So your concern was the
Alprazolam and then the buprenorphine.
And what is buprenorphine, which is just testified about? What substance is that, doctor? Is it a common name or generic name?
Do you want me to answer?
Yes, doctor.
Buprenorphine is a medication used for opioid addiction. It does have a brand name Suboxone when it is mixed with Narcan, but buprenorphine is the generic name. And
Excuse me for a second. Did you have a prescription for it, Mr. Galvez?
Yes, sir.
Okay. Did you dispute that, Ms. Hopper?
I don't dispute the prescription. I doubt that it was detected.
Okay, all right. So I previously indicated that the doctor can report about the substances found in Ms. Pavlon's tissue. And we've got other evidence about the tissue or the strength of the findings and so on. So there was a prescription for alprazolam or Xanax, and if there was a prescription for Suboxone and it's some substance in it, I am going to allow that testimony that there may have been a prescription for it. But I think whether or not it's relevant is a subject for cross-examination. But I want to be really clear here. I've made my ruling about what this doctor can report. She can report about the toxicology findings and the other verbiage about the cause of death, what she believed golfers could see or not see. That is off limits. And I think I've made that very clear previously before. And if you get even close to that, I'm not going to wait for an objection, right?
would you clarify for me what?
Mr. Valley should have done that for you already.
Judge, I did, but I think you ruled that she could not testify as to the manner of death, not the cause of death.
She is able to testify about her beliefs about the toxicology, right? The report sets those things out. She says certain things. In each of the substances, she makes findings about. I'm just going to start looking at page 15. The end of the first paragraph. Acute overdose cannot be ruled out. Death from caffeine toxicity is rare and thus unlikely. Death from cotinine, COTINE toxicity is unlikely, etc. She's made those findings about those substances. And I think I've made it very clear about, in the motions in limine, her ability to testify today. And I've made those findings already.
Correct.
Right? And I presume you've related them to her clearly. That's your responsibility, not my responsibility.
Right. And again, your ruling was that she was not to give an opinion as to the manner of death, not the cause of death.
She can testify about the substances that she made findings on and whether or not they contributed to her cause to death. I think I made that clear.
So my concern, Your Honor, is that nowhere in this report does she say the cause of death for Stephanie Pavlons is blank.
I understand that.
So I have a lack of notice as to what she's about to say. Absolutely no idea what she's about to say.
But you do. You have her report, and if she says something else, you can impeach her with it.
But I can't because she never says in the report her cause of death is oxycodone overdose or alprazolam overdose, or she doesn't say what the cause of death is. Her ultimate conclusion is suicide must be considered, which is what you
specifically indicated was not to be testified to.
Correct. And suicide is not cause of death anyway, it's a manner of death.
Right.
But that's what her report says. But my concern again, Judge, and I'm sorry to be repeating myself, but I have no problem if he says to her, was she prescribed alprazolam? Yes, she was prescribed alprazolam. But to allow her to say what are the effects of withdrawal of alprazolam, or can death result from alprazolam, when there's nothing in this record, gives an improper miscommunication to this jury that, boy, there must be something more here. He could, I believe, my request is he can ask what she's prescribed. But if it's not in her toxicology, we don't know if she consumed it or not. We just simply don't know. Nobody knows. Dr. Hill doesn't know. I don't know. Nobody knows unless it's in her tox.
I understand that. And I think that's a proper subject for cross-examination. So I'm going to allow that testimony, right? As to what she was prescribed, and perhaps what those substances may or may not do. But again, the fact that there isn't any indication in the toxicology report, and that whether or not alprazolam could cause X, Y, or Z, that's a fair and appropriate subject for cross-examination, whether or not it was at all present.
All right, thank you.
All right, we'll bring the jurors back.
And we might prescribe it short term, but our hope would be that that patient receives continuity of care either by their primary care physician or their neurologist to continue that kind of long-term prescription.
Was she prescribed clonidine? Spelled C-L-O-N-I-D-I-N-E.
Yes.
Have you ever prescribed that?
Yes.
What's that for?
Well, clonidine actually has two purposes. The first, most commonly, is to treat high blood pressure. The other reason why it may be prescribed is to treat opioid cravings.
Was she prescribed bupropion?
Yes.
Spelled B-U-P-R-O-P-I-O-N. Have you ever prescribed that?
Again, this is a psychiatric medication, and same thing, we try not to prescribe psychiatric medications for emergency patients because we would want that to be in conjunction with our psychiatric colleagues.
Again, you are a medical toxicologist, true?
True.
And your expertise is in prescription drugs or illegal drugs?
Yes.
And your expertise in this field, how long have you done it?
Since 2004.
Is it dangerous for a patient to mix these drugs?
It can be, yes.
Is it dangerous for a patient who's prescribed any of these drugs to stop taking them?
It depends on which one. Alprazolam is, again, a medication that if you stop it, you can develop a withdrawal syndrome. So part of that withdrawal syndrome that is dangerous is seizure activity. Alcohol withdrawal, benzodiazepine withdrawal is a life-threatening condition, whereas opioid withdrawal, albeit extremely uncomfortable, is not a life-threatening condition. Opioid toxicity is, but not opioid withdrawal.
Now, you talked about the documents you received from the medical examiner. Does that include the NMS report?
Yes.
Prior to this court case, have you ever seen an NMS report?
Oh, almost every day.
I'm showing you it's marked as State Defense Exhibit number 442, just for the witness, please. Is it? Oh. Let me take... I made a mistake. Exhibit number 443, doctor. Tell me when it's on your screen.
This is NMS Labs. NMS stands for National Medical Services, and it is the go-to forensic toxicology laboratory in the entire country. It's located in Pennsylvania, and many medical examiners, even from California to New York to Texas, send their samples to NMS Labs, as well as sometimes other types of samples as well, and they are the ones that will do the forensic toxicology testing.
Now, does this appear to be the NMS report from Ms. Pavlons?
Yes.
Do you recognize this as being the report from Ms. Pavlons?
Yes.
It's an 8-page report? 8 pages?
Yes.
Judge, I'd ask to admit this exhibit and publish to the jury.
Any objection?
No, Judge, we had previously stipulated to this exhibit.
Okay, go ahead. It's admitted.
Well, what the jury's saying now is the initials for NMS, too? Doctor, the initials for the NMS lab is at the top page of this exhibit, true?
True.
Ms. Pavlon's name is on there, true?
True.
And as far as you know, this is the report that was generated by the medical examiner.
This report is generated by NMS Labs and then forwarded to the medical examiner.
What does the labs receive from the medical examiner in order to generate this report?
Well, lack of foundation.
I'll sustain that objection, yes, to that question.
Have you ever submitted samples to the NMS, to the lab in Pennsylvania?
No, I have not.
I'm showing you as marked as, look at page 1. What is the jury saying right in front of them?
So these are the final results of the toxicology testing that was performed on Stephanie Pavlons. So in other words, they may test for a whole menu. It's actually, when you when you submit samples to NMS labs, there are different menus that you can choose as far as what to have tested, and in general, they're pretty broad testing of a number of different substances, and they'll test for all of those different substances, and whatever ends up being positive will get reported inside this black box.
Is there anything significant about what you see on these results from Ms. Pavlons?
Well, typically, when the medical examiner sends samples to NMS labs, it's usually blood or urine. It's not as common to submit liver or muscle tissue, but what has been described is the advanced state of decomposition in this case, where there was not any blood or urine, or oftentimes vitreous, which is the eyeball jelly that can be tested for. Because of the state of decomposition in this case, vitreous was not available, but you can still confirm the presence of substances in other types of tissue, in this case, liver and muscle.
Now, you indicated that Ms. Pavlons was prescribed alprazolam?
Yes.
Based upon your review of her medical records, was it something that she was supposed to take every day?
Yes.
The findings in this exhibit do not have alprazolam listed. Did you note that?
Correct. There's no alprazolam or metabolites of alprazolam. A metabolite is what your body changes one substance into another. All drugs get metabolized, so to speak. And so alprazolam has metabolites that are not present here, nor is alprazolam, the parent molecule, present either.
Would you know that had Ms. Pavlons taken her alprazolam as prescribed, would we have noted a finding for alprazolam in this report?
We should, unless for some reason it was below the level of detection in this tissue.
Was there anything else that you needed to receive from myself, or in this case, to render any kind of opinion?
Can you be more specific?
Do you believe I gave you all the material that you needed to render an opinion in this case?
Yes.
Did you note that on the report?
I did.
I'm going to show you it's marked as exhibit number 442, and again, this is just for the witness. Let me know when you see it.
I see it.
Now, this is a report that you drafted for this case, State of Wisconsin versus Matthew Pahl, true?
True.
And this appears to be the first page of the report?
Yes.
And is this your final draft?
I believe so, yes.
And it's dated August 7, 2025?
Yes.
Page 1 of the report discusses your qualifications, true?
Yes.
Why did you find that significant to list that on this report?
Why do I put qualifications in a report?
Yes, ma'am.
I put qualifications in every report that I generate just to describe my education, background, and experience.
Page 2 of your report, it's labeled methodology?
Yes.
What's the purpose of that?
Well, methodology is how an expert goes about reaching an opinion. And whether it's somebody in a laboratory who describes the technique that they use to analyze something, or fingerprints or DNA, that's the methodology. And what's very important when you're considering a toxicologic cause of death is not to hang your hat on a specific number. And I will tell you that when I tell lawyers this, and honestly, when I tell a lot of other physicians this, it's like telling them that there's no such thing as Santa Claus, because it's hard to believe that impairment, for example, in a driving while intoxicated case, or intoxication, or cause of death is determined by a blood level alone. And this is true if you have blood. This is true even if the person is still living, because, for example, if someone gets into a car crash and they have methamphetamine present, it is not determined that they're impaired based on that level, and that's living blood. So there are only a handful of substances that we check blood levels on in the healthcare settings. There's just a few. Everything else, you have to correlate the post-mortem or the ante-mortem blood levels, which we don't typically get, with peri-mortem circumstances, with how a person may have been looking around the time of their death. And it is not determined by the level in and of itself. So if it's not something that we can determine from blood, you certainly cannot make a determination based on a level that is in liver or muscle tissue.
In the report, you discuss opioid toxicity, and death. You have a page of that discussion. What's that about?
Objection, relevance, Your Honor.
What's relevant, sir? Relevance.
Is in your NMS report there's oxymorphine, true?
Oxymorphone.
So, sustained objection. Can you ask another question? Go ahead, next.
In this case, what were the pertinent details that you considered in rendering an opinion?
Can you repeat that?
What pertinent details did you consider in rendering your opinion?
Well, as I was describing earlier, it is
More
important.
specific, Mr. Galvez. Just a second. Go ahead.
Well, you looked at the pertinent details about Ms. Stephanie Pavlons, true?
True.
And that's what you took into consideration?
Yes.
And what was pertinent about her that you considered?
All right, let's use the jury for a second, okay? All right. repeat everybody. The jury's left. Mr. Galavis, I told you that I would stop without an objection. Your question was, and what was pertinent about her that you considered? The answer to that in the doctor's report is that she considered things that I indicated very clearly in my prior ruling that I would not allow the doctor to testify about. You've been asked, and don't play coy with me, you're asking a far too open-ended question that if she answers truthfully, she's going to get into things that I said she could not testify about. And that's why I asked you to be more specific, Mr. Galavis. If you can't do that, then the response is going to be farewell to Dr. Hale. You need to be more specific in light of my prior ruling on the motions in limine. All right? And you can think about that. We're going to take a break right now for the afternoon, about 10 minutes or so. You can step down, doctor. Thank you. I think we're clear where we're going to go, and we're not going to go beyond that. And if she's reported in a report about the manner of death, and I've indicated that that's not to be testified to. And again, I expect Mr. Galavis to talk to the doctor about that. I'm taking, and I'm listening carefully to the questions. We're going to move forward. And again, if I think that there's going to be an attempt to cross the line, given my prior ruling, I won't wait for an objection. All right? Let's bring the jurors back. All rise for the jury.
Anything significant in the medical records?
Objection, beg.
I'll just say that you have to be more specific, Mr. Galavis.
What?
I'll let you lead on this question, sir.
Thank you, Judge. In her past medical history, there was a discussion on her being treated for seizures, true?
True.
And convulsions, true?
Convulsions are seizures.
There's reports in her medical records about depression?
Yes.
There's reports regarding her opiate dependency, true?
Objection, Your Honor. Prior ruling.
Hang on a minute, doctor. I'll allow it. I'll overrule the objection. Go ahead, doctor. You can answer.
Yes, there were indications in her medical records about opioid dependence, which is why she was prescribed buprenorphine.
Your Honor, my objection is not from the September 12th motion hearing, but from the motions earlier in the year regarding motions in limine.
All right. I'll allow this response. I'll overrule the objection. Continue, Mr. Galavis.
You indicated that you also reviewed her diary, true?
True.
And in her diary, she had comments about suicide, true?
True.
You reviewed the note discovered, or you don't know where it was discovered, but the note that's been testified, the note found in Mr. Pavlons' talk reference to discussing suicide, true?
Objection, Your Honor.
Sustained. Don't answer. Next question.
Did you review the note that was found in Mr. Pahl's talk?
Yes.
Did you consider Ms. Pavlons' physical health?
Yes.
Did you consider her mental health?
Yes.
Dr. Shield ruled cause of death as undetermined.
Is that a question? Objection?
Basis.
I'm not sure if that was a question for the witness or just a statement by Mr. Galavis.
I just finished.
All right. I'll sustain the objection. Next question.
Dr. Shield, well, ultimately you saw the autopsy, Dr. Shield's finding after the autopsy, true?
True.
You also saw the final death certificate with Dr. Shields' finding, true?
True.
Do you agree that Dr. Shields' finding is appropriate under the circumstances?
Yes.
Would you agree based upon, again, you're under the totality of circumstances that there are other possibilities?
Yes.
would you agree that that there's a medical possibility?
Objection vague.
I'll sustain the objection. Next question.
Yes, was in this case a seizure a possibility?
Yes.
In this case, was an overdose a possibility?
Yes.
Do you believe a natural cause of death is a possibility?
Yes.
I have no further questions, Judge.
Cross-examination.
Thank you, Judge. Good afternoon, Doctor. Good afternoon. Thank you for being here. I'm going to start with your work at Parkland. You said it's the busiest ER in the country, right? It is. And you're known for having treated President Kennedy after he was shot. Well, not me personally. I was informed, yes. Parkland. Yes. There you go. All right. And let me ask you a question, Dr. Hale. Have you ever treated a victim of domestic violence in your ER? Oh, yes, many, many times. Many, many times, correct? Very common for a person to present with you to the emergency room with complaints of domestic violence, or now I think they call it intimate partner violence, correct? Correct. And as an emergency room physician, you actually receive training on the dynamics of domestic violence, correct? Yes. Helps you know what to look for, things a victim may say or not say to you, to obtain, for you to obtain good information and provide treatment, correct? Of course. And of course, you want to try and attempt to prevent future acts of domestic violence for the patient, right? Yes. If possible. Yes. Okay. If you ever, you're aware of the fact that a lot of times domestic violence victims will not report their abuse? Yes. That's very, very common, isn't it? Yes. They won't tell even their closest friend or family member, correct? Correct. Oftentimes they won't call the police. Correct. Oftentimes they're very isolated by their abuser, correct? Yes. They can be controlled financially, emotionally, correct? Yes. You can even have a circumstance where the abuser dictates the movement of the victim. In other words, she's not allowed to leave the house without him, correct? Yes. She's not allowed to stay home without him, correct? Sometimes. Okay. And you would agree with me that a person could lose control of their bladder when they're confronted with life and death fear, correct? Sure. They could also lose their bladder when they are strangled, correct? Possibly, yes. In fact, the research shows that even within a short period of time, it's 5 to 10 seconds, a person can lose control of their bladder when they're being strangled, correct? Possibly, yes. Okay. And death can occur, I think the research says something between like 60 seconds to 157 seconds. Does that sound right? I don't know. It depends on so many different circumstances. Sure. But there is research that would support, at least in a strangulation case, death can result in a range of 62 to 157 seconds, correct? Again, I'm not aware of any specific literature on that topic, so I can't speak to that. And yes, it does kind of depend on different circumstances. Sure. Loss of consciousness can occur in 5 to 10 seconds. That sounds right? Yes. And loss of bladder control within about 15 seconds? Possibly, yes. Okay. You agree with me that the research that was published in the Journal of Emergency Science indicated that a prior non-fatal strangulation is a very strong predictor of a future fatal strangulation, correct? I'm not aware of which literature you're referring to. Okay. Have you ever heard of a report that was published, maybe I said the name wrong, the Journal of Emergency Medicine? You've heard of that publication, correct? Yes. And it's a very well-respected journal, correct? Sure. I'd imagine as an emergency room physician, you probably read it frequently. Depending on the topic, sure. Okay. And are you aware that in 2008 they published an article that primary author was a Dr. Nancy Glass, who concluded that prior non-fatal strangulation was associated with greater than 600-time odds of becoming an attempted homicide and over 700-time odds of becoming a completed homicide? No, because I have not memorized medical literature. Okay. You won't dispute that conclusion, though, do you? I don't know how I can possibly dispute a conclusion of an article that I have not reviewed. Okay. I'm asking based on your training and experience. Like, if a person presents to you in the ER and says she was strangled by her intimate partner, that sets off a huge red flag for you, correct? Of course. It's extremely dangerous behavior, correct? Sure. It doesn't take long to kill somebody by strangling them, correct? Correct. Okay. And because of this conclusion, of this finding, it's recommended that doctors, nurses, and other people working in the ER screen victims of domestic violence for non-fatal strangulations, correct? Again, I'm happy to answer your questions in general, but I am not going to answer a question specific to a study that I have not reviewed. Sure. So I'm asking you, in your hospital, do you try and screen victims of domestic violence for prior acts of strangulation? We screen every single patient that presents to our emergency department for domestic violence. Because it's such a dangerous behavior, right? Of course. And it's a huge risk to a person's health and safety, correct? Yes. You agree with me that through your training in domestic violence, you've learned that when a victim gets close to trying to leave his or her abuser, that's the most dangerous time for that person, correct? It can be, yes. And that's why you do safety planning with a victim, right? Yes. And that's something you'd even do at the ER, maybe not you personally, but you may refer a victim to social services or somebody that can help with safety planning if they tell you, I'm in an abusive relationship and I'm trying to get out. Yes, we would consult what's called VIP at Parkland, which stands for Violence Intervention Prevention, and that would be something that we would do in conjunction together. Okay, thank you, Dr. Hale. I wanted to ask you about I want to ask you about the NMS report. I think it was exhibit, let me see for you, 443. Remember when Mr. Delafield displayed that? Yes, okay. And I read on there, and if you want, we can put it back up, but I read on there that there were two sources or sample that were provided to NMS lab, correct?
Yes.
There was liver tissue, correct?
Correct.
And skeletal tissue, I'm sorry, pardon me, muscle tissue, correct?
Yes.
Okay. Of the two, do you know the quality of those samples that were presented to the tox lab?
No, I don't.
Okay. If I told you that Dr. Shield testified the other day that the quality of the liver tissue was extremely compromised and that she was very concerned about it because there was the presence of maggots in the liver and maggot droppings in the liver, and she had grave concerns about cross-contamination. As a toxicologist, does that cause you concern as well, ma'am?
It certainly would affect the levels, which is why I've testified before that you can't rely on levels in a vacuum. However, believe it or not, maggots and other insect casings are frequently also tested in post-mortem toxicology situations because you can find those substances in the insects and their pupal casings, I think is the word. I am not a bug expert or a forensic entomologist. But as far as confirmation of the substance, the fact that we see prescription medications that Ms. Pavlons was taking and confirmed in this tissue, again, I don't care what the actual number is, but it was confirmed. I feel like there was, just because you have insects present doesn't necessarily affect the sample because you can actually test the insects themselves.
Okay. Did you read anything that told you the insects that were collected in this case were tested at NMS?
No, but your question was, should the fact that there are maggots in the liver tissue affect confirmation of the substance? The answer is absolutely not.
No, my question was, are you aware that Dr. Shield said she did not put much faith in the veracity of the toxicology findings from the liver tissue because it had deteriorated and decomposed so much? Were you aware that was Dr. Shield's opinion?
I was, and I actually did see her opinion. And again,
thank you. That's all. Did you do anything, either by contacting Dr. Shield or NMS or what? I'm not sure. My question simply is, did you do anything to try and learn for yourself the quality of the sample that was sent to NMS?
No.
And what about the muscle tissue? Is that a good source? Typically, would you be relying on muscle tissue for toxicology purposes?
You could technically rely on any substance that you're able to test, especially for confirmation. Again, not the levels. I think comparing liver to muscle, liver is better, but of course, blood and vitreous is better than liver and muscle.
Sure. And we didn't have those things either, correct? The vitreous in the blood.
Correct.
Okay. And your testimony, if I understood it on direct examination, is that Ms. Pavlons, you knew from reviewing records, was prescribed a number of medications, correct?
Yes.
And you'd agree with me, Dr. Hale, that looking just at the NMS report, some of these medications don't show up anywhere, correct?
I don't know what you mean.
Some of the medications she prescribed were not found by NMS labs, correct?
Correct.
And you'd only be speculating as to why that may be, correct?
Correct.
Okay. Were you aware of the fact that Matthew Pahl was also prescribed oxycodone?
Yes.
And that Matthew Pahl was also prescribed alprazolam?
Office or obituaries or overseas moves.
It appears that way, yes.
Okay. And finally, the next slide. Detective, ultimately, was Mr. Pahl arrested?
Matthew Pahl to monitor her prescriptions.
Objection calls for hearsay.
See. Next question.
Florida. Between like 60 seconds to 157 seconds. Does that sound right?
I don't know. It depends on so many different circumstances.
Sure. But there is research that would support.
Certainly would affect the levels, which is why I've testified before that you can't.
You asked that if you were aware that Matthew Pahl would take Stephanie Pavlons pills. You remember that question?
Yes.
You remember by reading the police reports and interviews why Stephanie Pavlons wanted Matthew Pahl to monitor her prescriptions.
Objection calls for hearsay.
See. Next question.
I mean, you were aware that Stephanie Pavlons would abuse her prescription medication, true?
Objection.
See. Don't answer. Next question.
So you read her diaries, true?
True.
And you read the police reports, true?
True.
And you read or listened to family interviews, true?
Yes.
And based upon all that information, did you glean anything that Stephanie Pavlons abused her medication?
Objection, Your Honor. This goes to the motion in limine.
Sustain the objection. Next question.
No further questions, Judge. Thank you.
All right, recross.
No, Your Honor, thank you.
All right, thank you very much, Doctor. You are excused. Take care. Next, Mr. Gaudi's or Mr. Wolf.
Your Honor, the next witness will be Emily Pescador, our canine expert.
Okay. Ma'am, come up to the witness stand to my right, and once you get up there, remain standing. That's not her? Come on, witness stand. Thank you, Mr. Wolf. And if you could, once you get up here, raise your right hand and face her.
So, possibly you're about to give us an hour report, shall be the truth, the whole truth, and nothing but the truth, so help you God. Yes.
All right, have a seat, please. Can you tell me your name, please?
Alex Pescador.
Tell me again, spell the first and the last name.
ALEXPESCADOR.
Okay, very good. And go ahead. Okay, let's go.
Thank you. Can you give your name and spell your name for the record?
Did that already. I'm sorry, Your Honor. That's okay.
Ms. Pescador, how are you employed?
I own the DNA Canine, the training company for cadaver dogs.
And what does that company do?
I do consulting and I sell training equipment generally, and I teach seminars for human remains detection or cadaver dogs.
And how long have you been in that business?
Since 2022.
Okay. Where did you go to college?
The University of Southern Mississippi.
And when did you obtain your degree?
This year, 2025, I graduated in May.
Okay, and what was your degree?
I graduated with a Bachelor of Science in Forensic Science with a concentration in Forensic Anthropology and a minor in Biological Sciences.
It's safe to say that a lot of your experience predates your getting your degree, correct?
Yes, that started with dog training in 2008 and cadaver dogs in 2018.
Okay, so let's go back to that. When did you start training dogs?
2008.
Okay, and when did you start training detection type dogs?
2018.
Okay, describe what happened that got you into that.
I met my first mentor, Mr. Don Abney, in Louisiana. He was a retired sheriff's deputy with the St. Tammany Parish Sheriff's Office right outside New Orleans.
Okay, could you spell that parish name for our court reporter?
Sure. St. Tammany's S-T and Tammany T-A-M-M-A-N-Y.
Thank you.
Sheriff's Department.
And I apologize. The gentleman's name is what his last name?
Abney, A-B-N-E-Y.
Perfect, thank you. Okay, go ahead, sir.
So Mr. Abney was also what could be considered a court expert in canine training and human remains detection canines.
Your Honor, I'm going to object and move to strike that last statement by the witness that was not even in response to a question.
All right, I'll strike the last response. Next question.
Okay, what did Mr. Abney train you in?
He trained me in canine training, which included human remains detection, forensic science generally, canine tracking, canine obedience, canine training.
What methods did he use to train you?
Can you clarify that?
Specifically, what methods did he use to train you? How did you learn?
So that included field training with the dogs and under his instruction. The practical application of that, it included what you might consider classroom training and testing. So I was tested in a traditional sense with pen and paper. I had to take tests on that. And then I had to teach him as if he was a student, and I was presenting to him how to do the actual training.
Why were you learning to be simply a dog handler, or was there more to your training?
It was both. It was being a handler as well as an instructor. So the certifications that I obtained from him after a year were as an instructor.
And who issued those certifications?
Mr. Abney.
Was there an organization that gave you certifications?
It was his company, Abcantra.
Okay. And can you tell me how many hours, according to what you observed, how many hours he put in training the dog?
Oh, okay. So generally, the hours that he logged were much higher than what I audited.
Okay. But for example, let's go to February of 2022. Okay, you didn't audit any hours, correct?
Right.
And how many hours did he train the dog in that particular case?
So 8 hours.
Okay. And that was the highest one out of all the months that you reviewed?
Correct.
Okay. What about April of 2022?
Okay, it's just repeating and repeating and repeating. Let's just go on today. On the live one. I mean, my God. Talk about repeat. Wow.
Come on up, ma'am, please. and I'm going to just explain to the witness what's going to happen before she begins to testify.
Okay.
I'm going to be reading the stipulation to the jurors first before Mr. Wolf starts to ask you questions, okay? All rise for the jury. All right, all 14 jurors have returned. Thank you very much, everybody. Please be seated. And ladies and gentlemen, you can be seated, ma'am. Thank you again for your patience. I can assure you that while you were gone, an extent of the 15-minute break that I had intended, we were working on some matters, legal matters. And before Ms. Pescador continues, I am going to read to you a stipulation and agreed facts from the parties. It is hereby stipulated and agreed as follows. Better light over here, that one's up. Number one, that during the search, K9 Raven exhibited 2 changes of behavior. Number two, that in his report, Deputy Willis stated that Detective LaFleur later confirmed the 2 vehicles K9 Raven exhibited changes of behavior on were involved in fatalities. Number three, that Attorney Galaviz became the attorney of record in this case at the beginning of April 2025, that at that time, no one in the Waukesha County Sheriff's Department or the Office of the District Attorney had a comprehensive list of the vehicles that were in the garage on September 19, 2022. Number four, that counsel for the defense made an open records request to the Waukesha County Sheriff's Department. Number five, that counsel for defense received reports related to the vehicles in the garage on September 19, 2022 from the Waukesha County Sheriff's Department. Number six, that counsel prepared a summary which was substantially similar to Exhibit 610. Number seven, that summary was provided to Ms. Pescador. This stipulation and agreement is signed by Mr. Wolf, attorney for Mr. Pahl, Mr. Pahl as well, and Attorney Opper also. So, Mr. Wolf, your redirect examination.
Thank you, Your Honor. Ms. Pescador, you read a portion, I believe, of Deputy Willis's report that said those 2 vehicles were, quote, involved in fatalities, unquote, correct?
Correct. And
so when you received the information from Attorney Galaviz, it was basically your understanding was a summary of information he had that related to all the vehicles or the inventory of the garage on September 19th, 2022.
correct.
And you were simply looking for, you were trying to determine how many of the vehicles were, I want to use the right words, involved in fatalities.
Correct. I was trying to see how many vehicles were involved in fatalities and matching language from the report that Officer Willis wrote.
And some of there was that additional column that kind of gave a little bit more detail as well, and that was helpful for you to try to understand the environment where this search was conducted.
Correct.
So part of your job, you analyze searches both in training scenarios and real life, correct?
Yes.
And can you give me an example of an evaluation that you've conducted?
Yes, so there's operational proficiency or effectiveness, and then there's forensic reliability. Those are two different types of evaluations that I perform.
Can you give me an example of an operational efficiency evaluation?
Sure. So operational efficiency is more of a field test, and that is to determine how efficient or effective a team, canine team, performs in the field.
For the handler, it can be search planning, being able to read the dog, as I said before, their body language, being able to tell the dog's alert, its changes of behavior, and for the dog's performance, how well it is able to work independently from the handler, that it's not cued by the handler, it's not paying too much attention to the handler's own body language and movements, that it is able to independently work, perform its alerts, and that they work together as a team effectively.
Okay. What about, you said forensic, what kind of evaluation would involve an analysis under forensic reliability?
So that is more of an analysis of process, and it does include an evaluation of training logs, making sure that the team has been performing consistently over time, that the team it's documented that the team has performed that consistent training. That includes discrimination apart from animal remains, so that the dog is not cued by that. It can tell the difference. So in the field test for forensic reliability, we will put out animal remains, which could be animal bones. So as an evaluator, I will keep animal bones. You may find roadkill for that. You could use pork. You can use pork, you could use chicken, and you'll put it out in the field to make sure that the dog isn't cued by that, and it'll go and alert on that. Sometimes they will, and that will be a way to identify a problem. There are many ways that you can test for problems with that. I had given an example yesterday of a dog that will false alert based on the scent cues of previous dogs or handlers. So you're checking for biases and problems with cueing in that regard, as well as a history of consistent training.
Okay. What kind of evaluation did you do in this particular case?
This involved records, and it involved very comprehensive documentation that was kept by Officer Willis in this case that provided a lot of that information that I was able to help perform that assessment for forensic reliability.
Okay. Were there things that were lacking that did not allow you to get to establish forensic reliability?
In his documentation, there was records of his training, and there was lacking of training.
Okay, what about the actual test? What do you think in the test caused into question forensic reliability?
Objection, vague. What test?
During the search in this particular case, what do you feel causes questions as far as the forensic reliability of that search?
All right, he's clarified. I'm not going to rule on the objection.
No.
Right, go ahead, ma'am. You can answer that.
Thank you. There was no documentation of discrimination, training, or testing against animal remains. So that was entered in as an issue, as well as documented cases of false alerts on vehicles and multiple vehicle training.
What about the actual test itself that you saw that would cause concern about its forensic reliability?
May I ask for clarification?
What aspects of Deputy Willis and Raven's search on September 19th, 2022 cause you concern about any forensic reliability?
Burping of the vehicle was one issue because of the potential for introducing human odor cues.
Okay, what else?
Could you please?
Were there any actions by the handler that caused you concern for forensic reliability?
It was his behavior at that critical moment when Raven had turned at the service door, and then he had, the handler had turned around as well at that moment, or approximately within the same frame of time.
Okay, what about the environment? Did the environment cause you concern for forensic reliability?
Yes, it wasn't just what vehicles were present in the building on that day, but it is the history and the use of that building to store vehicles that had been involved in fatal accidents or vehicles that had been involved in serious injuries. So it's an accumulation over time. It's the history of that building.
Okay, so even if certain of those vehicles that were on the list were removed, there could still be some residual.
It's the fact that that vehicle, Mr. Pahl's vehicle, was placed in that building, and if I recall correctly, it had been stored in there for 2 days prior to the search taking place. It had introduced the potential for cross-contamination of odor. The ventilation fans in that building were also noted as being on during that time, which provided airflow and an even greater potential for cross-contamination.
Okay.
So even if that vehicle had been taken out of that building and placed in a parking lot, if a search had been performed, even then it still had that potential for cross-contamination.
Okay. Finally, the issue is raised as far as your compensation, correct?
Correct?
And you are getting paid in this case, correct?
Correct.
And do you get paid for everything you do?
Not everything.
Okay. You could have requested the police reports from Attorney Galaviz, correct?
I suppose so, yes.
And you could have spent hours and hours on those police reports, correct?
Correct.
And why didn't you do that?
I felt that I had enough information based on the scope of what I was looking for.
Okay. Thank you. Nothing further, Your Honor.
Reed Cross?
So just to be clear, this was not a test, right? This was an actual search in the field on September 19th of 2022 by K9 Raven, correct?
Correct.
So anytime you're referencing a test, that's not what this was, right?
Correct.
Okay. And you agree with me that it was a blind search?
Correct.
Okay. And it is incorrect when you just testified that Raven turned at the service door, correct? That's not where she turned.
I said the approximate location and time.
No, you said she turned at the service door. She turned right when she got to the back bumper of that truck, correct? She was passing by the back bumper of the truck.
It was around that area, the same area as the service door, according to the diagram drawn by Officer Willis.
And after that, Investigator Willis started to walk the other direction, consistent with prior trainings, correct?
Could you please rephrase your question?
Yes. After the dog's walking past the car, right? Dog's walking past Mr. Pahl's vehicle in the garage. You agree with that?
Past his vehicle?
Yes, the dog.
I'm sorry.
This is the vehicle. She's walking past the vehicle, right? My table's the vehicle. The dog comes around the side, correct? Dog comes from this way. The table's the car, the truck.
Okay.
Okay? Based on what we heard from Investigator Willis, the dog walks past and then suddenly turns, has a change of behavior, goes to the rear passenger side, and provides a trained formal alert, correct?
Where's the service door in this case? In this?
Tell me.
I'm asking you. You're walking around, but I can't tell where the service door is in your scenario.
This is the truck.
Okay.
This is the direction of travel for Raven. Are you with me?
I'm following.
Okay. Where's the service door?
I'm asking you.
You'd agree with me, Ms. Pescador? There's absolutely nothing in the training records that suggests Raven hits on animal remains, correct?
Well, he didn't write that down. He didn't proof against it.
He didn't write it down. It's in his training records, correct?
No, there's no indication that he ever trained against that. He didn't proof off of it.
You're telling me there's nothing in his training records where he documented there be search training areas and there were animal remains present and the dog did not alert? Are you telling me that's not in his records?
Correct.
Okay. Thank you.
That's it?
Yes.
All right. Thank you very much, ma'am. So I'll finish your excuse.
Oh, okay.
All right?
Thank you.
Sure. All right. Any other witnesses from the defense?
No, Your Honor.
All right. Any rebuttal testimony from the state?
No, Judge.
Okay. So, folks, here's what's going to happen. That means the testimony's over in the case, right? And I am going to talk to the attorneys about jury instructions and how we're going to proceed after this. And what that means, effectively, is that you're going to turn your notebooks over because the testimony's finished to Mike, and then you'll get them back when you deliberate. I'm going to do this. I'm going to have you go back to the jury room now. And I'm going to talk to the lawyers a little bit about timing. And then what's going to happen is you're probably going to get an extended lunch time. And then we're going to come back with jury instructions and final statements. After we have the closing instructions, so we're going to have instructions. I'll read most of them. We'll have closing arguments, and there's very few instructions after that. And then immediately before you start your deliberations, we're going to select the two alternates who will not involve themselves in the deliberations, right? And I can assure you that that's going to be done by random computer assignment, and I have no idea who it's going to be, right? And it will be a very disconcerting experience for the two of you, whoever it's going to be, when you're told, thank you very much, you're excused. And I apologize for that, but again, I think you can understand, I think this is our 8th day here, I think, right? And you understand that during that time period, anything could have happened with anybody. And that's why we have the two alternates, especially in a trial like this that's going to last that long. So my instructions to you now are go back to the jury room, take your notebooks, wait a little bit. I'll talk to the attorneys about timing, and then I'll send word back to Mike, and he'll instruct you when you're to return this afternoon. All right? Anything else from the state before we break?
No, Judge.
All right, anything else from the defense?
No, Your Honor.
Okay, very good. Thank you, folks.
All rise for the verdict.
You got this one?
About your right to testify and your decision to testify or not testify, your right to testify or not testify. I know that as well. The bailiffs brought you in to talk to Mr. I think Galaviz this morning as well, I presume, about that decision also. And do you feel that you've had enough time to talk to your attorneys, sir? Mr. Pahl? About your decision to testify?
I don't know if it was enough time, but...
You want more time? Okay, that's fine. We'll give you more time. We'll take it up later. We'll switch off your microphones and you can talk right now. With Mr. Pahl.
Okay.
I think he should have taken the stand. What is he? I mean, really. I'm not going to listen about the dog handler. Oh, wow. She was the whole day.
You're still talking to your client. I'll give you time later about his decision to testify or not, okay?
Yes, sir.
All right, we're going to continue now. We'll bring the jurors in.
Let me see what's going on in the YouTube world.
Your Honor, you want her on the stand or just here?
Just there. She can come up to the stand. That's fine. All right?
Morning.
Come on, man. And then when the jurors come in, we'll swear you in. Okay? All right. So, sit, wait. Will you stand up?
Thank you.
All rise for the jury.
All right, have a seat, everybody. Thank you very much. All right, all 14 jurors have returned. Good morning, ladies and gentlemen. Thanks for coming back. We are going to continue again with the defense case. Ms. Pescador, if you could stand up and raise your right hand to be sworn in again. Thank you. All right, have a seat, please. And of course, you are still Alex Pescador, correct?
Yes, sir.
Okay, very good. Continue, Mr. Wolf.
Thank you, Your Honor. Ms. Pescador, a couple things that I thought of after you were testifying yesterday. We obviously went over your education and the work that you've done in this area. How old are you?
35.
Okay. And when did you start dog training?
When I was 18.
Okay. Thank you. And I know we're not supposed to ask that, but I think it's important here. The other area I want to touch on before we get into the actual search is you reviewed Deputy Willis's qualifications, correct?
Yes.
And did you look at his certification from the NNDDA?
Yes.
What did you note about his certification?
Could you please be more specific?
Who certified him for NNDDA certification?
He had 2 different evaluators. The first one was Mr. Gumman, and the second one was Miss Corcoran.
Okay, what did you note about the individuals who are providing the certification?
With Miss Corcoran, that was his main trainer.
Okay, and why is that an issue?
It was significant because in the standards under OSAC and what was posted with AAFS, the American Academy of Forensic Sciences, and under SWGDOG as well, it is typically against best practices for someone who is significantly involved in the training of a canine to also be the evaluator for the same canine.
Okay, why is that?
It's a kind of a conflict of interest.
Okay, let's, as part of your Madam Clerk, just for the witness, we're going to pull up Defense Exhibit D12.
612.
I'm sorry, D612.
I can't remember, shown to the witness and the jury? To the jury as well. Okay. So you were sent, again, a rough draft yesterday, and our clerk just sent the parties another draft, right?
Yes.
Yes.
And so let's methodically go through these things. So 100 is the opening instruction, and that's a pretty standard instruction. Is that okay from the state?
Yes.
Defense?
Yes, sir.
115, one defendant, 2 counts.
No objection?
No objection.
Okay. And then 1010, first degree intentional homicide. State?
No objection?
No objection.
Defense, okay. 1194, hiding or burying a corpse. There wasn't any, should we just include the word hiding?
Well, that is a request of the state, Your Honor. In the pattern instruction, there's a, I think it's footnote 3 that refers to State versus Bedker, Bedker.
Yes.
Providing that the dictionary definition of the word to hide is appropriate, and we would request that the court provide that definition after element 1. The defendant hid a corpse. To hide a corpse means to hide or keep in place.
All right, let's, where would that be? So let me ask this first about the term hiding or burying a corpse in the title.
Right, so we definitely agree it should be hiding, not burying.
Okay, so it should be hiding a corpse.
Yes.
Do you agree with that, Mr. Galaviz?
Yes, sir.
Okay, so now, what other language do you want, and where do you want it?
So the state's request, Your Honor, again, I'm looking at the pattern instruction. It's footnote number 2.
Right. Let me look at that.
Okay.
Again, hang on a second. I printed the pattern instruction. I think, I don't remember if I printed the,
Do you have that, Mr. Galvez? Do you have that? Do you want me to email it to you?
Sure. Thank you.
let me just look on the,
Yeah.
does it have the notes on it? No, I don't think so. Or yes. Yeah, okay. All right, tell me which, you're looking at which footnote, ma'am?
2.
2, okay. To put or hide means to put or keep out of sight?
Yes, I would ask that be added to the, after the first sentence of element number 1, it reads the defendant hid a corpse. Then I would ask you add a sentence that says to hide means to put or keep out of sight.
Agree or disagree with that, Mr. Galaviz?
No objection, sir.
Okay. So that would be, again, elements of the crime the state must prove. Number 1, the defendant hid a corpse. To hide means to put or keep out of sight.
That's our request, Your Honor.
Okay, with that and the modification of the title, you approve that, ma'am?
Yes, sir.
And Mr. Galaviz?
Yes, Judge, right under the identification, the title, on that first line, it says hide or buries a corpse.
Okay. So it should be violated by one who hides a corpse, right?
Correct.
We'll take out the word or buries.
Yes, sir.
You're correct, okay. All right, but otherwise, that seems to be approved by the parties. You agree with that, Ms. Opper?
Yes.
Okay. 140, burden of proof and presumption of innocence. That's a standard instruction. Ms. Opper?
No objection?
Mr. Galaviz?
No objection, Judge, thank you.
All right. 145, information, not evidence. State?
No objection?
Defense?
No objection.
103, evidence defined. State?
No objection?
Defense?
No objection.
Agreed fact. Now, there's a number of agreed facts in this case. Some I read at the beginning, some I just read. My recollection is that there are two sets of agreed facts, I believe. And let's just, for clarification, actually there's two sets of agreed facts. One is about the weather and the rain, and this last one is about the canine search, the building, and so on. Do you agree that there's two sets, Ms. Opper?
I do.
And Mr. Galaviz?
Yes, sir.
And so I should read again each of those sets of agreed upon facts. Do you agree, Ms. Opper?
Yes.
And Mr. Galaviz?
Yes, sir.
Okay. So here's the other thing. The instruction is incorrect. And because it says the district attorney and the attorney for the defendant, that's partially true. The district attorney and the defense, because it involves Mr. Pahl as well, right? Ms. Opper?
We're agreeable with that change, Your Honor?
Mr. Galaviz?
Yes, sir.
So it should read, the district attorney and the defense have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defense have stipulated to the following facts, and then I would read the facts, correct?
Yes.
All right. You agree with that, Mr. Galaviz?
Yes, sir.
Now, judicially noticed facts, there are not any in this case, correct?
Agree. We should
State?
remove that one.
Defense?
Yes, sir.
That's to be removed, okay. Circumstantial evidence. There's parenthetical language that talks about if evidence of flight, escape, or concealment has been admitted, see Wisconsin Jury Instruction 172. So that language, obviously, we're looking at page 6 of 15. That would be excluded on that page, correct?
Yes,
So-
all caps, yes.
Right, so the circumstantial evidence language for 170 would be the 1, 2, 3 paragraphs. Do you agree with that, Ms. Opper?
Yes, Your Honor?
Mr. Galaviz?
Yes, sir.
And now the question is 172, flight, escape, or concealment. So evidence has been presented relating to the defendant's conduct after the alleged crime was committed or after the defendant was accused of the crime, whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Ms. Opper?
Well,
Should we give that instruction?
we would request that instruction. There has been at least circumstantial evidence of flight. However, I don't feel strongly about it. If the defense objects to it, I would not have a problem removing it.
I would object.
You don't want that?
Correct.
All right, so if the defense doesn't want it, ma'am?
Then we can take it out, Your Honor. Thank you.
172 is out by agreement of the parties, okay. 275, cautionary instruction, evidence of other acts or conduct of the defendant. Is the well, there was other evidence of other acts, including acts of domestic violence, specifically, I think. What do you believe we should do with that instruction, Ms. Opper?
We did submit a proposed instruction 275 way back when. I don't know the document number, Your Honor, but it was filed on September 25 of 2025.
I think that this incorporates the language that you submitted.
Okay.
That let me just look. Which document is it in the file, ma'am?
Again, I'm sorry I can't see document numbers, but it was filed on September
right.
25 of 2025.
Let me take a look.
It's document 177.
Thank you, Mr. Galloway.
Yes,
Appreciate
sir.
that. All right, this is, we incorporated the instruction that the state submitted, right? So, but you also left, when you submitted that instruction, it says in the second paragraph, specifically, evidence has been presented that the defendant, and there's parentheses, described conduct. What do you believe should be put in there?
As a starting point, I would suggest the defendant committed acts of domestic violence in the past or towards Ms. Pavlons.
So you would say specifically the evidence has been presented that the defendant committed
Acts of domestic violence towards Ms. Pavlons.
or against Ms. Pavlons?
Or against Ms. Pavlons in the past.
Mr. Galaviz?
I'm not sure on this one, Judge. I think we should maybe pinpoint in the past as being 2020?
Or prior to 2020, prior to August 23rd of 2022?
No.
I think the record would reflect 2020 and 2021.
No objection to that.
So it should say committed acts of domestic violence against Ms. Pavlons in 2020 and 2021? That's
Yes.
what you asked me to do?
Yes, sir.
Okay. You agree with that, Ms. Opper?
Yes.
Stephanie Pavlons. We'll say Stephanie Pavlons instead of Ms. Pavlons. Okay?
Good idea.
And then, so the title of the instruction is, I don't like it, right? Should I just say cautionary instruction? Because that's what it is. It says, okay, they've presented these things and you can look at it for these reasons, and it defines or delineates the reasons why. Or what do you want the title to say, Ms. Opper?
I don't think we have any position on that, Your Honor. I think you can defer to the defense, and I think...
I could just list the number.
Except that then it's going to look different than the rest, but...
Right.
Judge, I like your idea, cautionary instruction, and leave it at that.
You okay with that, Ms. Opper?
Yes.
Okay, that's what it's going to read. And I think because that's what it does. It says, hey, this was presented, but caution. And so what about the rest of the instruction that you submitted then, Ms. Opper? You okay with that?
Yes.
All right, Mr. Galaviz?
Yes, sir.
Okay. $175 motive.
I don't think this is necessary because it's already covered in 1010, Your Honor.
All right.
That exact language is in 1010.
I agree.
All right, we'll take 175 out. 180, statements of defendant.
Agreeable to the state, Your Honor?
Yes, sir.
Okay. 270, evidence as to defendant's character. I don't think we really had, I mean, any kind of instruction about his character really was we have other acts, but not character evidence in this case. What's the state's position?
I agree with the court. I think it should be removed.
Yes, sir.
Okay, it's removed. 157, remarks of counsel, pretty standard state.
Agreed?
Defense?
No objection.
154, summary of evidence, state.
Don't think we need it, but if they request it, we'll not object.
I mean, that's what 202 was, right?
Yes, sir.
Yes, but yes.
Right.
It is a summary exhibit.
You want it in?
I'm not requesting 154, Your Honor.
Defense?
If the state doesn't want it in, I don't want it in.
Okay, all right. All right. 155 exhibits, pretty standard state.
Agreed?
Yes,
Defense?
sir.
148 objections of counsel, state. Again, it's standard state.
Yes, agreed?
Evidence or defense?
Yes, sir.
Okay. 147 improper questions, standard state.
Agreed?
Defense?
Yes, sir.
150 stricken testimony, state.
Agree?
What was stricken?
Something later.
I struck something,
Yeah, Dr. Hale's testimony, I think he struck.
a very small portion, a
Yes.
sentence perhaps.
Yes.
So you want that, ma'am? State?
Yes.
Defense?
Yes, sir.
Okay. Weight of evidence, standard state.
Yes.
Defense?
Yes, sir.
195 jurors' knowledge, standard state.
Yes.
Defense?
Yes, sir.
Credibility of witnesses, the main portion, state.
Agreed?
Defense?
Yes, sir.
Now, 315. Give me 1 second. This is to be given only if requested by defendant. Defendant elects not to testify. State, I don't care.
Right.
Defense?
I want it in, Judge.
Okay. So it will read as indicated. The title will remain the same. Defendant elects not to testify. A defendant in a criminal case has the absolute constitutional right not to testify. And the defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. That's what you want. That's the form instruction, correct?
Yes, sir.
Okay, very good. 317, witness exercising privilege against self-incrimination. That's not applicable, state.
I agree. Take it out, please.
Defense?
Agree.
Okay. 317 is out. So, 200. It's titled Expert Opinion Testimony General. And that is, the concern I always have is that there's a Daubert hearing. The court is the gatekeeper as to whether or not somebody is able to testify and whether or not a person is an expert and whether their word is to be taken, whether it be Dr. Heil or whether it be the medical examiner or the entomologist or the forensic anthropologist, that whether they have a specialized knowledge And whether they look at the qualifications, that's up to the jury. I don't want to put the label that the entomologist or the medical examiner is an expert. That's up to the jurors. So I usually keep the title as opinion testimony. That's it. State agree with that?
We do.
Defense?
Yes, sir.
Okay. And then otherwise, is 200 okay from the state?
Yes, I would request the bracketed language about if
In
there's
resolving
conflicts.
conflicts?
Yes.
All right. You agree with that, defense?
Yes, sir.
Okay, that will, I think that's a good idea in this case. Because we have opposing opinions from about cause, and we have opposing opinions about the dog handling and so on, right?
Yes.
And then 201, opinion of a non-expert witness.
State is not requesting that one, Your Honor.
Defense?
I agree.
Okay. I mean, there were some statements by law enforcement officers about what would usually happen in a law enforcement scenario and so on, but state's not requesting, defense is not requesting?
Your Honor, we're not asking for.
Okay, 201 is out then.
Correct.
All right, 205, opinion testimony, hypothetical questions. Again, I would take the term expert out of the title, but I think it's appropriate. State?
I agree with the court.
Defense?
No objection.
Okay. 312 is not an issue here.
No longer.
.320, impeachment of the defendant by prior inconsistent statements which are not admissible in the state's case in chief. Not an issue here. State?
Agree.
Defense?
Agree.
Okay, so 320 is out. 325, impeachment of witness, prior conviction or juvenile adjudication. Not an issue here.
Agree.
Agree.
That's out then. Impeachment of defendant as a witness, prior conviction or juvenile adjudication. 327, not an issue here. State?
Agree.
Agree.
160, closing arguments of counsel. That's a standard instruction. State?
No objection.
Defense?
Agree.
And then 465, closing instruction, optional short form. I like the short form. State?
Agree, but maybe you don't have to read optional short
Oh, that
form.
will be taken out.
Okay.
Yes. Defense? Okay. With that modification, Mr. Galaviz?
Perfect.
Okay. So 484, verdicts submitted for one defendant, 2 counts.
My computer.
484, state,
No objection to 484.
defense,
Your Honor, just in mine, at least what I'm looking at,
yes?
it says in one reading, we, the jury, find the defendant guilty, and where it says intentional homicide, there's 3 H's. Is that?
What?
I don't see that.
I don't see that.
Yeah, see, 3 H's. Then it's just my computer, Your Honor. I have.
No, that is not on mine.
All right.
Must be a glitch in my computer, Your Honor.
That's a glitch, and we have to look out for glitches in the system.
Yes, in the matrix.
All right, that's just yours. Okay, so otherwise, are you okay, Mr. Galaviz, you okay with that?
Yes, sir.
Okay. 515, unanimous verdict and selection of presiding juror. State?
No objection.
Defense?
No objection, Judge.
And 247 doesn't apply. State?
Agreed.
Defense?
Agreed.
Okay, any other instructions that the state wants to add?
Nothing further, Judge. Thank you.
Or any change in verbiage?
No, sir. We're
Right.
satisfied with these proposed instructions.
Mr. Galavis, same questions to you, sir.
No change, Judge.
Okay.
I've been listening the whole time.
Just to confirm, when we look at the cautionary instruction 275, it says specifically evidence has been presented that the defendant committed acts of domestic violence against Stephanie Pavlons in 2020 and 2021. Were there any indications in any of the communications from 2022 that it happened prior to August?
No.
Prior to August of 2022?
Of 2023.
No, 2.
2022, excuse me.
There wasn't anything in our...
There were no communications located prior to August of 2022.
Okay, all right, so it's just going to... Okay. Okay, so if you look at the proposed instruction that we received from the state, it says if you find that this conduct did occur, you should consider it only on the issues of, and here are the important words, motive, intent, preparation or plan, absence of mistake or accident, context or background. And then that which was submitted by the defense, or excuse me, the state says motive, and it gives an explanation about that. And next it says opportunity, but that wasn't listed in the original criteria.
In the original, from our motions?
From your submitted instruction. From the state's submitted instruction.
You understand what I'm saying now?
Yes, Judge.
Okay.
Judge, I think we can take opportunity out. I don't think there's really a dispute about the opportunity.
You agree with that, Mr. Galavis?
Yes, sir.
All right, we'll do that then. So we got motive, intent.
I'm here. I'm just listening. I want to know how to do a jury instruction. Shall I ever be called in for, be a judge? Anyways, don't forget to like, share, and comment. I rely on the shares. And don't forget to subscribe. I guess not like, but subscribe and like the video.
Preparation or plan, absence, absence of mistake or accident, and context or background. All right, then that's consistent with what was submitted. All right, and again, both of you agree to that, right?
Yes, sir.
Okay. The verdict forms, Kenzie's going to prepare them, and we'll make copies available to everybody. Okay, they seem to be appropriate. So let's do this. Mackenzie will have these done in short order, a couple minutes, right, Mackenzie? Just a minute or two. They appear to be the final instructions. So before you leave at noon, I want everybody to come back at 1 o'clock for the final okay for the instructions, okay? Now, my intent would be to read up to 160, the closing arguments of counsel, and let the attorneys give their closing arguments, right? Who's going to give the closing argument for the state?
I am, Judge.
Okay, and defense?
I am, Your Honor.
Okay, all right, very good.
So absent getting copies of the proposed final instructions, anything else from the state at this juncture?
No, Judge.
Defense?
No, sir.
Okay, so sit tight, we'll give you those instructions in a minute or two.
Wow, they're going to have a really long lunch.
Question for the attorneys. When we read the stipulated and agreed upon facts, should we copy them from the documents we have and put them in the instructions, or take the stipulate, which that's probably the better way, or take the documents themselves and give them to the jurors with their instructions? Ms. Hoffman.
I think it's easier for them to understand if it's actually copied and pasted into the jury instruction, Your Honor.
Mr. Galaviz?
I don't have any objection either way.
Okay, well, I think it's better for us to copy and paste them into the instructions. Okay.
Yes, sir.
But it'll take us a couple minutes to get them to you folks, all right?
Okay, do you need Word documents for those, Mackenzie?
I have both.
Okay.
My practice is, of course, to provide the jurors with the paper copies of the instructions in the folder that I give them.
Okay.
Yeah, my hands are free. It starts out warm and then it's cold.
Okay, another thing, folks. When I read the original agreed facts about the weather, I said, in this case, the district attorney and the defendant's attorney, as opposed to the district attorney and the defense. Again, that's, and on the record, I told everybody that it was the agreement, I think, of Mr. Pahl with the defense. So when we read it to the jurors, it's going to indicate the district attorney and the defense. Okay?
Yes, sir.
Okay, very good.
Yes.
So I guess they're going to be gone till 12 o'clock now. Or I mean 1 o'clock. Oh boy, what do we do? I guess we go to paroles. And then I got Stephanie's picture up there. Oops.
incarcerated. I've really had the privilege of getting to know him during this period of incarceration. I do also want to emphasize that I was in touch with Agent Gerard throughout the course of these proceedings, and he emphasized to me, as well as the officer who conducted the preliminary hearing, that he really has had a good, sustained relationship with Mr. Lewis, who also approaches his relationship with Agent Gerard with a great deal of respect. He emphasized that Mr. Lewis does stay in touch via the phone, comes to meetings.
Let's check it out.
You're taking a look over the city of Cleveland, Ohio at this hour, and our next story takes us about 30 minutes south to a suburb of Akron. That's where a mass shooting is under investigation. The police chief in Bath Township telling me at least 9 people have been wounded in an attack that happened early this morning at a short-term rental property where a party had been advertised all over social media. I do want to bring in Bath Township Police Chief Vito Sinopoli joining us here to discuss. Thank you so much, Chief. I know you've had a very busy several hours, so we definitely appreciate you being here with us.
Certainly.
And first off, I did want to ask you, can you break down, as this is an active investigation, what information you can tell us so far about exactly what happened?
Well, our community unfortunately experienced a tragic and senseless act of violence at about midnight this morning, November 2nd. We received calls in our communications center about multiple shootings within a resident in the 900 block of Top of the Hill Drive in Bath Township. When responding officers arrived on scene, it was a very chaotic scene with multiple juveniles and adults fleeing from the residence, and our officers also observed a number of people who sustained gunshot wounds. We did have assistance from other area departments, the Akron Police Department, Copley Police Department, Fairlawn, Ridgefield Village, all of whom helped us immensely with this rather large crime scene. And at this point, the individuals responsible for the shooting are still at large.
Do you have any information you can provide at this point about the shooter or shooters involved in all of this?
Well, again, it's a very dynamic scene, and we're still interviewing witnesses to determine whether it was one or more individuals who were involved in the shooting, but we did confirm multiple shell casings at the residence, which would indicate potentially that there were others and it was not just one individual.
What about the victims themselves? Do we know how old they are in age range? Are they all juveniles? How they're doing? Anything of that nature just yet?
We don't know that information as of yet. We know that
Welcome back here on Live Now from Fox, and I do want to get you out to some breaking news that we are following involving the elections today as we cover everything related to those elections. You can see right now, according to Fox and Friends, that is Mark Meredith there saying bomb threats have forced the closures at New Jersey polling places. Again, that is according to Mark Meredith with Fox News, and there are 2 bomb threats that have reportedly been received.
Wrong one. I wonder what's going on, y'all. Yo, what in the world is going on out there? What is going on? Was that the plane that was supposedly had the you know what on it? I don't know what's going on. They're even calling them into the polling places. Just wow. Nothing else better to do? I'm trying to figure out what's going on, but of course I can never find anything. I'm eating some lunch. I'm hungry. I'm going to be tired before I even get to therapy. Well, they ain't doing nothing over here. No sound, nothing. So oh, wrong one. Durr.
Every morning when I wake up, I lose her again. Every day, she is still not here, and the heartache starts over. It's never ending pain. It's been 4 years and several months, days, hours, minutes, and seconds since I've been able to hear her voice, hold her, or have a conversation with her. Alexis was only 17 with her whole life ahead of her. Mr. Thomas took everything concerning Alexis away from us. The month of April has become a traumatic and triggering season for me. Alexis was born in April. The crash happened in April. We took her off life support and she died in April. And we buried her in April. This year, even in May, was especially painful for me. It would have been her college graduation. It made my baby Alexis should have been walking across the stage receiving her degree. To know Christopher is up for parole and that he could be traveling on the roads again gives me great anxiety. So much so that when I'm traveling, I have the overwhelming feeling that a car or truck is going to run into me. My heart starts beating fast, I flinch or jump easily. However, I can't fight my passengers even though I'm scared as hell. I work hard to keep my thoughts and my fears in check. The depression and anxiety are tremendous. I wouldn't wish this on anyone. This is what Christopher has done to me. On April 3rd, 2021, I asked Alexis' coach if we could do a flag video on the football field in Saturday the following Tuesday. We didn't know that at the time that would be the day we take her off life support and donate her organs. That day was the true start of pain that would never go away. We still held the prayer vigil and balloon release. So many of Alexis' classmates, teachers were struggling with the loss almost as much as her family and close friends. We tried to be strong and comfort each other and keep moving through the shock of our grief. At the balloon release, while Alexis' volleyball team was taking a picture, I lost my balance and tore the ligament in my right thumb. It has never properly healed even after surgery. Not only did I end up being out of work from April 5th until July 26th, with way too much time to think about missing Alexis, but now I have another reminder of this horrible time. If Christopher had not been drinking and caused the death of my child, I would not have been on that football field to remember Alexis or help comfort her friends. I would not have to have surgery on my hand. I would not have to talk to a picture or a headphone when I want to talk to Alexis. I wouldn't feel like I'm about to lose my mind with grief or have emotional breakdowns when I'm alone. I would not have this horrible pain in my heart all the time. We would not be here today, but here we are. If Christopher had been driving the speed, he would not have hit Alexis. The crash report clearly states that he doesn't deserve to be free just yet. My child is dead, and I truly feel he has not served enough time to say he has been rehabilitated and free to drive the streets of any community. There has been no evidence of true remorse or rehabilitation, and without those, he will do this again. With parole, Crystal will get he will get to start a new chapter while I'm stuck in the old chapter. It's not fair. We are still dealing with her death. Her father had not dealt with the loss of his baby girl. Their bond was amazing. The pain is so unreal. During the court proceedings, Christopher Thomas' attorney asked if he paid restitution upfront, could he do just 3 years? I said no, because it was not about the money. Look at it, he's done just 3 years. That was his attorney victimizing me. Justice is not for Alexis, it's for the offender. The offender gets justice, not Alexis or her family. Christopher has devastated me, my family, and our friends. I will never be the same person that I was before April 30, 2021. My family will never be the same. I feel lost without my child, Alexis. We are incomplete without her. I hate that he has done this to me and my family. I wake up looking at my home cameras expecting her to drive up. But to see my sister still carrying this pain in their hearts all the time, it hurts me more. I walk around with a smile on my face, but inside I'm numb, I'm angry, I'm extremely sad all the time. One of the hardest things about living life since Alexis was ill is watching her friends get older and doing all the things that she never get to do. I hate that he made it all this start over and we love doing life without her. Without true remorse and our demonstration of rehabilitation and repentance next time, it could be one of you who suffers, or maybe it's you. I know that God has the final say in all this. I pray that you make the right decision and God to deny Mr. Thomas parole at this time.
Thank you, Ms. Robinson. We appreciate hearing from you today. So, Mr. Thomas, I was pleased to hear you say early on when you were speaking, at the end when you were speaking, you acknowledged that it was a choice that you made, not a mistake. And that speaks volumes to me. When did you said going to prison is what made you realize you had a problem. At what point in your sentence, period of incarceration, did you come to realize that?
Definitely after a couple years. It wasn't immediate. It was, even after doing some of the classes I've done at Steve Oil, I was still honestly in denial about all of it. You know, it took me a while and a lot of reading and speaking out to other people for me to really accept it. So to answer your question, I would say a little over 2 years after being incarcerated, I was able. And
how long in the Steve Oil program?
I did the 6 month. I wanted to do the 9 month, but I didn't have a choice in the matter.
Right.
So they put me in the 6 month, and I almost earned all the good time there, but 90 days. And then they shipped me to Union Parish from there, which is like a work release facility. And from there, when they screened me for work release, I asked them that, or I mentioned to them that I wanted the rest of my good time, if there was a place they could send me for that. And that after about 6 months of being trustee at Union Parish, they sent me to ECI, and I've been trustee here since. And here I was able to earn the rest of my good time.
Right. You took 100 hours in parenting?
No, well, I did parenting at Steve Oil. That was a reentry class.
So what programs did you do there? DCI?
DCI, I did the reentry. I did the forklift class. I'm also trying to do the OSHA class. I want to be certified OSHA, for OSHA. I've also been in the AA and NA meetings. But as far as the classes, I mostly did them. I did most of the classes at Steve Oil. the ones that DCI offers. I basically already did Steve Hoyle.
So you mentioned you wanted your good time classes, and you did get a year of credit, about a year, I think. And so you have a good time date, which is about 8 months away, I think, in June of next year. I need you to know there is, of course, the opposition we heard today from the victims, and we also have a whole numerous letters from other family members, sisters, aunts, friends, teachers, grandparents, an entire community protesting an early release for you. There's opposition from the District Attorney's Office in East Baton Rouge Parish, Sheriff's Office in East Baton Rouge Parish, the Chief of Police in East Baton Rouge Parish, as well as the Attorney General's Office, to an early release for you. The district attorney believes that you need to stay until your good time date. I tend to agree. I'm not, I know you worked hard for the good time. I'm glad you got something out, and I'm glad you have come to the realization that you're going to have to work on this for the rest of your life. You can't fall. You know what you have to do. I don't have any other questions. Any questions?
No questions.
No questions. All right. So, Mr. Thomas, I'm prepared to vote. I agree with the district attorney. I think you're very fortunate that you have a good time date, a mandatory release date that's coming up soon. My vote today is going to be to deny your parole based on that and the opposition we've heard from today.
Concur with Ms. Renata for the same reasons.
And Mr. Frazier.
I concur also, but I want you to keep going to AA and keep working on yourself because, you are getting out next year. So you need to be prepared.
Good luck to you, sir.
Thank you.
Okay.
All right, Mr. Alaman? You're on mute.
Good morning.
Well, it's afternoon.
Oh, wow. Good afternoon.
Would you introduce yourself? Tell us your name and DOC number, please.
Randolph Allen. 444-227.
Sir, and thank you. You have counsel there with you today. Sir, would you introduce yourself for the record?
Good afternoon. Nelson Cantrell on behalf of Randolph Allen. Thank you.
Thank you. And we have Mr. Alaman, we have your brother Kenneth, who's on Zoom with, and he'll be speaking shortly. And also here in our position, we have a representative of the District Attorney's Office in Jefferson Parish, and he's asked to have some comments also. So I'm going to just read some identifying information into the record, ask you to verify that it's accurate, and then I'm going to turn it over to Mr. Barra, seated to my left. Your case has been assigned to him. So, Mr. Alaman, you are classified as a second felony offender. You're currently serving a 23-year, 6-month sentence. You were sentenced in Jefferson Parish, February 2003, 2 counts aggravated incest. You were afforded probation. That was revoked in 2006 for a new felony conviction. You were sentenced in Jefferson Parish again in August of 2006 for sexual battery, and then as a habitual offender for aggravated incest. Your parole eligibility date is June the 7th, 2026, and you have a good time date, September 10, 2027. Is all that accurate?
Yes, ma'am.
All right. Mr. Barra.
All right, Mr. Allen, would you tell us what you did to get yourself in trouble and why do you feel now is a good time to be released?
Yes, sir, I can. What I done was troubling that I should have never done. Sexual battery on juvenile was definitely not the right thing. That was terrible to my family. I hurt them extremely bad. I'm sincerely sorry I've done those things. It was a selfish thing to do. And it was terrible. I mean, just very terrible thing to do to my family. And I'm very sorry that I've done those things. I want to say those thoughts that will never be in my desire ever again. I will never do that ever again. So I did take classes on sexual offense, on the risk factors, like justifiable blame, and grooming and stuff like that. I'm doing a lot better as an inmate. I work for maintenance department over here. I have a job of 14 years over working in the tool shed. About 8 of it I was a yard orderly, and about 6 of it was maintenance. I had the same job for 14 years, and I appreciate this opportunity for this parole date. I really do appreciate it. And tell you another thing too. I want to say I want to thank the DA for arresting me and for pressing the charge and stopping me, because I had a serious problem out there in the world, and I'm over that now. I took these credits. I understand how I hurt my family, and I'm never ever going to do anything like that again. Thank you. for allowing me to speak.
All right, I see that the record shows that you committed this crime while you were on supervision for another crime. What was the other crime that you were on supervision for when you committed this one?
Sexual battery or I think it was sexual battery or aggravated incest, either one. I don't remember, I really don't remember, so.
Okay.
No, I think it was aggravated incest from my nephew.
All right. What would you consider the best class that you did that you learned the most from?
Sexual battery and living in balance, because living in balance it taught me how to control my emotions and not altering don't let anything at all alter my mind. And the sexual violence, it taught me how it hurt my family. It was a domino effect when it came to the people I hurt. That I hurt too many people. My sister, my mother, my father, my wife, my 2 kids. It taught me. I realized going through these classes that. The pain that I put my family through was not worth it. I should have never done something like that.
Thank you. I see we have somebody in support and we have an attorney that would like to speak. So let's move on to Mr. Kenneth Alamo, your brother.
He's not making somebody.
Go to the attorney and come back. All right, Mr. Kenneth is not available right now. We'll go to Mr. Nelson, attorney, and let him speak.
Okay, thank you. And let me just say that Mr. Alamo was born on November 7th, 1962. And this Friday, November 7th, 2025, he will be 63 years of age. Mr. Alamo was arrested on December 11th, 2005, and has been in the custody of the state of Louisiana continuously since that date. So in approximately 1 month from today, Mr. Alamo will have spent an uninterrupted 20 years in the custody of the state. During these 20 years in the custody of the state, Mr. Alamo has been a model inmate in the Louisiana Department of Corrections and has completed numerous classes and programs successfully in connection with his incarceration. And these are well documented. On March 15th, 2019, Mr. Alamo's wife, Tammy Gilliard Alamo, died after an unexpected and brief illness. Her funeral was on March 3rd, 2019. Despite all of my efforts, I was unable to obtain the permission from the Department of Corrections for Mr. Alamo to attend her funeral. Which brings us to today. If Mr. Alamo is released on parole, he will have to start his life from scratch. He's prepared to do that. He has a good support group, and he has a job waiting for him. Most important to me is that he and his mother will have the opportunity to reconnect with each other. This is invaluable, and this is a priceless proposition. Certainly, that was far from guaranteed at the time of his arrest and during the early days of his incarceration. So thank you very much.
All right, how about, Warden Smith, do you have anything to add about his behavior or?
The only thing I can add is that he has been at DCI since 2009, and he has maintained a job in the maintenance department on the unit he lives. His last write-up was in 2010, so he's really not a disciplinary issue, and he is a member of our Pride program.
All right. Now we'll hear from Mr. Randall Meyer, of the District Attorney's Office.
Good afternoon, Randall Meyer, Assistant DA, Jefferson Parish, and we are adamantly opposed to Mr. Alleman being released. I think all of our jobs is to try to protect the innocent people in the parish and the state, and we have to protect the most vulnerable among us, which are our children. The only way we can assure that they're protected from Mr. Alleman is to keep him in jail until his full-term date. He's had 7 arrests for sex crimes against children. He's had 3 convictions for sex crimes against children and was on probation for a sex crime against a child when he was revoked because he committed another sexual battery and aggravated incest against minors. Looking at his prison record, there is a note indicating that he has taken the sex offender courses. It's my opinion that he's not able to be rehabilitated, and I think his record shows that. His criminal record shows that over the many years. His most recent Static 99 from October of 2025, he's found to be a high-risk sexual offender. For those reasons, we are very strongly opposed to Mr. Alleman being paroled.
Thank you very much, Mr. Myers. All right, we'll go back to Mr. Kenneth Alamo, the offender's brother. I think we got him now. Alamo? All right, it doesn't look like we're able to get hooked up with Mr. Alamo. Do my colleagues have any questions? No questions. If we have no questions, it's time to vote.
Time to vote, Mr. Rock.
And I am the lead voter on this case. Mr. Alamo, I have to vote to deny your parole request today. Just based on your criminal record and how many times you've already committed these crimes, and doing it while you're on supervision, putting you on supervision, I kind of agree with Mr. Myers. The only way to stop you is to keep you where you're at. So that's my vote.
Mr. Freeman?
DA opposition, history of sex offenses and a public safety risk, I deny.
My vote, Mr. Allen, also is to deny for the reasons that have already been stated. So your parole's been denied today, sir. Good luck.
Thank you, ma'am. Thank you.
I guess we'll just sit here until they come back for their closing argument. Fun, fun. I shouldn't have ran through the stream, but my God, they just kept saying the same thing over and over and over. The same text messages, the same. Everything was the same. It's like, my God. So I don't know what to talk about. I don't know if the government shutdowns come to an end or... I only got 6 minutes. I'm tired. So what's everyone doing today? I'm not doing nothing. Barely staying awake. Kind of tired. Yeah. Hang on, I gotta make a phone call. Waiting for them to come back for 1 o'clock. They said 1 o'clock. I'd like them to be ready and on time. Yeah. That's how we roll around here. Ready and on time. Tired, oh.
Well, counsel and Mr. Pahl are present at this time, and we discussed the jury instructions. I gave the parties what hopefully will be the final version of the jury instructions, and I want to review finally what we're going to do in regards to jury instructions. So, Ms. Opper or Ms. Gordon, who's going to have Ms. Opper, you acknowledge receipt of the instructions?
Yes, sir.
All right, and Mr. Galavis, you do as well, sir?
Yes, sir.
Okay, so what I'm going to do is we're going to go to each instruction. I'll give the number, and I'll ask for an okay from each side, or let me know if there's any problems or concerns. So 100, state?
Yes.
Defense?
Yes.
115, state?
Yes.
Defense?
Yes, sir.
1010, state?
Yes.
Defense?
Yes, sir. Wait a second. Is this the paper one you gave us we're looking at?
Good. Okay, I'll take a step back.
What happened to the
You
camera?
ready, Mr. Galavis?
Yes, sir.
You have the paper instructions, right?
Yes, sir.
All right, let's start again, okay? So I think you were probably looking at the ones that were on the screen prior to that. Okay,
Yes,
so 100, state?
Yes.
Defense?
Yes.
115, state?
Yes.
Defense?
Yes.
1010, state?
Yes.
Defense?
Yes.
1194, state?
Yes.
Defense?
Yes.
140, state?
Yes.
Defense?
Yes.
145, state?
Yes.
Defense?
Yes.
103, state?
Yes.
Defense?
Yes.
162, state?
Yes.
Defense?
Yes.
170, state?
Yes.
Defense?
Yes.
275, state?
Yes.
Defense?
Yes.
180, state?
Yes.
Defense?
Yes.
157, state?
Yes.
Defense?
Yes.
155, state?
Yes.
Defense?
Yes.
148, state?
Yes.
Defense?
Yes.
147, state?
Yes.
Defense?
Yes.
150, state?
Yes.
Defense?
Yes.
190, state?
Yes.
Defense?
Yes.
195, state?
Yes.
Defense?
Yes.
300, state?
Yes.
Defense?
Yes.
315, as to the form, state?
Yes.
As to its inclusion and form, defense?
Yes.
All right. 200, state?
Yes.
Defense?
Yes.
205, state?
Yes.
Defense?
Yes.
160, state?
Yes.
Defense?
Yes.
465, state?
Yes.
Defense?
Yes.
484, state?
Yes.
Defense?
Yes.
515, state?
Yes.
Defense?
Yes.
Now, 525 is the final instruction, the short form. We'll give each of you a copy of that as well. But obviously, that won't be read until and unless the jurors return with a verdict on each count. And we'll make a copy of that. Now, what about the verdicts from the state?
The verdicts are agreeable, Your Honor.
1 second. Okay. The original verdicts read dated this blank day of November 4, 2025. So there was an error there. So the ones that I'm going to use, you have the wrong ones, are going to say dated this blank day of November 2025. And then you're going to get a copy of 525 now.
Okay.
So again, the verdicts, instead of saying, putting the number 4 in, are going to be not guilty of first-degree intentional homicide, guilty of first-degree intentional homicide, guilty of hiding a corpse, and not guilty of hiding a corpse, and the presiding juror will fill in the dates, okay? So 525, state.
Agreeable?
Defense?
Yes, sir.
Okay, and the verdict forms again from the state with that change, no allowing the jurors to fill in the date number. You're okay, state?
Yes.
And defense?
Yes, sir.
Okay, very good. Any additions or modifications from the state?
Nothing further, sir. Thank you.
All right. Any additions or modifications to the instructions from the defense?
No, sir.
Okay, then with that, then our intent, as I indicated, I'll read up to the end of 160, and then you'll make your closing arguments, and then we'll select the alternates and send the jurors to deliberate. All right? So we'll wait. I'll see if all jurors are present. We can start early. They're all present. Any reason why we shouldn't start up now?
I don't know if there's more family expected. Is there anybody else?
Probably the bathroom.
Okay. Can you just check the hallway, please, Detective Fredericks?
Other than family
Other than
members
that,
coming in?
yes.
I think it'll be a couple minutes before we get the jurors in here and
Sure.
everything. Anything else? Ms. Gordon, you're doing the closing?
Yes, sir.
And Mr. Wolf, you're doing the closing, right?
Yes, Your Honor.
Anything, Mr. Wolf, before we bring him back?
No, Your Honor.
Okay, let's do it.
Okay, thank you.
How about your computers?
All rise. Okay, have a seat, everybody. Thank you very much. All 14 jurors have returned. Maybe this is the first time I got it right and got you back earlier than I thought, ladies and gentlemen. So, as I said, here's what's going to happen. I am going to read some closing instructions. I'll read the majority of the instructions. The attorneys will make closing statements. There's just a few final instructions after that. And then we're going to select those who will be the alternates. Again, I have no idea who it's going to be. And if you think I'm looking at one of you because I know you're wrong, right? It's going to be a random selection made by the computer, right? And I won't know until Mackenzie passes me that document later on in the course of the proceedings. Everybody please listen carefully. Even so, there may be a need to have one of the alternates return, right? I don't know. We'll see. But you'll get the instructions. You're going to have this book, this 3-ring binder that's going to contain the instructions that I'm going to read to you. And it's also going to have the verdict forms in it as well. If you have any questions, we'll talk about that. But I'll tell you now, if you have questions for us, there are forms in the back in the jury room that you would write the question out. The presiding juror would write the question out, knock on the door, give it to Mike, he'll bring it to us, and you'll get more instructions about that shortly. If you can't hear me, let me know, all right? I don't think that's going to happen, right? So, members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions, regardless of any opinions you may have about what the law is or ought to be. You must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The first count in the information in this case charges that the defendant, Matthew E. Pahl, on or about Tuesday, August 23rd, 2022, in the town of Delafield, Waukesha County, Wisconsin, did cause the death of Stephanie Pavlons with intent to kill that person. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Here's the statutory definition of the crime. First-degree intentional homicide, as defined in 940.01 of the Criminal Code of Wisconsin, is committed by one that causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you, beyond a reasonable doubt, that the following two elements were present. Number one, the defendant caused the death of Stephanie Pavlons. Cause means that the defendant's act was a substantial factor in producing the death. Number two, the defendant acted with the intent to kill Stephanie Pavlons. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Stephanie Pavlons with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. The second count on the information charges that the defendant, Matthew E. Pahl, on or about Tuesday, August 23rd, 2022, in the town of Delafield, Waukesha County, Wisconsin, did hide a corpse with the intent to conceal a crime. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. The statutory definition of the crime. Section 940.11 sub 2 of the Criminal Code of Wisconsin is violated by one who hides a corpse with intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements are present. Number one, the defendant hid a corpse. To hide means to put or keep out of sight. Number two, the defendant hid a corpse with intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find out intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from a fear to return a verdict of guilty is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant while it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt, you are to search for the truth. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. The district attorney and the defense have stipulated or agreed to the existence of certain facts, and you must accept these facts as conclusively proved. In this case, the district attorney and the defense have stipulated to the following facts. In the first stipulation that I read to you, on August 20, 2022, the rainfall in the Waukesha/Pewaukee area was 0.50 inches. On August 25th, 2022, the rainfall in the Waukesha/Pewaukee area was 1.39 inches. On August 28th to 29th, 2022, the rainfall in the Waukesha/Pewaukee area was 0.34 inches. There was no other rainfall in the Waukesha/Pewaukee area between August 15th to September 9th, 2022. In the second stipulation, the parties agreed as follows: that during the search, K-9 Raven exhibited 2 changes of behavior. That in his report, Deputy Willis stated that Detective LaFleur later confirmed the 2 vehicles K-9 Raven exhibited changes of behavior on were involved in fatalities. 3, that Attorney Galaviz became the attorney of record in this case at the beginning of April 2025. That at that time, no one in the Waukesha County Sheriff's Department or the Office of the District Attorney had a comprehensive list of the vehicles that were in the garage on September 19, 2022. Next, that counsel for the defense made an open records request to the Waukesha County Sheriff's Department. Next, that counsel for defense received reports related to the vehicles in the garage on September 19, 2022 from the Waukesha County Sheriff's Department. Next, that counsel prepared a summary which was substantially similar to Exhibit 610. That summary was provided to Ms. Pescador. Circumstantial evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented regarding other conduct of the defendant for which the defendant is not on trial. Specifically, evidence has been presented that the defendant committed acts of domestic violence against Stephanie Pavlons in 2020 and 2021. If you find that this conduct did occur, you should consider it only on the issues of motive, intent, preparation or plan, absence of mistake or accident, context or background. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offenses charged in this case. The evidence was received on the issues of motive, that is, whether the defendant has a reason to desire the result of the offense charged; intent, that is, whether the defendant acted with the state of mind that is required for the offense charged; preparation or plan, that is, whether the other conduct of the defendant was part of a design or scheme that led to the commission of the offense charged; absence of mistake or accident, that is, whether the defendant acted with the state of mind required for the offense charged; context or background, that is, to provide more complete presentation of the evidence relating to the offense charged. You may consider this evidence only for the purposes I have described, giving it the weight you determine it deserves. It is not to be used to conclude that the defendant is a bad person and for that reason is guilty of the offense charged. The state has introduced evidence of statements which it claims were made by the defendant. It is for you to determine how much weight, if any, to give to each statement. In evaluating each statement, you must determine three things: whether the statement was actually made by the defendant. Only so much of a statement as was actually made by a person may be considered as evidence. Whether the statement was accurately restated here at trial. Whether the statement or any part of it ought to be believed. You should consider the facts and circumstances surrounding the making of each statement, along with all the other evidence in determining how much weight, if any, the statement delivers. Remarks of counsel are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find the testimony of one witness is entitled to greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experiences in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. A defendant in a criminal case has the absolute constitutional right not to testify. The defendant's decision not to testify must not be considered by you in any way and must not influence your verdict in any manner. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to be given to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reason given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. In resolving conflicts in opinion testimony, weigh the different opinions against each other. Also, consider the qualifications and credibility of the witnesses and the facts supporting their opinions. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in a hypothetical question have not been proved, then the opinion based on those facts should not be given any weight. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence, under the instructions given you by the court. Ladies and gentlemen, at this juncture, as I indicated, I've read most of the instructions. The attorneys will now give closing statements. The state, because they have the burden of proof, goes first, the defense second, and then the state will have an opportunity for a rebuttal closing if they wish. Ms. Gordon?
Thank you, Judge. Ladies and gentlemen, I want to thank you for your time and your attention. I know it's been a long 7 days, jury selection, and then hearing a lot of tough, difficult evidence. I don't take that for granted, that it's hard for individuals off the street on your normal everyday life to hear some of the evidence that you've heard and seen, some of the photos that you've seen. So I appreciate the time and attention you've given to this case. In the state of Wisconsin versus Matthew Pahl, the state has to prove 2 elements on the charge of first-degree intentional homicide. We have to prove that the defendant caused the death of Stephanie Pavlons, meaning that the defendant's act was a substantial factor in producing her death, and that the defendant acted with the intent to kill Stephanie Pavlons. You heard from the medical examiner. She makes a medical determination. You, as the jurors, make a legal determination. Just because she was not able to determine a medical cause of death does not mean that you, as 12 jurors, cannot reach a conclusion that the state has proven beyond a reasonable doubt that the defendant caused Stephanie Pavlons' death. Because you have the benefit of all the evidence that you heard over the last few days. You heard the text messages, you saw the Skype messages, you saw the phone evidence, you saw the interviews, and you know the history between Mr. Matthew Pahl and his longtime girlfriend, Stephanie Pavlons. You have more evidence here today than Dr. Scheel was able to review. But also, you make an entirely different determination. I don't have to prove as the state that there was a motive or that this act was premeditated. I think in this case there was a motive. I think in this case Mr. Pahl was done with Stephanie Pavlons. But I don't have to prove that, and you don't have to believe that I've proven a motive beyond a reasonable doubt. This is a circumstantial case. You heard all the evidence, and particularly with Detective Schrader, all of the cell phone evidence. That is circumstantial evidence, but that is just as good as direct evidence. For count 2, I have to prove that the defendant hid a corpse, and to hide means to put or keep out of sight, and that the defendant hid a corpse with the intent to conceal a crime. The body must be concealed. It doesn't have to be buried. It doesn't have to be covered up. It just has to be concealed, out of sight. Ms. Pavlons' body was clearly concealed, clearly out of sight, because for 17 days, golfers at the Western Lakes Golf Club did not see her body. For 17 days, employees at OAW came and left every day. Some even ate their lunch on a picnic table looking out towards those woods, and they did not see her body. For 17 days, patients came and went from OAW and did not see her body. And you heard Deputy Frischello say, if that construction worker had not pointed the body out to me, I would not have been able to find it. Those construction workers just happened upon the body. They didn't intend to find the body. They didn't know that that's what they were going to find that day. Those poor construction workers were just trying to do their job, put in some no trespassing signs. But what they came upon was a nightmare. Ms. Pavlons' body was also not visible to the drivers on I-94 or to the drivers on Gulf Road. You had the opportunity to go out there and see the scene yourself. So use your common sense and judgment. That body was concealed. That body was hidden. And the defendant intended for her body to be concealed. He didn't want anyone to find her. He didn't want anyone to know what had happened. Sure, he didn't dig a grave and put her in a grave, but he didn't have to, because in 17 days, her body was so decomposed that Dr. Scheel couldn't determine a cause of death, that the insect activity and the state of decomposition was so great that he left us with very little evidence at the scene. Ladies and gentlemen, the defense asked a lot of questions about Ms. Pavlons' mental health history, her suicide attempts. But ladies and gentlemen, let's be clear, this was not a suicide. This is Stephanie Pavlons on August 18th, her conversations with Mr. Zakos. Want to get together? You could come out to Delafield. We could get some dinner. Look at that picture of her. She looks happy. She looks upbeat. So how do we know this wasn't a suicide? She's making plans for her life. She's making plans with Mr. Zakos, or at least trying to. She's telling her doctor that she wants to work on some problems that she might have with her memory. She wants to do some testing. She's concerned about her health. Someone that's not planning to live doesn't make those plans for their life. And Dr. Russell told you, she was more upbeat when he saw her in May. She was thinking more positively, and she was concerned about her future health problems. She wanted to find ways to make her life better. She was taking care of herself. Mrs. Pavlons told you that Stephanie was looking forward to going to the Philippines. She was excited to get her passport. That was Stephanie's plan. That certainly wasn't Mr. Pahl's plan. He didn't want Stephanie to go with him, but Stephanie was excited about the future. You saw on her cell phone that she had upcoming appointments, both doctor's appointments. She had dentist appointments. You heard from the dental scheduler that said, yeah, I called her a couple of times because she was planning for the future. There are no suicide attempts since March of 2021. Was Stephanie depressed? Yeah, absolutely. You saw those journal entries. Her life was terrible. But who made her life terrible? Mr. Pahl. His violent and abusive actions made her life miserable. He controlled her medications. He controlled her movements. He controlled her finances. He controlled every aspect of her life. She doesn't even have the ability to take her medication when and how it's prescribed. No, Mr. Pahl tells her when she can have her medications. She has to ask him for her own medications. She has no prescriptions with her in the woods. She's found in the woods, no purse, no water bottle, no drug paraphernalia, no prescriptions, nothing. Just a vape and a scalpel outside of the wooded area. The position of her body and the location of her body tell us this was not a suicide. Ms. Pavlons didn't go out there with the intention of ending her life. And finally, that note. The note that's found in Mr. Pahl's car, Exhibit 35. Mr. Pahl, initially in his interview, says, that was just a cry for help. That's what him and his dad thought. But here in court, they characterized that as a suicide note. But ladies and gentlemen, that was no suicide note. That was a breakup note. That was an I'm done with you note. The content is not consistent with a suicide note. And where it's found, think about that. Under the floor car mat, under a piece of foam on the floor of the passenger footwell. If Stephanie is committing suicide on August 23rd, she surely isn't leaving a message for Mr. Pahl under a piece of foam under the floor mat. We also know that this isn't a medical cause of death. You heard from Dr. Russell. How powerful was that testimony? He told you that there was a less than 1% chance that a seizure would cause great bodily harm or even death. He said the only times he could think of a seizure causing a patient's death was if they had the unlucky occasion to be swimming while they had the seizure. Or maybe they were sleeping and they smothered themselves in their bedding. This was not a seizure. You can rule that out. This was not a suicide. So what is this? This was a homicide. Mr. Pahl is covering his tracks from August 23rd all the way until he's arrested on September 18th of 2023. He says to his girlfriend in the Philippines, "We will be ready." On August 19th, we know that there's a conversation between Mr. Pahl and one of his girlfriends in the Philippines, Ms. Sherilyn Valente, saying he's upset that Sherilyn and Stephanie have been talking. He tells her, I'm asking you just to leave her alone. He doesn't want them communicating. And why? Because they don't know that Stephanie's living with him. They don't know that Stephanie and Mr. Pahl have a child in common, Layla. They don't know that Stephanie is not his employee, that it's his girlfriend, his longtime partner. He's hoping for a future in the Philippines with a good, honest girlfriend. What he means by that? Someone that will obey him, do exactly what he tells them, and let him control every aspect of their life. He wants to move on. He wants to be in the Philippines, and that does not include. So on August 23rd, we see Ms. Pavlons leaving the apartment at 8:39 a.m. Ladies and gentlemen, that is the last time Ms. Pavlons is ever seen entering, exiting that apartment. You saw her belongings. You watched that video over and over again. And I know we played it over and over again, but that video is so important because it tells us everything about Stephanie in her last moments of life. What is she wearing? What is she carrying? What does she have with her? On August 23rd, the defendant goes to his OAW appointment and he takes this picture, captured at 9:34. It's pretty curious. Why are you taking a picture in your appointment? But also look at those windows. Those windows were pointed out by the defense a couple of times with a couple of different witnesses. Those windows at the top, you can't see anything out of those. You can't see into the wooded area. And those windows all the way to the other side of the building, there's all kinds of workout equipment. People are being rehabbed, having physical therapy. You can't see out those windows the way the defense wants you to believe. Then between 10:33, when Mr. Pahl's appointment is over, and 10:53 a.m., you saw these records. And these are so important, ladies and gentlemen, because they tell us that Mr. Pahl on the left and Ms. Pavlons on the right, their cell phones are located at or near OAW for that entire time period. 20 minutes, that's plenty of time. That's plenty of time for Mr. Pahl to kill Ms. Pavlons. There's 20 minutes that's unaccounted for. What is Mr. Pahl doing during that time? He says he's driving up and down the road looking for Ms. Pavlons because she's just disappeared. That's not supported by the records. That's not supported by the records, and Ms. Pavlons' device was there too. Then from 10:54 to 11:03, you heard from Detective Schrader that both of those devices returned to the residence. At 11:03, you see Mr. Pahl's truck enter the Willow Park Apartments parking lot. Then, for about 11 minutes, Mr. Pahl is in the parking lot. In his truck? We don't know. There's no cameras that look out that direction, but we know he's not inside yet. At 11:14 a.m., the defendant comes in carrying Ms. Pavlons' pink water bottle. Between 11:14 and 12:19, just over an hour, the defendant is inside of his apartment. You should have noticed that on that last video, Mr. Pahl didn't prop the door open. In fact, on any day, August 23rd or after, he doesn't prop the door open for Ms. Pavlons because he knows she's not coming back. He knows where she is. She's in the woods. She's dead. She's not coming back, so he doesn't need to leave the door open. At 12:19, he exits the apartments. He walks outside towards the parking lot, and from 12:19 to 12:29, he's again outside in that parking lot. We don't know what he's doing. But at 12:29, he comes in. And what is Mr. Pahl carrying? Mr. Pahl is carrying this purse, concealed in a bag. Concealed in a bag so that no one sees him coming in with this distinctive looking purse. Because Ms. Pavlons was last seen walking out. And he's not stupid. He knows there's cameras. You saw him in some of those videos that Attorney Galvez showed you. He's kind of ducking his head, trying to stay out of the camera view when he's letting Stephanie in. He knows he's on camera. He has to conceal that. That is a vital piece of evidence. Ladies and gentlemen, you can see from this, that is absolutely Ms. Pavlons' purse that Mr. Pahl carries in that day. And he even tells law enforcement that he brought the purse back. He just lies about how that happened. Then on August 23rd, that afternoon, he makes 2 calls from Stephanie's phone. 2 calls to her food share card, checking her account. Why make those calls from her phone? According to him and what he tells law enforcement, he hasn't even found the phone yet. But we know that that's him using the phone. Mr. Pahl doesn't have visitors. Mr. Pahl and Ms. Pavlons don't have friends. It's just the 2 of them. And if Ms. Pavlons isn't there to make those calls, it's Mr. Pahl. Sorry. On August 24th, he then makes a call to Pick and Save Pharmacy because he's going to pick up her prescription for alprazolam. He's also prescribed alprazolam, but he wants her alprazolam. Then on August 25th, he says, I'm really worried about somebody in my circle. 2 days have gone by. You saw no evidence that he called 911, said, oh my gosh, my girlfriend's missing. This is concerning. He doesn't call family members. No, he calls the pharmacy and he calls her food share. What is he really worried about? He's really worried that he's going to get caught because he killed Stephanie. He calls the Pick and Save Pharmacy again on the 25th, and then he deletes that call. You should be asking yourselves, if he wasn't doing anything wrong, if Mr. Pahl had nothing to hide, why does he delete the call to Pick and Save Pharmacy? If he was really just picking up her prescription because he was just being a good guy, then why delete the call? That day at 3:17, he picks up her prescription, which, important to note, that bottle's found at his apartment on September 17th. And guess what, ladies and gentlemen? It's empty. Stephanie Pavlons has not once been at that apartment to use her prescription. And yet, the prescription bottle is empty. He says that night to his friends in the Philippines, hoping something bad didn't happen, I'm getting even more worried. Yeah, I bet he's worried. It's been 2 days since Stephanie was last seen alive on camera. He knows she's dead. He knows that he could be in trouble. He even gets Stephanie gets a missed call from her daughter Layla on the 25th. He doesn't answer that Facebook call. He doesn't call Layla back. And again, he doesn't do anything. In fact, on that day, the defense showed you video of him sitting in the lobby, reading in the newspaper, just going about his everyday life. Not the kind of guy that looks really worried about someone in his circle. He's really worried about himself. On August 26th, there's an email with Sherlyn Valente. He says, I think something bad happened here. Don't ask me through text. Over and over, he says, "Don't ask me through text." Something bad happened here. Like you murdered your girlfriend? That would be something bad. He says he woke up with a bad feeling. Yeah, a bad feeling that what he's doing is going to get him caught. His web history, he's searching for obituaries, searching Stephanie's name. Not a single soul in the world, except for Mr. Pahl, knows that Stephanie Pavlons is dead on August 26th. Not law enforcement, not Mr. and Mrs. Pavlons, not Layla Pavlons, Mr. Pahl. This is now 3 days after Stephanie is killed, and these messages about being worried, they just keep coming. Then on August 26th, Stephanie has 3 missed calls from Layla on Facebook. Then Layla calls her phone. She's so worried about her mom. Why aren't you answering the phone? She calls and calls and calls. And we know that 17 minutes later, Mr. Pahl listens to that voicemail. We know that. You can see from this evidence. Is this circumstantial? Absolutely. But it shows that it is Mr. Pahl that listens to that voicemail. Because what happens next? He says, "My niece called, left message. She's in hospital and broke her leg." My God, what next? See, he didn't tell his girlfriends in the Philippines that he had a daughter with Stephanie, because maybe they wouldn't want to be with him. He's creating this fantasy life in the Philippines to escape his real life, his daughter, his longtime girlfriend, and he says Layla is his niece. But then there's all those bring to focus of the police scanner app. See, Mr. Pahl knows that Stephanie's isolated. He knows that she doesn't have any friends. He knows that she doesn't have anyone in her life that's going to be looking for her. Except for maybe Layla, except for maybe Mrs. Pavlons. And Mrs. Pavlons told you they'd go weeks without hearing from her. She's an adult. She's living with her boyfriend. It's not that uncommon. But she eventually comes back. She eventually comes and stays at their house. Mr. Pahl had a choice on August 25th and August 26th. If he was really worried about Stephanie, if she really just walked off the way he said she did, he could have picked up the phone and talked to Layla. He could have said, "Hey, I have mom's phone here. I'm really worried." But that's not what he did. That's not what he did because he killed Stephanie. We also know that on August 26th, for the first time in over a month, or over 2 months, Mr. Matthew Pahl calls his dad Marvin Pahl. This is very suspicious. They haven't talked in a long time. They don't talk regularly, clearly. And then on August 27th, August 28th, they talk. 9/8, 9/9, 9/10, 9/11, 9/12, 9/13, 9/14, 9/15, and 9/17. He's calling his dad almost every day, repeatedly, and he's talking about his conversations with his girlfriends. So on August 27th, he calls his dad, and while he's on the phone with his dad, we know his dad is searching Stephanie Pavlons. Why is Marvin searching for Stephanie Pavlons? That's mighty suspicious. On August 28th, he says, "I can't explain in text." See, if Stephanie's missing, or she killed herself, why can't he explain that in text? Ladies and gentlemen, the reasonable explanation here, he can't explain in text because he doesn't want to leave a trail. He thinks he's covering his trail. He thinks he's being smart about this. He's not texting about certain things. But he didn't know that we would know Stephanie's phone went to OAW and came back. He didn't know that we'd be able to look through her entire phone, find some things that he deleted. He didn't know that we were smarter than him because he thinks he's the smartest guy in the room. Ask yourself why. Then on August 29th, he again searches obituaries, and this time Pavlons. Detective Schrader said he was conservative in how he listed these web histories. That each time he listed a web history, that was because it was a new and unique search, telling you that Mr. Pahl was making a new search for Miss Pavlons on August 29th. Again, no one in the world on August 29th, except for Mr. Pahl, knows that Stephanie Pavlons is deceased. Then this really weird exchange happens on September 4th. He poses as Stephanie. Mr. Pahl uses Stephanie's account to reach out to his girlfriend in the Philippines because they haven't been talking because he's been mad at her. He wants her back, but he's not going to be the one to reach out. So he reaches out through Stephanie's account. He sends her these messages, hey, what's happened with you and Matt? And then suddenly, Matt and Sherlyn start to talk again. On September 7th, he has this conversation. You had more than a year to be friends with Steph. Suddenly you act like a friend. She says, I'm sorry about Steph. She wasn't being a good friend, and to just leave it alone. He's mad. He's pretending to be mad because he doesn't want them to talk. But he knows, Mr. Pahl knows, Sherlyn wasn't talking to Stephanie. She was talking to Matt. And the day before, on September 6th, we know that he drives around the backside of OAW. You saw those really slowed dash cams as he comes around the back, just looking at that little wooded area where he left Miss Pavlons' body. He's looking to see if anyone found her, and on that day he goes to the car wash. He says that's the day he found the note. That's the day he found the purse. But the evidence suggests otherwise. Then on September 9th, he's supposed to go to OAW. He has another appointment, but when he gets there, he is not expecting to see the law enforcement presence that is there. He is so caught off guard. He is so surprised. You saw him on that dash cam. He's in the right lane of travel, and he's like, whoop, nope, not going in there. Definitely not going in there right now. Got to figure this out. Ooh, what should I do? Yeah, I should probably drive all the way down into a subdivision, turn around, get my wits about me. He's probably thinking if I don't go to the appointment, that'll look really suspicious. I'll go there. I'll try and find out what they're doing. I'll try and get an eye on what's going on. He doesn't just make a quick U-turn either. He drives all the way down into that subdivision, all the way to the end, and then turns around. He's panicked. He knows why they're there. He's the only person in the world that knows whose body is laying in those woods. He knows why they're there, he knows what they're doing, and he knows the jig is up. If he's not careful, if he doesn't cover his tracks, if he doesn't act carefully over the next few days, he's going to be in big trouble. So while he's at his appointment, he checks the police scanner. He calls his dad. And when he drives into OAW on September 9th, these are zoomed in stills of that dash camera. Look back into the woods, ladies and gentlemen. You can't see any of those detectives that are working in the area where the body was found. You can't see anything. That body was concealed. Mr. Pahl on September 9th, when he drives in, he can't see what they're doing back there, but he knows. This just proves how concealed that area is. It's concealed in plain sight. It's concealed in a busy area, but everybody's busy. Everybody's focusing on their own day, their appointment, their job, their drive. How many times have you thought, man, I just got to work and I don't remember getting here. Because you're focused on your own day. The people at OAW couldn't see what Matt hid. After his appointment, you heard him on the scanner as he walks out. He's outside of OAW for a little bit before he gets in his car, and then he goes right to his dad's house, where he and his dad talk things over. He doesn't approach the cops. He doesn't say, oh my gosh, I'm so glad you guys are here. I've been so worried about my girlfriend. She walked away from my car here 17 days ago. I had no idea. I have no idea where she is. No. He drove away. He didn't talk to police. He talked to his dad. While he's at his dad's house, look at these web searches. Stephanie Pavlons, missing woman found dead. Does anyone know that Stephanie Pavlons has been found dead on September 9th? Well, Mr. Pahl knows. Maybe Marvin, based on these searches. The police definitely don't know that day. Waukesha police scanner, news happening today in Waukesha. Again, missing woman found dead. Body found by construction worker, dead. These searches, they tell you that Mr. Pahl knew what happened to Stephanie. They tell you that he was the one responsible for what happened to Stephanie. Then on September 9th, you heard testimony that the only other time he used the elevator was when his dad came over to spend the night. They took the elevator up to his apartment on the 3rd floor, and his dad spends the night. Then on September 10th, in the morning, Mr. Pahl reads this article. Dead body found by construction crew in Delafield. And you heard over and over again the testimony that no one knew that this was a woman. On September 10th, we don't even know who the body is. We don't know who the identity of that person is. And then at 8:26 p.m., Mr. Marvin Pahl is searching Stephanie Pavlons. On September 11th, he says he's wondering why all this bad shit. Now is grieving time. What are you grieving? You're grieving Stephanie because you killed her. Who's dead? No one knows that Stephanie's dead. Nobody but Mr. Pahl. He certainly doesn't seem like he's been grieving. He's been chatting daily with both of his girlfriends in the Philippines. He's going about his life. No huge change in pattern for Mr. Pahl. He's just going about his life, taking walks, taking her phone with him when he goes to appointments, random places out in the city of Waukesha. Who knows why he's doing that? But we know Stephanie Pavlons isn't making that phone move. The only reasonable explanation is that Mr. Pahl was taking the phone. Then Mrs. Pavlons calls Stephanie, her mom. Her mom calls her. And Mr. Pahl, her partner of 20 years, doesn't answer the phone and say, hey, Georgianne, I know things are really strained between us, but I'm worried. I haven't heard from her. I haven't seen her. I don't know what's going on with her. Have you seen her? Have you heard from her? No, he doesn't do that. Defense is going to say, well, he's just a bad boyfriend. He's a really bad boyfriend, and you don't have to like him, but, you know, it is what it is. That doesn't mean he killed her. If he didn't kill her, why doesn't he answer the phone? If he didn't kill her, why does he check the voicemail and then go on with his day? He then calls his dad at 6:36 p.m. And that night he says, I had a long talk with Dad. We will be ready. Ready for what? Ready for the police? Ready for the investigation that's going to follow? Ready for the search warrants that will happen? Ready for what? The family called someone and said nobody has seen her. The family. Mrs. Pavlons. because Mrs. Pavlons called her that day. And Matt knows, Mr. Pahl knows, that the only people in her life that are actually going to raise some alarms or might be concerned about her are her mother and her father and her daughter. Then on September 12th, again, web searches for obituaries and funeral services. Now keep in mind, this is the day that Mr. and Mrs. Pavlons learn that their daughter is deceased. They're notified on that day by Detective Fredericks and Detective Plennis. They make the death notification. And on that same day, Mr. Pahl, who has not been notified by law enforcement, is searching for her obituary. Mrs. Pavlon calls again that day. Mr. Pahl still doesn't answer. He deletes the call to the voicemail, and Marvin is checking CCAP and dead body found by construction worker. Dead body found in Delafield. September 14th, if you don't hear from me because something happens, I'll get with you ASAP. In case something bad happens, he says a lot of chatter about this and that, but nothing concrete, not texting anymore. This is a constant theme. He won't put it in text because he knows if he'd put it in text, I'd be reading it here, right here for you in court. He knows that. He's not that stupid. He knows he has to be careful. He can't text it followed by calls. What are they talking about on the calls? We're never going to know that. Then on September 15th, he says, driving back from Dad's, got my banking business done for overseas traveling. Says to the other girlfriend, Sherlyn, did banking business for overseas travel. Then he sends a message from Stephanie's phone to his phone. And this is the only remaining message between Stephanie and Mr. Pahl on her device. Some YouTube link, some article about ATF. I don't know what the significance of that is, but I do know the fact that that's the only remaining message means that Mr. Pahl had been very busy deleting things. And we know he was very busy deleting things because Detective Schrader explained this to you. 380 messages are deleted between March 17th and June 17th. 442 messages deleted between June 17th and August 15th. And 93 messages deleted between August 15th and September 14th. All kinds of things we know were deleted after September 8th because Detective Schrader testified about that snapshot that came up on her phone, that no one would be able to see, right? That he could look through her phone and find. And it had text messages and calls, all of which are deleted. That snapshot's taken on September 8th. So sometime between September 8th and September 17th, Mr. Pahl was deleting things. I don't know when he deleted all these messages. I don't know if he deleted these messages. But I do know that there are no messages between Stephanie and Mr. Pahl. That's pretty curious, given that they're so close. They spend so much time together. Why are all those messages gone? If Miss Pavlons is just missing, if she's just walked off, if she's committed suicide, why is he deleting things? Why is he deleting voicemails? He's covering his tracks. He will be ready. And 66 times he brings to focus the police scanner app on 9/9. Now, ladies and gentlemen, I've talked about all the cell phone evidence now that points to Mr. Pahl being guilty of this, of the state proving beyond a reasonable doubt, circumstantial evidence that Mr. Pahl was the person that caused the death of Stephanie Pavlons. I want to talk to you about that interview. I know that was a lot of days ago, and a lot has happened since then. But let's talk through some of those inconsistencies that he had in his interview. When he's asked about the phone, he gives a few different versions. First, he says, well, I found it when I found the purse, which is on September 6th when he's at the car wash. But then he says, no, she didn't have her phone that day. She left it at the apartment. Because I said, oh, I'll text you when I'm done with my appointment. And she said, oh, I left it at the apartment. See, but he didn't know that we could track her phone. He didn't know when he made that lie to the police that we had tracked her phone to OAW and back. So he got caught in a lie. And what does he do? Oh, well, I thought, maybe her mom picked her up. Well, how could you call her mom? Well, I couldn't call her because, she didn't have her phone because I had her phone. Right. He's trying to cover his tracks. He doesn't know what we know. So during the interview, he's constantly asking law enforcement, well, what do you know? Well, what did you see out there? What was going on in the woods? What were you guys doing yesterday? He's trying to gather information from them so he can weave his story together. And he weaves some truth in with the lies, because he thinks that'll make it more believable. When he's asked about the purse, he says, well, I found it at the car wash. Before he knows he's caught in the lie, he says, yeah, it was the black purse. Yeah, that black purse, sure. Yeah, I brought that in. He's asked, well, how did you bring it in? He's like, well, it would look strange if I just, carried it on my shoulder. But he never answers the question directly. And then, when confronted, he says, oh, that's not the purse. That doesn't prove anything. That doesn't prove anything. Well, Mr. Pahl, it proves a lot of things. It proves that you knew Stephanie wasn't coming back. It proves you had the purse on August 23rd. Why did you have her purse on August 23rd? Then he says, oh, no. It was a different purse that I found on September 6th. It was a gray purse. Okay. The damage was already done. We'd already caught him in a lie. When he's asked about the note, he claims to have also found that at the car wash. And at one point he even says, oh, well, if I had found the note and the purse together, then I would have been really worried. I probably would have done something. About that. Well, he didn't. He didn't do anything about that. He didn't find the purse and the note together at the car wash. You saw that video. He wasn't like, oh my God, a note from Stephanie. I didn't know she left this. No. He takes the mats out. He hangs them up, comes back. He doesn't vacuum the car. He doesn't spray down the mats. He just takes them out and puts them back in. See, because here's where Mr. Pahl's deliberate. He knew there was video. He knew we were watching. He's trying to cover his tracks every day. Bit by bit, he's trying to create a narrative. He doesn't say it's a suicide note that day when he's interviewed. He doesn't say, yeah, I thought Stephanie tried to kill herself based on this note. That's not what he says. And he also doesn't tell law enforcement that it's going to be found under a piece of foam under his car mat. That was weird. He cannot remember the last time that he saw Stephanie. It's more than 20 minutes, maybe even more than 40 minutes into the interview before he finally nails down, well, I think we went mattress shopping the day before. Okay, well, what happened the next day? Mr. Pahl? Yeah, I think I went to OAW. Yeah, I think she went with me, but I don't know. Did you stop anywhere? Yeah, I don't know. Oh, yeah, no, actually, when I came out of my appointment, she was just gone. Ladies and gentlemen, that makes absolutely no sense. He doesn't have a story that fits the evidence. He tried to cover his tracks. He tried to do things that he thought would be distracting to us, but we found the evidence. The cell phones changed the game. Throughout that interview, he's trying to control the narrative, say that this was suicide, bring up every time they try to ask, well, when was the last time you saw her? Oh, well, she's really suicidal. Yeah, she's a basket case. She's got problems. Let me tell you about all her problems. He doesn't sound like someone that's worried about the well-being of his girlfriend. He doesn't sound like someone that's concerned that she might be deceased, because he knows what happened, and he's trying to spin a web of lies. We know that after this, he travels to the Philippines. He goes to be with his girlfriend in the Philippines, and he comes back. Why did he go to the Philippines? Well, maybe he went there to be with his girlfriends. Maybe he was hoping to move there, get away from this case. He hadn't been charged yet, avoid any charges, which is why that extradition note, that's what we've called it, the note that's found in his apartment saying, extradition yes, extradition no. That's why that's so significant. He's looking for countries where he can't be brought back here to face the justice that Stephanie Pavlons deserves. He's not the smartest criminal. He's not the stupidest criminal. I don't have to prove to you that he's extra smart or that he made dumb decisions. Some of the things that he did don't make sense. You might be thinking, well, if he did this, why wouldn't he just dump his phone in the river? Well, I don't know. But he did it. And we have that evidence. And the phone evidence is powerful. The phone evidence is circumstantial, but bit by bit, as Detective Schrader went through that timeline, the state built its case. And Ms. Opper in her opening asked you to be patient. And I know you all were patient with the state as we built our case. Because this isn't a case where we had an eyewitness. This isn't a case where we had the homicide on video. We had to do hard work to prove this case. Each piece of evidence builds on one another. No single piece of evidence is determinative in this case. But each piece shows you the kind of person that Mr. Matthew Pahl was, shows you the relationship that Stephanie Pavlons had with Mr. Pahl, and ultimately that Stephanie Pavlons met her demise on August 23rd because of the actions of the defendant. This is a circumstantial case, ladies and gentlemen. I ask that you carefully consider each of the pieces of evidence that were presented to you, that you look at all of the evidence in a whole, not close up, one by one, because it's each piece put together that shows beyond a reasonable doubt that Mr. Pahl is not only guilty of first-degree intentional homicide, but that he also intentionally concealed Stephanie's body. And because he did that, because she was concealed, she was eaten by insects, her body decomposed so greatly to the point that there was no DNA evidence, there's no cause of death, but that doesn't change the other evidence we have. So ladies and gentlemen, I'm asking that you find the defendant guilty of both counts 1 and 2. Thank you.
Thank you, Ms. Gordon. Mr. Wolf?
Thank you. Madam Clerk, if I could just make sure that our side works. Thank you, Your Honor. Good afternoon. You, the jury, are now charged with trying to assemble the recipe for the charged offenses on August 23rd of 2022. You have certain major ingredients. We know that Matthew Pahl and Stephanie Pavlons had been in some type of relationship for well over 23 years. Again, they had an adult daughter, Layla, together. We know Stephanie and Matthew never married. They had an on-again, off-again relationship. Stephanie spent periods of time with Matthew, and she spent extended periods of time at her parents' home in Delafield. Her driver's license was for the Delafield home, and she listed the Delafield home to medical providers. We know in 20 and 21, Matthew communicated regularly with at least 2 girls in the Philippines. Stephanie was not only aware of this, but she also communicated with at least one and likely both of them. We know Matthew and Stephanie had medical issues, and both were taking prescription medication. We know Stephanie had a history of mental health issues, including suicide attempts. We know in the summer of 2022, Matthew broke his foot and needed to go through several months of physical therapy. And then we know Stephanie stayed at Matthew's apartment the night of August 22nd, 2023. The next morning, they left the apartment building and drove to Orthopedic Associates in the town of Delafield, and they stopped at Quick Trip on the way. Matthew attended his therapy appointment, then drove directly back to his apartment, and Stephanie was no longer with him. We know on the morning of September 9th of 2022, some workers were placing those no trespassing signs around that wooded area, and they located Stephanie Pavlons' body. Finally, we know the Waukesha County Medical Examiner cannot determine the cause or manner of death for Stephanie Pavlons. You as a jury have heard 7 days of testimony. You've heard from 28 witnesses and seen hundreds of exhibits. That testimony and that evidence does not provide the full picture, and they are not the necessary ingredients, and they are not sufficient for the crimes charged. I also would like to thank you as the jury. You've made sacrifices from work, you've made sacrifices from your family. This is not only your civic duty, but we all have a desire to see that justice and fairness are preserved. You've given Mr. Pahl the opportunity to have his day in court, and I believe we have demonstrated he is not guilty of these crimes. If you remember back to jury selection, the questions were meticulous, they were repetitive, and they were selective. And I want you to think about why. Why is because we wanted 12 people who could reason, we wanted 12 people who could listen carefully to the evidence, and we wanted 12 people who could apply common sense. Remember back to jury selection again that you promised to presume Mr. Pahl innocent. And again, he was innocent in the eyes of the law, and I hope and trust that you presented him innocent at the onset of this case. Finally, you promised to hold the government to the burden of proving Mr. Pahl guilty of these crimes beyond a reasonable doubt and to a moral certainty. And I call upon you to abide by that promise. You've all heard the phrase reasonable doubt. It's been mentioned in this and other trials. The judge will provide you a definition of it, and the state has the burden of proving each and every element beyond a reasonable doubt. Prosecutors, lawyers, and even police officers work within standards that are called burdens of proof. Burdens of proofs are levels of certainty as to whether a fact is true. Perhaps the lowest burden is a mere hunch or a suspicion. The next level would be reasonable suspicion. And reasonable suspicion is defined as having specific facts that a specific individual did something wrong. Reasonable suspicion is needed for a police officer to make an involuntary contact like a traffic stop. Next would be probable cause. Probable cause is a reasonable amount of suspicion, supported by circumstances sufficiently strong to justify a person's belief that certain facts are probably true. Probable cause is needed to arrest an individual for a criminal act. Then there's preponderance of evidence, which would be the next burden, and this is a balance of probabilities. And it is met if there is more than a 50% chance a fact is true. This is a general standard in civil cases. The next burden is clear and convincing evidence, and this means that a fact is highly and substantially more probable to be true. Finally, we have your burden of proof. Proof that something is true beyond a reasonable doubt. Again, this is proof of something so convincing that you would be willing to rely upon it without hesitation in the most important aspects of your life. This is something you have been told, and there is no plausible reason to believe otherwise. A criminal conviction is something so important that our legal system requires the government to prove someone committed each and every element of each charged offense beyond a reasonable doubt. Again, Mr. Pahl is charged with 2 offenses. The judge read the jury instructions, which give you the specific elements. I ask you to please review those elements very carefully. Reasonable doubt does not require you have the exact measurements of every required ingredient. However, it does require at the end you have a proper cake. I'm comfortable that the government has not met its burden. You need to sort through all the items in your pantry. See what is needed for the recipe. You need to focus on what relates to those events of August 23rd and how or if those ingredients even contribute to the proper recipe. Tragically, Ms. Pavlons' body was found in the woods on September 9th. Mr. Pahl was the last person seen with her. The police interviewed Georgianne Pavlons, and they reviewed some surveillance video. They arrest Mr. Pahl. They search his apartment, his car. A week later, they interview Matthew and his family. They hold Matthew for 3.5 hours, then interview him for 2. But they have to release him. A year later, after spending hundreds, if not thousands of hours focusing on Matthew Pahl's movements and his electronic communications, they arrest him. They conduct yet another search of his apartment, and they charge Matthew Pahl with first-degree intentional homicide. But there is reasonable doubt. The state has pointed out that Matthew must be guilty because he appeared to know something between August 23rd and September 17th. Stephanie drove with him to that scheduled appointment at Orthopedic Associates on August 23rd. Stephanie spent much of her time otherwise at the family home in Delafield, so she had a safe place to stay. Stephanie received SSDI for income. She had support from her parents. They drove her, and she had electronics at the house. Though she left her phone in the truck, she could text, Skype, and email on iPads. Most of her calls and texts were actually with Matt. Stephanie had emotional issues, and she also kept to herself. When he came out of his scheduled appointment, Stephanie was no longer there. He drives around a bit, but the cell phone mapping shows he didn't go much more than 300 meters or about 1,000 feet from the area of the appointment. But he would give Stephanie her space. He went home, he brought her stuff up to the apartment, so it was there when she returned. Matthew goes about his life. He checks the mail, he reads the paper, he goes for a bike ride, and he follows his routine. A few days go by, and he starts to express concern. You saw that in his communications. As you heard, Matthew is private, and he is paranoid of the government. He is worried that if something happened to Stephanie, he will be blamed. Then comes September 9th. Matthew sees a large police presence right next to Orthopedic Associates, and that's where he last saw Stephanie. His concern and his paranoia are really going. By the clothing and longer hair, all present deputies, officers, and detectives are aware the body is that of a female. By the shoes, we know that at least one of the construction workers knew it was a woman. The police talk with, they conduct interviews with people on the scene, including OAW employees and onlookers during the 4 to 5 hours they are on scene. Matthew monitors police scanners. He Googles the newspaper for stories, and he skims obituaries. Personally, I don't find this behavior suspicious. If someone I knew was missing, I'd do the same thing. He is now very concerned about Stephanie's whereabouts and her condition. Matthew has had contact with police before. His worry, his paranoia, concern for himself continues to grow. You are shown his interview from September 17th. Yes, he is evasive. Yes, he is paranoid. And yes, he does not recall some specifics. Keep in mind, this is 25 days after he last saw Stephanie. The Waukesha City Police Tactical Unit had burst into his apartment. His home is searched. He's arrested. He's taken back to the sheriff's department, placed in a holding room for 3.5 hours, then read his Miranda rights. Yet what does he do? Despite all that, he actually speaks to officers for 2 hours. Then he's released. Despite his paranoia, the government has taken issue that Matthew didn't report her missing. We know Stephanie and Matthew had this on-again, off-again relationship, and Stephanie spent the time at her family home in Delafield. She received her mail at the Delafield house, and again, she used that address for medical records. We know Stephanie had a spare phone, an older phone at the house. She had other electronics still at her parents' home. Georgianne Pavlons also said that after the move from West Avenue to Delafield Street, Stephanie kept most of her stuff at that house. Finally, we were told Stephanie was very private. It was not unusual for Stephanie to have periods of no contact. No one, no friends, not Layla, not Georgianne Pavlons, despite an unanswered text August 25th, and not Richard Pavlons. No one reported her missing. The government made issue of the fact that Matthew accessed and occasionally used some electronics and even social media for Stephanie. Matthew and Stephanie spent time together. They worked together. Matthew recently bought one of Stephanie's cell phones for her, and he paid the phone costs and the data costs for both of them. The state even showed us a Skype exchange between one of the girls from the Philippines and Stephanie's account shortly after August 23rd. Ms. DeCierto sent 20 plus messages to Stephanie's account. Matthew responded once, maybe twice, pretending to be Stephanie. He was fishing, trying to see what Ms. DeCierto thought of Matthew. Then we saw Matthew quickly revealed it was him by mentioning spanking. He ended his trickery quickly. The government took issue with the fact that some calls were deleted from Stephanie's phone and maybe some texts. They make a big deal that Matthew was using Stephanie's phone, sending Facebook messages and Skype messages. But you saw Matthew's interview. He didn't tell the police, hey, her phone's been used. She's sending messages. She must be alive and well. There was no trickery like that. I honestly don't know why he did what he did, but it certainly doesn't prove that Matthew killed Stephanie Pavlons. What about the alprazolam prescription that Matthew picked up for Stephanie on August 25th? We know that particular bottle was found empty 3 weeks later. It was mentioned by the state on September 17th. We also know that at that time, both Matthew and Stephanie were prescribed that medication. We know Matthew monitored Stephanie's prescriptions. We heard testimony that medication was often carried in their pockets. We know police thoroughly checked Matthew's apartment and his truck. We never heard if any alprazolam in the prescription bottle or otherwise was found anywhere else during those searches. Then there's the black purse. Again, Stephanie and Matthew were frequently in and out of the building, up and down the stairs, carrying shopping bags, water bottles, and stuff to and from the truck. At some point, Matthew brought the purse back into the apartment and placed it with Stephanie's other tan bag in the bedroom closet for her when she returned. Like the pill bottle, Stephanie's phone, like her iPad, like her pink water bottle, he didn't throw the purse in the garbage, he didn't hide it, he didn't destroy it. There's no evidence Matthew wiped out his email accounts or his Skype accounts, and he didn't delete the memory from his dashboard camera. Again, it does not appear Matthew threw anything out despite his interactions with the police. During the search warrant a year later in September 2023, detectives located in a box that list and designations of countries which wouldn't cooperate with extradition. But we have no idea when or why that list was made. It clearly was no secret that Matthew Pahl communicated very regularly with those two women in the Philippines, Ms. Valente and Ms. DeCierto. We learned Stephanie communicated with both of them. Both Stephanie and Matthew were making plans to travel to the Philippines. Given the regular and open communication, this does not appear to have anything directly to do with the end of Stephanie's life. 7 months after he had been arrested, then released, we learned Matthew planned a trip to the Philippines in March of 2023. Despite his DNA being taken right before he left, thus knowing he was still a person of interest, Matthew Pahl returned to Waukesha as scheduled in June of 2023. The state has replied on the testimony of Deputy Willis of the Racine County Sheriff's Department. Deputy Willis is a handler for Raven, and they had gone through cadaver search training. We heard a lot about his Deputy Willis and Raven's training. Most of the training involved actual human remains. Deputy Willis testified the NNDDA is voluntary. It's a voluntary membership, and he pays an annual fee. No specific education is required, and he's not even required to take training notes. He is tested or certified once a year or so, and was tested and certified by Ms. Corcoran, who is his regular trainer. Furthermore, we learned that Raven's real life, that that most real-life actual searches involve searches for entire human cadavers, and in one case, a tooth. If an area law enforcement agent needed a dog to search an area to see if there were human remains, I would be the first to tell them to call Deputy Willis and Raven. However, there's a very big difference between operational efficiency and forensic reliability for a criminal trial. We heard from several lab technicians and other experts. We heard about the importance of blind testing, even double-blind testing. From certain experts, we heard words like statistical confirmation and certainty. We also heard in one certification test for the NNDDA that Deputy Willis and Raven had an 80% for proficiency. And that was a test that included human remains. And that was acceptable for his certification under the NNDDA policies. Again, I'm not saying Raven isn't a valuable tool, but detection by Raven does not come close to the reliability and validity required under most all forensic standards. Let's talk about the search that occurred and the circumstances under which that search occurred on September 19th, 2022. We heard from Detective LaFleur. She was working in the ID Bureau and took initial custody of Mr. Pahl's Tacoma pickup truck. She directed the truck be placed in the pole barn for 2 days prior, and that was on September 17th. She said the pole barn or garage was pretty full. Though she was in charge of the inventory for that pole barn, she could not say where or what specific vehicles were in the garage on the date of the search. She was aware that there were at least 2 vehicles that were involved in fatal accidents. We learned there were many more, and she appeared to be unaware of those. We learned about the position of Mr. Pahl's truck during the search. It was parked alone at one end of the garage. Moreover, it was immediately at the starting point and thus the end point of the search. We also learned from Deputy Willis that human cadaver odor can transfer to containers and other items, even if they do not come in contact. So Mr. Pahl's truck spends 2 days in that pole barn, in the vicinity of numerous vehicles that had substantial, confirmed dead human cadaver contact. At Deputy Willis's direction, Detective LaFleur even burped each door of Mr. Pahl's pickup truck, moving the air from within, but also around the pickup truck. She was not directed to burp any other vehicle, and even Deputy Willis stated this was a less than an ideal environment for a cadaver dog search. Then the search begins. Raven starts the search adjacent to Mr. Pahl's pickup truck with no change in behavior. We know Raven did not indicate on most of the vehicles that were actually involved in human fatality accidents, including numerous vehicles, motorcycles. And Raven did not even exhibit a change of behavior in most all cases, nor did she provide an alert. Then we learned that when Raven was nearly back to the starting point, done with the search area, she turned around. Then Deputy Willis started walking away. Raven looked up at him, then walked back to the rear of the pickup, and Raven sat down and appeared to provide a formal alert. The dog walked past the pickup truck, then changed her behavior when she was just about back to that service door. This test was certainly not double-blind. The detectives were all aware of the target. The test wasn't single-blind. Deputy Willis was advised of the target. Again, why is this important? It's important because of increased likelihood of human cueing, either intentionally or more likely unintentional. Cueing by Deputy Willis and cueing by the deputies present. We were also told by several experts and detectives that preservation during evidence gathering is critical. And it's critical for documentation. It's critical in criminal cases when there is a need for review, for critical analysis. Deputy Willis even takes photos for his training notes. On September 19th, Deputy Willis and certainly the Waukesha County Sheriff's Department had the capacity to record that canine search. Video would have been best, photo would have been good, especially to have an inventory of that, a specific inventory and placement of cars in the garage. But we have neither. We have no way to review or evaluate what truly and accurately happened. Finally, we learn that the Waukesha County Sheriff's Department, or detectives, brought in the forensic experts from the Wisconsin State Crime Lab to process the truck. Not only was there no visible evidence of any relevant volatile human remains, they took countless swabs, including from the rear bed and bumper. The results showed signs that Matthew Pahl was in the front cab of the truck, and I think the bed of the truck, but all other tests were negative. Finally, we have the biggest areas of reasonable doubt. We still have those 3 questions that I asked at the beginning of this case. Question 1, how did Stephanie get from the cab of Matt's truck several hundred feet in broad daylight to the small wooded area where she was found? Keep in mind that in August and September of 2022, the area appeared to be quite active. It was not yet posted no trespassing. It was not overgrown like you saw. You saw the pictures. The body was along a path in a moderately sized clearing near a fire pit or a burn barrel, not far from numerous beer cans. Even after workers posted those no trespassing signs, at least one person walked that trail through the woods. We saw that on the trail cam picture. Keep in mind, the area is bounded by a heavily traveled frontage road and interstate, a very busy health center, a golf course, and homes. Question 2, if Matt carried Stephanie into that wooded area, when would he have done that? Keep in mind, Matt was still dealing with his broken foot. Keep in mind the distance from that parking lot to the woods, the traffic, the sight lines along the east side of Orthopedic Associates. Keep in mind that the government has hundreds of hours of camera footage and cell phone mapping, cameras that capture every single time Matthew leaves or enters that apartment building. That door 4 camera that captures every single time Matthew's truck leaves and enters the apartment. Those comings and goings correlate to cell phone mapping. Other than a few scheduled daytime appointments, there is no evidence that Matthew ever went back to the area of Orthopedic Associates. Think about this. If Matthew Pahl somehow killed Stephanie, why didn't he flee? He didn't flee after August 23rd, 2022. He kept his appointments at Orthopedic Associates. He kept his routine. He didn't flee after being arrested September 17th of 2022. He also could have stayed in the Philippines, but he returned as scheduled to Waukesha in June of 2023. Finally, we have question 3, and that is, what proof does the government have that Stephanie was actually killed by another person? Could it have been suicide? Could it have been a medical issue? Now, we had Deputy Schrader's outline that took a good part of 2 days. After scouring days, perhaps weeks, of surveillance footage, thousands of emails, hundreds of Skype messages, and other cell phone data, he provided his PowerPoint presentation. That PowerPoint presentation not only very selectively picked which messages and data to show, he actually showed just select portions of many of those messages. Still, none of those 3 questions were answered. The government certainly wants Stephanie's death to be a homicide. They presented selective evidence to support their theory. However, there are countless theories, and those theories are not inconsistent with the testimony and the evidence. Again, members of the government said Stephanie was murdered in the woods. Then maybe Stephanie was murdered in the pickup truck, then somehow dragged to the woods. Keep in mind, family members said Stephanie liked to go for walks outside, especially if she wanted to smoke. Maybe Stephanie walked into the woods to vape and something happened. Keep in mind, Stephanie accidentally urinated in Matthew's truck during an appointment 2 weeks earlier. And we know Stephanie did not use the restroom at Quick Trip. Maybe Stephanie walked into the woods to use the restroom and something happened. Maybe Stephanie accidentally overdosed on her prescribed medication. Stephanie's own mother, Georgianne Pavlons, testified Stephanie talked about suicide. We learned Stephanie recently overdosed on her prescription medication. We also heard Stephanie had visible cuts on her wrists. We have Stephanie's journals, and we have the note that was found in Matthew's truck. Perhaps it was an intentional overdose. While admittedly, not likely, Stephanie could have used that scalpel, but there's not necessarily evidence of that. All I'm doing is trying to express the number of things that could have happened that aren't inconsistent with the evidence. We also know, finally, that officers found that empty container of Stephanie's seizure medication at the family home in Delafield. And we heard Dr. Rochelle talk about the correlation between stressors and epileptic seizures. Perhaps Stephanie had a seizure or another medical event. We have our Waukesha County medical examiner, Dr. Shields' testimony. She examined the scene. She examined the clothing. She examined Stephanie. Excuse me. She examined the scene. She examined the clothing. She examined the body. After a year of investigating and testing, she provided her report. Though her initial impression was that Stephanie's life ended in those woods, she could not be certain where she died. She could not rule out strangulation or suffocation, though the hyoid bone was intact. She could not rule out stabbing or other sharp object injuries. She even said there were two small, or we even heard testimony that there were two small spots on Stephanie's shirt, which tested positive for human blood. But there was not evidence of substantial blood loss or marks on the clothing, the skin, or the bones. She could not rule out an overdose or a medical death. She could not even rule out a car accident, though that's doubtful. Dr. Shields determined cause of death and manner of death was undetermined. This was affirmed by Dr. Truesdale, the state's death investigator, and this was affirmed by Dr. Hale. Again, there were thousands of emails and Skype messages, and the government picked some messages from 2021 and a few in early 2022 that demonstrate Matthew was unkind and at times downright mean towards Stephanie. This was especially true when he was discussing the misuse of her prescription medication. We also saw a few selections from Stephanie's journal, which were over a year prior to August of 2022. Matthew Pahl was private. Matthew Pahl was clearly paranoid. Matthew was at times less than kind, perhaps much less than kind, with women, in particular Stephanie Pavlons. But being a bad boyfriend does not make him a murderer. In summer of 2022, we don't have any of those type of entries. We don't have those journal entries. Stephanie was freely and willingly going back and forth between the Delafield house and Matthew's apartment. Keep this in mind. Georgianne Pavlons testified, and she stated that she was not worried about Stephanie's safety when she was with Matthew Pahl. All this testimony and all this evidence is your pantry full of ingredients. You have certain background facts, and those are like the items in the fridge. The government has tried their best to assemble the specific ingredients. They decided Matthew Pahl somehow killed Stephanie Pavlons. They have selected evidence to fit that theory. I sincerely hope that over the 7 days of testimony, you took good notes so that you're clearly aware of what was actually testified to. The state has baked what they want to be a chocolate cake. It doesn't look right, and it doesn't taste right. You will have the right to review some of the evidence. If you want to see a video or picture or certain documents, you can ask. You can see the video of Matthew coming back to the Willow Park apartments after that appointment on August 23rd, 2022. No dirt, no sweat. He looks just like he does on any other day, and he acts just like he did on any other day. I do have a final note before I finish up. I assume at times during the trial and presentation of evidence, you observed Matthew Pahl talking to either Attorney Galaviz or I. I can tell you, he knows the evidence in this case probably better than me. I did not always like when he interrupted me, but he was passionate, and he pointed out when evidence was inconsistent with the evidence. Think about it. If a trial defendant just sat quietly, people may make other assumptions. Matthew is fighting for his freedom. Ladies and gentlemen of the jury, You sit today in this case as 12 judges, 12 individuals who control the destiny of Matthew Pahl. You sit here today as the ultimate law enforcement officers. Please give this case your full attention, deliberation, and analysis. There is not proof beyond a reasonable doubt. Though there has been significant proof that Mr. Pahl is innocent, he doesn't have to prove that. He doesn't have to prove anything. However, given the evidence and testimony, the state certainly has not satisfied their burden of proof with respect to the crimes charged. I'm confident you will render verdicts that will be consistent with good common sense and logic and find Matthew Pahl not guilty. Thank you.
We can flip it back to the safe table, please.
Sure.
Go ahead, Jen.
Ladies and gentlemen, this is a classic story of escalating domestic violence. We know that there was a history of domestic violence incidents between Mr. Pahl and Ms. Stephanie Pavlons. And we know that largely from her journals, because Ms. Stephanie Pavlon kept those journals in 2020 and 2021. Unfortunately, we did not find a journal from 2022. So I don't know what was happening in Stephanie's life in 2022, but we do know that on July 6th of 2020, she writes, "I feel trapped." July 9th of 2020, sick of being called every name in the book, no purpose but to be abused, he's Dr. Jekyll and Mr. Hyde. On August 2nd of 2020, I'm afraid of Matt, but have nowhere to go. September 2nd of 2020, scared to death of him, have no one. October 7th, 2020, she has a blown eardrum, a black eye, and you heard testimony that she went and saw an ENT. October 29th, I'm going to end up 6 feet under. Those are just selections of different journal entries that Ms. Pavlons made. We know that Mr. Pahl was abusive, controlling, and violent. And we know that Mrs. Pavlons said she knew this was an unhealthy relationship. She doesn't know these details. She doesn't know the 100% of what detectives testified we learned. She didn't see text messages. She didn't see Ms. Pavlons' journal entries. She had no idea the violence was this bad. But as we know in domestic violence cases, domestic violence goes unreported. Victims of domestic violence don't tell their closest friends and family. It's humiliating. It's embarrassing. It's terrifying. The most dangerous time for a victim is when they decide that they're ready to leave. We know that there are significant size differences between Mr. Matthew Pahl and Ms. Stephanie Pavlons. She's tiny, petite, incredibly skinny. Mr. Pahl works out, he exercises regularly, he's healthy and fit and muscular. He's taller than her, he weighs more than her. Stephanie is Mr. Pahl's punching bag. Whenever he has a bad day, he makes sure she's going to have a bad day too. Because he's not going to suffer alone. He wants her to hurt worse than he hurts. She's at a size disadvantage. She's scared to death of him. She can't fight back. He's bigger than her. He's stronger than her. He always gets his way. We don't know what fights are happening closer to August of 2022. There's no text messages between them. Wonder why. Ms. Pavlons doesn't keep a journal. Probably because she's staying with Mr. Pahl. She's with him all the time since she's helping him with his foot injury. The defense made a really big deal about that date of August 8th when Ms. Pavlons came in with her pants wet. So let's talk about that day. We know that his truck returns at 2:34 p.m. Mr. Pahl walks in 4 minutes later at 2:38 p.m. Mr. Pahl exits and leaves the door ajar at 3 p.m. At 3:01 p.m., Ms. Pavlons walks in and her pants are wet. So for 30 minutes, Mr. Pahl had Miss Pavlons sit in the car with her wet pants. He's humiliating her. He's embarrassing her. He's controlling her. Then at 3:27, he has the gall to send her a text message that says, "Your piss stain," along with a picture of the seat. How condescending, how degrading. Her partner of 23 years. So what can make someone lose their bladder? Dr. Hale told you, strangulation, suffocation. Within a matter of seconds, when someone's being strangled, they can lose their bladder. So either that day at OAW, maybe even in the parking lot, they get into an argument. He's really pissed at her. He's upset. He wants to let her have it. He grabs her neck. He strangles her. She's terrified. Terrified. She begins to lose consciousness, and then she loses her bladder. See, strangulation's all about power. It's all about power and control. Mr. Pahl is showing Stephanie that he holds the power. He's in control, not her. She doesn't get to make decisions. He does. He holds her life in his hands. Then, in another act of power and control, he makes her sit in the car. After he's done this to her, after she loses her bladder, he changes his shirt. He takes his time getting back down there to let her in because she's stuck. She can't get into the apartment without him. She knows that. He knows that. He knows that she's at his beck and call. She is completely reliant on Mr. Pahl. Between August 19th and August 23rd, we know that Stephanie and Sherlyn had been communicating. We saw from those messages with Sherlyn that made Mr. Pahl really angry. So angry that he stops communicating with Sherlyn altogether. He stops communicating with her via Skype, says, "I'm not getting into texting battles with you," and he only communicates via email. Again, just a little glimpse of his power and control over the women in his life. He's worried that Stephanie's going to ruin everything for him. Because like I said before, these girls in the Philippines, they don't know his whole life. He's told them selective details. They certainly don't know that he's living with a woman in his apartment. Yeah, Stephanie knows about these women. That's an element of the control. Mr. Pahl is rubbing that in her face. He's allowed to talk to these women. She's not. He's allowed to have girlfriends. She's not allowed to talk to anyone. This becomes a constant source of arguments, in addition to all the other little things that Mr. Pahl makes a big deal about. The other arguments that he starts, maybe about a missing pill or not having Ms. Pavlons do exactly what he wants when he wants. On August 23rd of 2022, Mr. Pahl and Ms. Pavlons leave the apartment. They go to Quick Trip. These arguments continue. It's just constant with Mr. Pahl. He's constantly badgering at her in her ear. He goes into his appointment, and while he's in there, Stephanie is just stewing. She's like, "I am sick of this. I'm done. I'm done with the violence. I'm done with the abuse. I don't want this anymore. I'm done with the controlling, manipulative behavior." She's ready to make a big change in her life. She's ready. It's not suicide. She's ready to dump the man that has abused her verbally, emotionally, and physically. By the end of that hour appointment, she's made up her mind. She's done. She's walking away. She doesn't want to be with him anymore. So she writes that note that's found in the car. And ladies and gentlemen, this note, this isn't a suicide note. She says, "I hate you. I hate being with you. All you care about is yourself. I'm not allowed to speak my mind around you, drive, spend money, or even feel good. Karma came back to you because your foot injury, not me. Go be with your virgin because I'm done, and keep the fucking money." That's not a suicide note. That's a breakup note. That's an I'm done with you, goodbye, get out of here, I never want to see you again. So she writes this note, she leaves it on the driver's seat, and she's running out of time. She's got to get out of there. His appointment's almost over. He's going to be done with his appointment. She has to find a way out. So she gets out of the car and she starts to walk away. She's like, I gotta be away from him. She knows she can't go into OAW, wait for her mom. That will definitely end in disaster. He sees her there and she's not in the car. You can guarantee he's yanking her out of there, taking her back into the car. She can't wait for her mom. She can't walk away. She can't walk down Gulf Road. He'll definitely come after her. He'll find her. He'll make her life even more miserable. So what does she do? She can't just sit there any longer. So she decides to walk towards that wooded area. She's probably thinking, hey, maybe I can go into the woods for some cover. Maybe I can walk over to a subdivision, call my mom. Maybe I can get to the golf course, call my mom. I just got to get out of sight. He can't see me leaving. But Mr. Pahl comes out of the appointment. She's run out of time. He sees her. He sees that she's not in the truck. He sees the note. Doesn't take very long to read this note. He reads it, and oh boy, he's mad. He's furious. He gets in his truck, he drives, and he sees Stephanie. He drives up to that little curve in the driveway. He sees her walking towards that wooded area, and he goes after her. He gets out of the truck. He comes after her. He grabs her by the back of the shirt. That shirt's too big. He's pulling the shirt up at her neck. And there's a struggle just outside the area of the woods. Maybe Miss Pavlons is vaping. During that struggle, she drops her vape. Mr. Pahl continues to grab at her shirt. He's not letting her go. And then what happens? Mr. Pahl grabs her purse. And ladies and gentlemen, this is the murder weapon. He wraps this around her neck. He strangles her for just a minute or two. That's all it takes. She goes unconscious, and she's dead. He uses the strap of her own purse to kill her. See, Mr. Pahl, he couldn't let Miss Pavlons have the control. He couldn't let her walk away. He couldn't let her leave him. He's the man. She does what he wants, not the other way around. He couldn't let her walk away. Only he gets to decide when this relationship is done. And in the ultimate act of control, he takes her life from her. He drags her body just inside the wooded area. The purse strap has caused a ligature mark, a little bit of an abrasion, a scrape to her neck, a laceration. That's consistent with the evidence, that there's some blood on the neck of her shirt, that there's a lot of insect activity at her neck, down to her collarbone, all the way to the top of her head. It's also consistent with the evidence. Look at the way her body is positioned. Look at the way her arm is stuck in her shirt. As he's grabbing her by the shirt, she's struggling. She's trying to get away. Her arms are up by her ears. She's trying to get her arm out of her shirt. She's fighting for her life. And Mr. Pahl takes her life from her. He doesn't know how quickly her body's going to be found. He notices that there's an injury. He panics. He drops the scalpel right outside the woods, right where that struggle started, thinking, oh, maybe I can say this was a suicide. He leaves Stephanie to decompose and be eaten by insects, effectively hiding any evidence that we have, effectively making it very difficult for the medical examiner to provide a cause of death here. His actions and his actions alone are the reason that there's no DNA, no evidence of injury, And that's because of her advanced stage of decomposition. So what does he do next? He grabs the purse, he grabs the water bottle, he goes right to his truck, opens the bed of his truck, puts the purse and the water bottle in the bed of his truck. Drives off, goes home. See, he didn't realize that by just being next to Stephanie at the time that she's deceased, and by using her purse, there could be a little bit of tissue left on the strap of the purse. That tissue decomposes, that tissue causes that odor that Canine Raven is trained to hit on. He returns to the apartment with her phone. He goes inside and he brings his the water bottle in. The purse remains in the vehicle. From 10:33 to 10:53 a.m., that's plenty of time for Mr. Pahl to have killed Stephanie Pavlons. It takes just a minute or two to kill someone by strangulation. Not very long. Not very long at all. It's plenty of time to kill her, and when he gets back to the apartment, he goes about his life as if nothing has ever happened. When he comes inside the first time, he just brings in the water bottle. And he thinks, oh, I don't need to conceal this. I know I've carried this before. But he knows if he carries that person, that's going to look suspicious. So an hour and a half later, he comes back down. He brings the purse inside at 12:29. That purse has been inside his car since 10:53. Enough time for that odor of a decomposing human remains to be just at the tailgate, just at the bed of the truck, right where Raven hits. He puts the purse in a Walmart bag to try and conceal the purse, so we can't say that that's what comes into the apartment. But he doesn't do a good enough job, because we catch that. Detective Seitz, right away when he reviews the video, catches that. When he brings the purse in, he cleans it off, he puts it on a shelf, and then has this theory. Oh, I'm just going to say she walked off. I brought it back inside with me. I didn't know if she was going to come back. The evidence suggests otherwise. Over the next days and weeks, he uses Stephanie's phone. He searches her name because he's trying to cover his tracks. He's trying to figure out what law enforcement knows. Mr. Wolf said, well, she wasn't answering her messages. Yeah, she wasn't answering her messages because he had her phone. He knew that. She's very private because Mr. Pahl has isolated her. He brings in the purse on August 23rd. The defense doesn't dispute that he brings in the purse. That's exactly what happened. The defense said in their closing that they had 3 questions. How did she get from the cab of his truck to the wooded area? That, what I just told you, that explains it all. He didn't carry her. He had to drag her a short distance. He was certainly capable of doing that. His foot injury did not stop him from getting rid of the one person that had the ability to ruin everything for him. Because if Stephanie left and she got a hold of Sherlyn, she could unravel his whole fantasy life. He couldn't let her go. He couldn't let her ruin everything. He uses our Facebook account. He wants to be ready when the police come. He was ready with a story. He just wasn't as smart as the police. Ladies and gentlemen, the evidence is absolutely circumstantial, but it's overwhelming. The only reasonable explanation supported by all of the evidence is that Mr. Pahl was a violent and abusive partner. He kills Mrs. Pavlons because she was trying to leave him, something he certainly couldn't let happen. Everything that happens after 10:54 on August 23rd of 2022 demonstrates that this wasn't a suicide, this wasn't a seizure, this wasn't an accidental overdose, an intentional overdose. No, ladies and gentlemen, this was first-degree intentional homicide. Mr. Pahl caused the death of Miss Pavlons, and he concealed her body. I ask that you find the defendant guilty of both counts.
All right, thank you. Ladies and gentlemen, you are to decide this case fairly and impartially, without fear or favor and without passion or prejudice. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 4 forms of verdict will be submitted to you concerning the charges against the defendant Matthew E. Pahl. As to count 1 reading, we the jury find the defendant Matthew E. Pahl guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant Matthew E. Pahl not guilty of first-degree intentional homicide as charged in count 1 of the information. As to count 2, another reading, we the jury find the defendant Matthew E. Pahl guilty of hiding a corpse as charged in count 2 of the information. Another reading, we the jury find the defendant Matthew E. Pahl not guilty of hiding a corpse as charged in count 2 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses charged. You must make a finding as to each count of the information. Each count charges a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count. This is a criminal, not a civil case. Therefore, before the jury may return a verdict which may be legally received, the verdict must be reached unanimously. In a criminal case, all 12 jurors must agree in order to arrive at a verdict. When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror. If you need to communicate with the court while you're deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of the trial, it is important that you communicate with the court only by written note. If you have questions, the court will talk with the attorneys before answering, so it may take some time. You should continue your deliberations while you're waiting for the answer. The court will answer any questions in writing or orally here in open court. When you've agreed upon your verdict, have it signed and dated by the person you've selected to preside. After you reach a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdict will be read into the record in open court, and the court may ask each of you if you agree with the verdict. Ladies and gentlemen, at this juncture, we are going to swear in our bailiff, and then after that, I'll advise you of the 2 alternate jurors who will be excused, and I'll ask you to follow Mike's directions. Alternate, even though you are alternates, please don't discuss with anyone. We'll tell you that if you're welcome to stay, whoever you are, to wait to see if there's a verdict, or you can let the bailiff know and we'll either call you or let you know the results, or you can be here by phone when the verdict comes back. So if you could swear in the bailiff, please.
Do you swear that you will keep the jurors sworn on this trial in a quiet and convenient place? You will suffer no communication with them except upon order of the court. That you will not report to any person the state or result of their deliberation until they have agreed upon a verdict, returned to the court, and recorded. So help you God.
I do. All right, sir, here's the jury instructions and verdict forms. And alternates are, I'm going to ask when I read your name to raise your hand, Diane Badalski and Steve Hayes. All right, folks, again, thank you so much. I know this is a disconcerting moment when you're all of a sudden separated from everyone you spent a number of days with. I assure you we thank you and respect the time you've spent. It's not wasted because it's important to have the alternates, and I appreciate that. Anything from the state before I release the jurors?
No, Judge.
Anything from the defense?
No, Your Honor.
All right, very good. You can go with Mike and follow his directions, please. All right, the jurors have left. Have a seat, everybody. Anything before we stand down from the state?
No, Judge.
Anything from the defense?
No, Your Honor.
Okay, very good. Then, folks, please stay in the vicinity. This has been a long trial, and I expect there may very well be some questions from the jurors, at least about what evidence they may see. So please remain in the area and report to our clerk with your cell phone numbers, okay? All right, let's stand down. Thank you.
Awesome, thanks so much. Yep.
I'm here. I'm here. Can anyone hear me? Oh, I think he's not guilty. He's not guilty. So now we're on verdict watch, right? I don't know how that got turned on. Now we're on verdict watch. WATCH. Oh, my neck. Oh, it's done. Leah, mommy's got a fucking migraine. Guess what, Leah? All day I've been bitching about one thing and it's finally done. the oven to 425. Oh God, I got such a fucking headache. What are you so pissy about? Well, I'm gonna cook. Oh shoot, I forgot I was. Oh my goodness, this is going to be a long day. So what do we think? I'm just talking to myself. I'm thinking maybe I'll just end the live. And then when a verdict comes in, we'll rush back to make a new live. Yo, guilty or not guilty? I need to know. Write it in the comments. If you're here after the live, don't forget to like, share, and subscribe. I know I was gone for a minute. I had to run and do something real quick. But it's not like I guess I'm talking to myself. Yay. That's okay. That's okay. I'll talk to myself.
Exercises regularly. He's healthy and fit and muscular. He's taller than her. He weighs more than her. Stephanie is Mr. Pahl's punching bag. Whenever he has a bad day, he makes sure she's going to have a bad day too. Because he's not going to suffer alone. He wants her to hurt worse than he hurts. She's at a size disadvantage. She's scared to death of him. She can't fight back. He's bigger than her. He's stronger than her. He always gets his way. We don't know what fights are happening closer to August of 2022. There's no text messages between them. Wonder why. Ms. Pavlons doesn't keep a journal. Probably because she's staying with Mr. Pahl. She's with him all the time since she's helping him with his foot injury. The defense made a really big deal about that date of August 8th when Ms. Pavlons came in with her pants wet. So let's talk about that day. We know that his truck returns at 2:34 p.m. Mr. Pahl walks in 4 minutes later at 2:38 p.m. Mr. Pahl exits and leaves the door ajar at 3 p.m. At 3:01 p.m., Miss Pavlons walks in and her pants are wet. So for 30 minutes, Mr. Pahl had Miss Pavlons sit in the car with her wet pants. He's humiliating her. He's embarrassing her. He's controlling her. Then at 3:27, he has the gall to send her a text message that says, "Your piss stain," along with a picture of the seat. How condescending, how degrading. Her partner of 23 years. So what can make someone lose their bladder? Dr. Hale told you, strangulation, suffocation. Within a matter of seconds, with someone's being strangled, they can lose their bladder. So either that day at OAW, maybe even in the parking lot, they get into an argument. He's really pissed at her. He's upset. He wants to let her have it. He grabs her neck. He strangles her. She's terrified. Terrified. She begins to lose consciousness, and then she loses her bladder. See, strangulation's all about power. It's all about power and control. Mr. Pahl is showing Stephanie that he holds the power. He's in control, not her. She doesn't get to make decisions. He does. He holds her life in his hands. Then, in another act of power and control, he makes her sit in the car. After he's done this to her, after she loses her bladder, he changes his shirt. He takes his time getting back down there to let her in because she's stuck. She can't get into the apartment without him. She knows that. He knows that. He needs to find a way out. So she gets out of the car and she starts to walk away. She's like, I gotta be away from him. She knows she can't go into OAW, wait for her mom. That will definitely end in disaster. He sees her there and she's not in the car. You can guarantee he's yanking her out of there, taking her back into the car. She can't wait for her mom. She can't walk away. She can't walk down Gulf Road. He'll definitely come after her. He'll find her. He'll make her life even more miserable. So what does she do? She can't just sit there any longer. So she decides to walk towards that wooded area. She's probably thinking, hey, maybe I can go into the woods for some cover. Maybe I can walk over to a subdivision, call my mom. Maybe I can get to the golf course, call my mom. I just got to get out of sight. He can't see me leaving. But Mr. Pahl comes out of the appointment. She's run out of time. He sees her. He sees that she's not in the truck. He sees the note. Doesn't take very long to read this note. He reads it, and oh boy, he's mad. He's furious. He gets in his truck, he drives, and he sees Stephanie. He drives up to that little curve in the driveway. He sees her walking towards that wooded area, and he goes after her. He gets out of the truck. He comes after her. He grabs her by the back of the shirt. That shirt's too big. He's pulling the shirt up at her neck. And there's a struggle just outside the area of the woods. Maybe Miss Pavlons is vaping. During that struggle, she drops her vape. Mr. Pahl continues to grab at her shirt. He's not letting her go. And then what happens? Mr. Pahl grabs her purse. And ladies and gentlemen, this is the murder weapon. He wraps this around her neck. He strangles her for just a minute or two. That's all it takes. She goes unconscious, and she's dead. He uses the strap of her own purse to kill her. See, Mr. Pahl, he couldn't let Miss Pavlons have the control. He couldn't let her walk away. He couldn't let her leave him. He's the man. She does what he wants, not the other way around. He couldn't let her walk away. Only he gets to decide when this relationship is done. And in the ultimate act of control, he takes her life from her. He drags her body just inside the wooded area. The purse strap has caused a ligature mark, a little bit of an abrasion, a scrape to her neck, a laceration. That's consistent with the evidence, that there's some blood on the neck of her shirt,
Ew.
that there's a lot of insect activity at her neck, down to her collarbone, all the way to the top of her head. It's also consistent with the evidence. Look at the way her body is positioned. Look at the way her arm is stuck in her shirt. As he's grabbing her by the shirt, she's struggling. She's trying to get away. Her arms are up by her ears. She's trying to get her arm out of her shirt. She's fighting for her life. And Mr. Pahl takes her life from her. He doesn't know how quickly her body's going to be found. He notices that there's an injury. He panics. He drops the scalpel right outside the woods, right where that struggle started, thinking, oh, maybe I can say this was a suicide. He leaves Stephanie to decompose and be eaten by insects, effectively hiding any evidence.
Verdict! The verdict is in!
Oh, sorry, Judge.
All right, send him in. I don't know what the verdict is, obviously, but I don't want any helpers from anybody. Yeah.
Are you here, Kathy? Oh my God, I'm gonna pass out.
All right, have a seat, everybody. All 12 jurors have returned. It's my understanding that the jury has reached a verdict. Who's our presiding juror? Is that correct, ma'am?
1 hour.
All right, if you could hand the
15
materials to Mike, please.
Oh my God. I can't do it. Just read it.
Okay, what I'm going to do is read the verdict forms at this time. The verdicts read as follows. We, the jury, find the defendant, Matthew E. Pahl, guilty of first-degree intentional homicide as charged in count 1 of the information.
No!
The second verdict reads, we, the jury, find the defendant, Matthew E. Pahl, guilty of hiding a corpse as charged in count 2 of the information. And each is dated today's date, the 4th of November, 2025, and signed by Kathy Meyer, the presiding juror, the foreperson. Ladies and gentlemen, what I'm going to do now is poll each one of you. And what that means is I'm going to ask each one of you, I'll read your name. When I read your name, the question that I'm going to ask each one of you is, are these both, in fact, your verdicts? And if they are, answer yes, and if not, answer no, okay? Are these both, in fact, your verdicts?
Yes.
Are these both, in fact, your verdicts?
Yes.
Are these both, in fact, your verdicts?
He's been found guilty on both counts.
Are these both, in fact, your
But
verdicts?
your money's on your card.
Are these both, in fact, your verdicts?
I didn't know if there was something you wanted to get while you were out.
Are these both, in fact, your verdicts?
I can't believe. No, I'll need some cigarettes.
Are these both, in fact, your verdicts?
Huh? Yeah, I'll need
Are
cigarettes.
these both, in fact, your verdicts?
Yes.
Yeah, do you?
Or Heineman, excuse me. Are these both, in fact, your verdicts?
Yes.
Are these both, in fact, your verdicts?
Yes.
Are these both, in fact, your verdicts?
Yes.
Did I miss anyone in polling? I think I got all 12. Is the state satisfied with the polling of the jury?
Yes, Judge.
Is the defense satisfied with the polling of the jury?
Yes, sir.
Okay. Ladies and gentlemen, I'm going to read to you the final instruction. Your service in this case is completed. You do not have to answer questions about the case from anyone other than the court. Additionally, you are under no obligation to maintain secrecy concerning what took place in the jury room, nor are you required to discuss the case with anyone or answer any questions regarding it. Ladies and gentlemen of the jury, thank you very much for your time. It's been a while. It's been a number of days. I think we're in day 8. I very much appreciate your service. I very much appreciate your time and the fact that you've taken time away from work and your families and so on. Your service is a difficult service. It's one that's like being drafted, as perhaps you heard me say before. You are going to be excused in just a moment. You can go back and follow Mike's directions. If you wish, you're free to leave, or in fact, I will come back and talk to you if you want to talk to me after this, but you're under no obligation to stick around. Is there anything else before I excuse the jurors, Ms. Gordon?
No, Judge.
Is there anything else, Mr. Galaviz, before I excuse the jurors?
No, sir.
Okay. Again, thank you so much, ladies and gentlemen. Everybody stand for the jurors, please. All right, have a seat, everybody. Thank you. All right, the verdict forms and the unexecuted verdict forms will be available for everybody's review. And is there anything from the state at this juncture?
It would move for judgment on the verdicts.
All right, and either Mr. Wolf or Mr. Galaviz, anything?
Your Honor, I'll move for judgment notwithstanding the verdict. No further argument.
Okay, I will enter judgment on the verdicts at this time, finding that the verdicts of the jury are certainly reasonable under the facts and circumstances of the case. Understanding it was a circumstantial case, understanding that it took a while for the state to present their evidence, and understanding as well the defense testimony that was contrary to what some of the witnesses from the state presented. It appears to this court that any reasonable jury could come up with these same verdicts. So judgment will be entered on the verdicts. Having said that, are the parties available for sentencing next week, or does the defense need more time?
Judge, we would be available this week if the court would be willing to do sentencing later this week.
I understand.
And Layla is in town until the end of the week. She was planning to stay through the end of the trial, but then after that she will be returning home out of state.
Out of state? Is it in contiguous states or farther than that?
Further than that.
Okay. But again, I understand that I take those things into consideration, but I also take into consideration these are serious charges. And Mr. Wolf or Mr. Galaviz, and they may need time to prepare things. Is anybody asking for a pre-sentence investigation?
I'm sorry?
Nobody, is anybody asking for a pre-sentence investigation? Is the state making such a request?
No, Judge.
All right. My preference is next week, Tuesday or Wednesday. And if, I'm sorry, I don't mean any disrespect by using somebody's first name, but if she wishes to appear by Zoom, that's certainly available as well. It gives the parties time to prepare. I am available Thursday as well.
Judge, Ms. Layla Pavlons would like to speak at sentencing. She's not comfortable speaking over Zoom, but she would like to be present and speak.
I understand, and again, I'm balancing the defense ability to prepare for sentencing and her rights as a victim as well. I'm taking these things into consideration. That's why I'm offering days either this week or next week.
Your Honor, I'd ask for the afternoon of the 12th.
That is what day?
Wednesday.
Wednesday? Okay, I understand. Layla's, is the state available?
Both Attorney Opper and I are at a training next week. Attorney Opper is presenting on Wednesday in Green Bay, so we're not available on Wednesday.
Okay.
That's why we were asking for this week.
All right.
I can do Tuesday afternoon as well.
State available? Tuesday morning? No? I'll give another date. I mean, I could give more time. If that's not convenient for the state, it's not convenient.
I mean, it's not convenient for the
all right.
state, Judge.
We'll set another date. We'll go off the record for scheduling.
Your conference is through next Friday, right?
Yeah.
Friday this week?
Friday this week? No, we don't have Friday.
Thursday afternoon. About Thursday.
November 17th.
No, I can be here too. What time did the court have on the 12th, Judge?
No. I have all day on the 12th.
And what about the 11th, Tuesday?
All day.
I teach until 10, so I could be here at 11.
State could be available after 11 on Tuesday.
Should we do it Tuesday afternoon?
I'll make it work. I'll cancel some things, yeah.
Tuesday,
Yeah.
like 1 o'clock or 1:30?
1 o'clock on November 11th.
All right, y'all. Well, I guess we got
November
it.
11th
I
at 1
surely
o'clock.
hope they
Thank you. Anything else
retry
before I
this
excuse everybody from the
and
state?
not let that
No, Judge.
Anything else
tell that
from the
story
defense?
No, Your Honor.
that's made
All right,
up,
thank you very much,
completely
everybody.
made
Good
up.
luck, everyone. We'll see you next week.
But thank you so much for being here with me. I do appreciate it. You guys all have a wonderful night. Stay safe. Don't forget to
Well,
like,
I
share, and
apologize.
subscribe.
Bail
And I'll
is
see you
revoked.
in the next one. Bye-bye.
Okay, thank you.